You excuse me, Senator, I got to get something off my chest.
Yeah.
You know, I resent the appointment of a special prosecutor. Damn, I think it's a reflection on me and the Department of Justice. We would have broken that case wide open, and we would have done it in the most difficult of circumstances. And do you know what happened? That case was snatched out under us when we had it 90% complete.
Yes.
With a recognition of the Senate of the United States that we can't trust those guys down there. And we would have made that case, and maybe you would have made it different. But I would have made it my way, and Silver would have made it his way, and we would have convicted those people, and we would have immunized them, and we would have gotten a breakthrough. Now, I'm not minimizing what you have done or the press or anybody else, but the Department of Justice had that case going, Senator, and it was snatched away from us, and I don't think it's fair to criticize us because at that point, we didn't have the evidence to go forward.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. Without any fanfare or ceremony, Senator Sam Ervin today sounded the closing gavel on the first phase of public Senate hearings that have made history. After 35 witnesses in 37 days of testimony, adding up to more than 1.5 million words, the Watergate hearings have surpassed even the Army McCarthy hearings of 1954 as a televised event. The committee has not yet finished with Watergate. It'll come back in September and hear 6 more witnesses before moving on to Phase 2, an investigation of campaign funding, and Phase 3, dirty tricks. The interval now will give President Nixon time to deliver his much-anticipated rebuttal to the damaging testimony of many witnesses here. For its finale today, the committee had 2 strong personalities as witnesses, former Attorney General Richard Kleindienst and Assistant Attorney General Henry Petersen. These 2 men, who had official charge of the Watergate investigation, resolutely defended the thoroughness of that investigation and the political independence of the Justice Department. And Petersen, criticizing the appointment of Special Prosecutor Cox, said the Justice Department would have cracked the Watergate case if it had not been snatched away.
After tonight, it's over, for a while at least, and the basic question is still the one that was asked the first week and during each succeeding one. With all of this conflicting evidence from the many witnesses with their varying good guy, bad guy impressions, manners, and axes to grind, who are we to believe? Or to put it crudely, who's lying and who's telling the truth, and how do we go about making that decision? Well, Peter Kay discussed this general subject with Committee Vice Chairman Howard Baker at the close of it all today, cast in terms of what he has learned thus far.
Do you really feel we're any closer to knowing the central questions after all of this testimony and evidence and documents and some tapes of who planned it, who carried it out, and who covered it up? Do you feel any more satisfied about that?
We know a great deal more than we did before, but we don't know with absolute certainty who did what, when, and where the responsibilities lie. We don't know, for instance, what the president knew and when he knew it. We have much more information on that subject, but most of it's tangential and circumstantial.
How are we ever going to find out?
Well, you see, there's not a requirement that this committee find the truth. That is simply our ambition. There's no statute that says we have to establish the facts beyond a reasonable doubt, although that would be highly desirable. The mandate to this committee is do the very best you can from all of the facts and circumstances that are available, digest it, and report it to the Senate. The tapes, the presidential tapes, the access to documents, and all the rest, the things that might yield information in that respect in furtherance of our search, will inevitably affect the quality of our report. But no matter how the litigation turns out, no matter what the Supreme Court may say about our access to documentation and presidential tapes, we will state our conclusions. And they, no doubt, will be weighed and judged not only by the Senate but the country. But the answer to your question is we have a great volume of additional information, and it does serve as the basis for an intelligent judgment of what happened. But we may never be completely certain.
Richard Kleindienst and Henry Petersen were the two witnesses today on this, the 37th day of these hearings. Hugh Sidey, Washington bureau chief and columnist for Time magazine, watched them in action with us. Hugh, what advance or guiding comments would you offer about these two men?
Well, I must say these were two very human persons, and they were a delight to watch. It wasn't a bore at all, this last chapter. As a matter of fact, Kleindienst came on. He had the face, the tone, the manner of a cop. He had an engaging smile. He was tough, and yet he had some emotion in him, and we got the sights and sounds of the locker room out at Burning Tree, as well as some honest-to-goodness anger at John Ehrlichman. Mr. Petersen, on the other hand, would look like a dead-honest attorney general, big, craggy face. He described the Byzantine atmosphere of the White House, and he, too, showed emotions, outrage, hurt, all of these things. I think, by and large, they were two excellent witnesses for themselves.
Okay, there was also significant Watergate activity in Judge Sirica's courtroom downtown today. And Jack Murphy at the Georgetown University Law Center, who, as you regular viewers know, has been with us many times as our legal expert, went down there. Jack, first of all, tell us what happened, and then tell us what it all means.
Jim, this was the day they had the hearing on the July 26th show cause order, which the district court had issued several weeks back. Question was, does the president have to respond to the subpoena? And today the president came in and filed what he called a special appearance. Not a motion to quash, apparently is not prepared to go along with the usual court processes. And in this special appearance, he asked the court to vacate that order to show cause, saying that executive privilege prevented the court from enforcing an order against the presidential branch under the separation of powers doctrine. He argued that the character of the presidency would be fundamentally altered if a different rule applied, and that the notion that the president could be held personally subject to orders of the court would radically change the status of that branch as a coordinate and equal branch of government. He didn't say that there was no power to issue the subpoena. He said there was no power to enforce it. This is the intriguing question.
All right, now what happens next?
On August 22nd, we'll have oral argument on this after Mr. Cox has responded to these papers filed today. He will file his response next week, and in about 15 days we'll hear the argument. Now, what will happen after that is wholly speculative. We have no idea.
All right, and also it needs to be pointed out that the committee has deferred action on what it's going to do as far as its potential legal action involving the tapes until this whole matter is resolved involving Archibald Cox, right?
Yes.
Okay, Hugh Sidey and Jack Murphy will be back at the close of tonight's broadcast to talk about this, the final day of the first phase of the Watergate hearings in more detail.
To help you plan your evening's viewing, here is NPAC's hour-by-hour look at the day's testimony. In the first hour, Kleindienst describes his reaction when he was visited at the Burning Tree Country Club by G. Gordon Liddy and first told of the Watergate break-in. He praises Ellsberg's trial judge Matthew Byrne and tells of his own feelings about the burglarizing of Ellsberg's psychiatrist's office. In the second hour, Senator Baker explores exactly what happened when Kleindienst told the president about the involvement of White House and re-election committee staff members in Watergate. And Kleindienst strikes a positive note with a list of the triumphs for the press and for the congressional system that have emerged from the case. In the third hour, when Kleindienst concludes his testimony, he's pressed by Senator Weicker on the circumstances of his resignation. Kleindienst says he'd wanted to announce it himself, that the president wanted to announce it along with the resignations of Haldeman, Ehrlichman, and the firing of John Dean. In the fourth hour, Assistant Attorney General Henry Petersen is the witness. He describes what was said in several meetings he had with President Nixon, including a critical one when he outlined the Watergate involvement of Dean, Ehrlichman, and Haldeman. During the fifth hour, Petersen makes a spirited defense of the Justice Department's Watergate investigation and disparages the need for a special prosecutor. Petersen also describes his suspicions of a possible cover-up in the case, saying his feelings at the time were, nobody acts innocent. And in the final hour of the day and of this phase of the hearings, Petersen says he never got any special orders from the president to investigate and report on the case, as Mr. Nixon claimed in an April statement. Senator Weicker wonders who did get such orders. And Petersen also defends the president's right to record his conversations for history. Now to Senator Ervin and the final day's hearing.
The committee will come to order. The committee met in executive session this morning and decided to postpone filing a suit until counsel for the committee have an opportunity to ascertain and study the reaction of the White House attorneys to the motion of special prosecutor. I'd like to put in the record a statement of the American Nurses Association setting out the code of the nurses in respect to their attitude towards revealing confidential information they acquire while serving the patients. The counsel will call the first witness and
Our former Attorney General, Richard G. Kleindienst.
Mr. Kleindienst, will you stand up and hold up your right hand?
Yes, sir.
Do you swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God? Now, you might identify yourself for the purpose of the record, giving your name and address.
Mr. Chairman, my name is Richard G. Kleindienst. My address is 8464 Portland Place, McLean, Virginia. I do not have a prepared statement, Mr. Chairman. I'm here voluntarily to provide to you, the members of the committee and the council, whatever information that I have and which you deem to be relevant to your investigation.
Mr. Chairman, Mr. David Dorson, Assistant Chief Counsel, will open the questions.
Mr. Kleindienst, am I correct that you are presently engaged in the private practice of law?
Yes, sir. After I left the Department of Justice, I opened up an office in Washington, D.C., and I'm a private practitioner by myself.
And you resigned as Attorney General as of April 30th, 1973?
I believe that it was April 30th, yes, sir, effective upon the qualification and appointment of my successor.
Mr. Kleindienst, could you please summarize for us briefly your background, especially with respect to your positions with the United States government?
I've only had two positions with the United States government. That was the position of Deputy Attorney General of the United States, a position that I believe that I was commenced around the 1st of February 1969. And the other position that I've had with the United States government is the Attorney General of the United States, a position that I commenced on or about June 8th of 1972.
Mr. Kleindienst, when for the first time did you learn that there was electronic surveillance of the Democratic National Committee headquarters at the Watergate?
Well, I learned it for the first time after June 17th, when the individuals who were arrested at the headquarters were arrested. I don't know whether I learned of the electronic surveillance on Saturday, June 17th, or sometime the early part of the next week.
But on June 17th, you were notified of the fact that there had been a break-in?
At approximately 8 o'clock in the morning, Assistant Attorney General Henry Petersen of the Criminal Division of the Department of Justice called me at my home and indicated to me that there had been a break-in at the Democratic National Headquarters at the Watergate Hotel. All the information that he had at that time was that there was a break-in, and I believe he said to me, it looks like it might have been a bombing case. The next knowledge of any kind that I had with respect to it came approximately 3.5 hours after that, when I met with Mr. Gordon Liddy and Mr. Powell Moore in a section of lockers at the Burning Tree Club, which is a golf club in Washington, D.C.
How did that come about, Mr. Kleindienst?
The reason why I was at the Burning Tree Club, they had their annual member guest golf tournament, of which I was a participant. I think I was scheduled to tee off for the Saturday round afternoon. I was having lunch in the main dining room area of the Burning Tree Club. I looked up and Mr. Gordon Liddy, who I recognized, came in with Mr. Powell Moore, and I likewise recognized him.
Who was Mr. Powell Moore?
Mr. Powell Moore was the Deputy Public Information Officer of the Department of Justice when I was there as the Deputy Attorney General. When Mr. Mitchell resigned as Attorney General and went over to the campaign committee for the re-election of the President, Mr. Palmore went with him to the campaign committee. I do not know what his title was at the campaign committee, but I knew Palmore quite well as a result of our association together at the Department of Justice.
I believe you indicated that you recognized Gordon Liddy. What was the circumstances under which you first met or got to know Mr. Liddy?
The only association I ever had with Mr. Liddy, except for this particular meeting on Saturday, June 17th, was in the year 1969, when I headed on behalf of the executive branch a task force that was looking into and devising a program of action with respect to the marijuana traffic from the country of Mexico into the United States. I believe that Mr. Liddy at that time was an officer or employed by the Treasury Department, and he was one of the representatives from the Treasury Department in that task force. There were representatives from 6 or 7 departments of the government that would have been in the late spring of 1969 and the summer of 1969. To the best of my recollection, I never saw Gordon Liddy after that time in the intervening years until that Saturday morning on June 17th, and I have not seen him since.
What was the nature of the experience that the Justice Department had with Mr. Liddy in connection with his role in Operation Intercept?
Well, I had no experience with him because he was under the jurisdiction of the Secretary of the Treasury. He had one assignment, as I recall, with respect to going from town to town along the United States-Mexican border to inform the business community who were quite concerned about so-called Operation Intercept. My recollection, which is not very precise, is that the manner in which Mr. Liddy was giving information with respect to our program was unsatisfactory, and I believe that based upon the information that I got, I recommended to the Secretary of the Treasury or Mr. Rosides, who was, I think, his immediate superior, that Mr. Liddy be called back from that assignment and not to continue any further with it.
Do you have any other recollection about any possible problems with Mr. Liddy or why his performance was considered unsatisfactory?
No, sir.
Directing your attention to the locker room of the Burning Tree Country Club, what happened when you saw Mr. Moore and Mr. Liddy there?
The first thing that I remember with some preciseness is the fact that Mr. Liddy, when he came into the entranceway of the dining area and saw me, in a rather furtive manner, made a motion to me like this, indicating, "Come here." I got up out of my chair and went over there. He was very agitated and seemed to be quite upset. He said that I have to talk to you in private. Where I was standing was not a very private place. There must have been 60 or 70 men who were eating or standing around. Right to the left of where he was, there was a little locker room complex at the club. I looked in there and no one was in there, so I said, "Gentlemen, come in here. I think this would be a private place to talk." We went in there. Mr. Liddy said that I've been asked to come out and give you a report with respect to the Watergate break-in last night, or the break-in of the Democratic National Committee. I don't know which he said. He said to me that he believed that some of the persons who were arrested might be employed by either the White House or the campaign committee for the re-election of the president. My reaction to that statement was instantaneous and rather abrupt. I think he also said, although I don't have too precise a recollection of it, that Mr. Mitchell had asked him to come out and talk to me. That was incredible to me. The relationship I had with Mr. Mitchell was such that I don't believe that he would have sent a person like Gordon Liddy to come out and talk to me about anything. He knew where he could find me 24 hours a day. In any event, as a result of my surprise, my incredulity, and I think my instant realization of the implications of what he had just said, prompted me to pick up the telephone and locate Mr. Henry Petersen. That I was able to do very quickly. All I had to do was to call the Justice Department switchboard and have her call him at home and put him on the phone. Since Mr. Petersen had called me at 8 o'clock, I didn't have to explain much to Henry. I told him, and I've always been of the impression that I said to Mr. Petersen that Mr. Gordon Liddy of the campaign committee is here. Mr. Petersen, based upon a conversation I've had with him, does not remember my mentioning Mr. Liddy's name. But in any event, I was intent upon giving him a very specific, direct instruction right then that with respect to those who are arrested at the Watergate, they should be given no treatment that would be different than anybody else who might have been arrested in circumstances of that kind. I was quite upset. To the best of my recollection, the next thing I did was to turn to Mr. Liddy and tell him to leave the premises, because I know immediately thereafter Mr. Moore and Mr. Liddy left.
Mr. Kleindienst, aside from the conversation you had with Mr. Petersen, which you just described, to whom else did you recount the incident at Burning Tree?
I might have told Mr. Dean. I don't recollect doing so. I have no recollection of recounting this incident to anyone else until I was interrogated by personnel from the Select Committee and also personnel from Special Prosecutor Cox's staff.
You are aware, are you not, that Mr. Dean has testified with respect to reported conversation you had with him on the subject?
I have no recollection of mentioning it to him. If he recollects it in as much as the event occurred, then I think on that instance I would have to credit Mr. Dean's testimony.
Mr. Kleindienst, did you participate in a conversation with Mr. Henry Petersen and Mr. Dean concerning the possibility of going to the President because the circumstances and events indicated that there was more to the Watergate break-in than appeared?
Well, the characterization that you put at the end I don't think was relevant to our meeting, but I believe it was either Monday or certainly no later than Tuesday that Mr. Dean, Mr. Petersen, and I had a conference that took place in my office. The purpose of Mr. Petersen and myself meeting with Mr. Dean was to indicate to Mr. Dean the apprehension and the grave seriousness with which we received the news of this fantastic event that had occurred at the Watergate Hotel. To inform him, as counsel to the President, that the Department of Justice and the FBI would be compelled and would immediately launch a full-scale, intensive, thorough investigation into all the facts surrounding it, that this was a felony, that in addition to being a felony, if you can think of anything worse, it also went to the very heart of our political system, and that it was an act of such a heinous nature that we were going to call forth and bring about an investigation immediately. I think Mr. Petersen interrupted or said that either myself or Mr. Dean should contact the President personally to indicate to him the gravity of the situation, the consequences of it. And I believe Mr. Petersen said in that remark that either Mr. Dean or I should urge the President to make a statement immediately, setting forth his attitude response to this fantastic event. I believe that Mr. Dean volunteered at that point to the effect that, well, I'm going up to San Clemente, and I will convey your suggestion, Mr. Petersen, because I'll be seeing the president myself. I believe I concurred in that. I don't know how long that meeting lasted, but I think that that's the substance of what transpired at that time.
There has been testimony, Mr. Kleindienst, that shortly after this meeting there allegedly was an effort to implicate or involve the CIA as part of the Watergate cover-up, and that was done by Mr. Dean, Mr. Ehrlichman, and Mr. Haldeman. In late June or early July of 1972, were you aware of these events?
I was not aware of the meetings that have been testified here by Mr. Gray, Ambassador Helms, or General Walters. I had no knowledge of such meetings until I heard their testimony in this matter. I have a vague recollection of Mr. Gray mentioning to me sometime during that period of time that assertions were being made that there was a possible CIA involvement in the whole Watergate situation, and the fact that I believe he expressed to me that if there is actual CIA involvement in this matter, it would certainly complicate the investigation of the FBI. So that statement must have been made by him prior to the time that he had ascertained that there was no CIA involvement. Having so ascertained it, to my recollection, he never mentioned that situation to me again. To my recollection, I never had a conversation with Mr. Dean, Mr. Ehrlichman, or anybody at the White House with respect to the so-called CIA matter.
Did Mr. Gray mention to you his telephone conversation with the president on July 6, 1972?
Not to my recollection.
Mr. Kleindienst, during the summer of 1972, were you aware that Patrick Gray was making available to John Dean FBI teletypes and 302s?
No, sir. First time I became aware of that was in the confirmation hearing of Mr. Gray to be the permanent director of the FBI.
Had Mr. Dean spoken to you about the possibility of the FBI supplying to the White House such documents?
Mr. Dean raised the question with both myself and Mr. Petersen. Both of us were very quick to tell him that we would not give him raw investigative data from FBI files. I told him, based upon his representation to us and my belief throughout this matter, that he was counsel to the president, he represented continually, he was dealing directly with the president, that the president had delegated him to more or less be responsible for an overview of the investigation insofar as it might relate to White House personnel. I told Mr. Dean that since I had been in the Department of Justice, I hadn't been Attorney General but a week when this fantastic situation occurred, that it had always been my policy, and one that was shared by Attorney General Mitchell, that only under the most restricted circumstances should raw FBI investigative data be given to anybody. I believe I did indicate that we wouldn't mind summarizing pertinent information that was relevant to his inquiry orally for him so that he could make a report to the president. I believe I also indicated that if there was a particular file that the President of the United States personally wanted to see, that I would be willing to take that file personally up to the President, sit down with the President, and let him look at it, and then bring it back.
Mr. Kleindienst, during the reporter, during the summer of 1972, were you aware or made aware of a Saturday night phone call from Mr. John Ehrlichman to Henry Petersen?
In the summer of 1972?
Yes, summer or fall, excuse me.
I don't know if it was an evening call. I became aware of a call that Mr. Ehrlichman made to Mr. Petersen, I believe in the middle of the day, sometime between July 7th or 8th and August 8th or 9th, at a time when I was at the Pocono Lake Preserve in Pennsylvania with my family on a vacation. I became aware of such a call at that time.
How did you become aware of it?
I became aware of the call because Mr. Ehrlichman called me. He started the conversation out, I think, by saying either Dick or General, depending upon the nature of the conversation and how he would address me. He said, I have just talked to Henry Petersen, and I'm very upset about my conversation with him because I gave him an instruction which he refused to follow. And I think my first reaction, which was again rather abrupt and instantaneous, was, what were you doing talking to Henry Petersen in the first place? And giving him instructions of any kind. And he said, well, never mind that. I asked him to have the FBI and the United States Attorney's Office not harass Secretary Stans with respect to interrogations, just not to harass the Secretary. And I said, John, you've got to be out of your mind. What did Mr. Petersen say to you? Well, I think he said, in a polite way, he told me to go to where. And I said, well, Mr. Ehrlichman, I think by that time I might have been calling him Mr. Ehrlichman because I was very upset. I said, you're awfully lucky that Henry Petersen is the kind of man that he is, that he doesn't blow off the handle. I said, if he resigned today and had a press conference and repeated your conversation with him, you could probably be involved in an obstruction of justice complaint. And I said, Henry did exactly what I would expect him to do. Then I remember saying to Mr. Ehrlichman, I said, John, I never want you again to call up anybody in my department and give them a specific instruction. I said, if you have something to convey to Mr. Petersen or anybody over there, you can call me. He said, well, I can't reach you all the time. And I said, well, John, we've always translated most of our business on the telephone. I had a telephone installed up here to be available to you and the President or anybody else 24 hours a day. And he said, well, I will not agree to that. And I said, all right, John, if you won't agree to that, then I'll come down Monday. I would like to meet with you and the President, and if the President tells me that you have the authority and the power to give specific instructions to people in the Department of Justice, then I will submit my resignation. At that point, Mr. Ehrlichman then treated the matter lightly. He said, oh, don't get excited. I was only kidding. Don't worry about it. It will never happen again. And I can say to you that it never did happen again.
Now, Mr. Kleindienst, am I correct that Mr. Stans did not actually appear before the grand jury?
That is my understanding. And
how did that come about in view of your conversation with Mr. Ehrlichman?
Well, that came about as a result of conferences that I had with Mr. Petersen. Mr. Petersen said that if you're dealing with persons of high position, persons of great notoriety or prestige, it is not uncommon, depending upon the circumstances, instead of having them appear before the grand jury directly, is to have them interrogated by an assistant United States attorney or the United States attorney with a court reporter and give them questions and get answers from them. Otherwise, the same ground rules would apply. They wouldn't have a lawyer with them. Their attorney could be in the next room, and if they wanted to consult with their attorney, they could step out and do that. He said that particularly he saw no objection to it in view of the fact that as of that time there was no evidence of any kind in our possession that would indicate culpability or criminal conduct on behalf of Mr. Stans. I have had very little experience with the grand jury procedure. I authorized that procedure with respect to Mr. Stans, and I will take personal responsibility for it.
Now, before I ask you your relationship with John Ehrlichman in reference to the Justice Department during this period, I'd like to read a few sentences from John Dean's testimony before this committee from page 2308. quote, throughout the Watergate investigation, Haldeman and particularly Ehrlichman had complained about Mr. Kleindienst's passive role in the investigation and prosecution. Haldeman and Ehrlichman were both aware of the strained relationship between Kleindienst and the White House. I knew that Ehrlichman was riding hard on the Justice Department in an effort to undermine Mr. Kleindienst. I also knew from conversations with Kleindienst that he had little affection for Mr. Ehrlichman. Is this a fair statement of your relationship with Mr. Ehrlichman?
Oh, I think the last statement that Mr. Dean made at that time would have been subjective in nature. I don't think I had a feeling one way or another in that way about Mr. Ehrlichman. I had had, generally speaking, a satisfactory working relationship with Mr. Ehrlichman. He had a very difficult assignment and role to fulfill on behalf of the President of the United States. I often wondered how John Ehrlichman could really take on to himself the multitudinous chores and responsibilities that he did. I made it a point, to the extent possible, to work with and get along with everybody at the White House and indeed in the government as a means by which I would discharge my responsibility in the government. I didn't know, nobody told me that I wasn't getting along with the White House. I have a personality and personality characteristics which people tell me sometimes can be irritating. And I am sorry about that, and I suppose I could have irritated people up there from time to time. So far as a passive role at the Department of Justice, the decision that I made on June 17th, when I became aware of this in terms of my role as the Attorney General, was essentially this, that I should not do anything more or less in this as a major investigation than I would in any other case. In every other case that I ever was involved in at the Department of Justice of a criminal nature, I looked to Mr. Henry Petersen to be primarily responsible for the direction of the investigation. And let me say this about Mr. Petersen. I believe that Henry Petersen is the finest career lawyer that this country has ever had. In 4.5 years of association with him, I found him to be intelligent, fair, courageous, honest, dedicated to the administration of our criminal justice laws. And I suppose that of all the people that I was associated there with who would be under me in the department, I respected him more, looked to him more for advice and counsel, relied upon him more, and thanked the Lord constantly that there was a man like Henry Petersen. My admiration for him is such that I believe that Henry Petersen is the first career lawyer in the Department of Justice who was ever appointed by the President to be an Assistant Attorney General. And I thought it was a great compliment to his career of service. Consequently, on any other, as I did in any other criminal matter, I looked at Henry Petersen. I probably saw him several times a day. I did not absolve myself of the ultimate responsibility as the Attorney General in the matter, but I relied upon Henry, and I got my information from Henry Petersen. With the exception of one event, I never talked to Mr. Silbert or Mr. Glanzer or Mr. Campbell or the United States Attorney. I never gave them any directions. If there was a policy matter that Mr. Petersen would submit to me, which was proper for me to discharge as the Attorney General, I made those decisions. If they were right, I'll take the credit for them, and if they were wrong, I'll take the responsibility for them. That could have been, to people at the White House, a passive role in the Watergate case. It's the role that I elected to take, and it's the role that I tried to pursue while I was there until Sunday, April 15, 1973.
Mr. Kleindienst, I'd like to turn to a meeting that apparently took place among you, Mr. Dean, and Mr. Ehrlichman on July 31, 1972. Do you recall that meeting?
Mr. Dean, Mr. Ehrlichman, and myself?
Yes.
Without something else to prod my memory, I have no recollection of that.
Well, I'll read from page 5285, Mr. Ehrlichman's testimony before this committee, there came a time when there was a feeling that, at least on my part, based upon what Mr. Dean was telling me about the unfolding of this thing, that Mr. Magruder may have had some involvement. And that culminated in a meeting with the Attorney General at the end of July, on the 31st of July, where Magruder was specifically discussed. But just where in there I acquired information, I can't tell you.
I have no recollection of any such meeting. The only recollection I have of anybody ever saying anything to me about Mr. Magruder was Mr. Petersen's characterization to me after he appeared before the grand jury as a witness, that he said Magruder just barely, got by. As a result of our conversation, I gathered he meant by that he didn't sound like a credible witness. However, there was no other evidence available to the U.S. Attorney to contradict what he said, and that's the only characterization of Mr. Magruder that I heard. Incidentally, Mr. Dorson, let me make another gratuitous statement, if I may, and that's about these three young lawyers in the United States Attorney's Office who conducted this investigation. To me, those three, along with Mr. Petersen, are the unsung heroes of the Watergate case. I think a lot of people should be given a lot of credit, the Senate, the press, Judge Sirica, but there haven't been very many people around talking about these career people in my department. These three young men were career lawyers. I believe that they're all Democrats. They were there before we came in. They were given this assignment by the United States Attorney, and they were never interfered with under very difficult circumstances, the obvious political notoriety of it, the problems with respect to the press, the interest of the nation with respect to this terrible, reprehensible event that had occurred, impose upon these young men a burden that very few prosecutors, I think, have ever had. I had complete faith in them throughout this thing. I do today, and I hope someday that they will get the recognition that they really deserve for conducting a thorough, comprehensive investigation. And let me conclude my gratuity by this remark, that this case, it seems to me, was ultimately broken, not by Magruder and Mr. Dean going to the Senate or the press or the judge, but by going to the United States Attorney's Office in the District of Columbia, to Mr. Silbert, Mr. Glanzer, and Mr. Campbell, and giving them the information that really has unfolded this and brought us to the point where we are today. Excuse the interruption, but I wanted to make that testimony for some very fine men that I admire very much.
Fine, Mr. Kleindienst. I'd like to move ahead to February 22nd, 1973, and to your meeting with the President on that date, and ask you if you can summarize for the committee what occurred.
February 22nd, 1973. Without something else to prod my memory, Mr. Dorson, I haven't the slightest idea. Incidentally, for the benefit of the committee and council, throughout the time that I was in the Department of Justice, I did not keep lengthy memos of my conversations. I didn't write memos to file. I didn't write self-congratulatory memos back and forth. When I dealt with people at the White House and with the President of the United States, I did it as a cabinet officer, as the Attorney General, in good faith. I gave them my best opinions at the time, and I did not keep copious memoranda for the benefit of my grandchildren 50 years from now or anybody else. Consequently, and I think you can see there as a result of my logs that it would not be uncommon for me to have 50, 60, or 70 telephone calls or meetings in a day. So unless you have something else about February 22nd with the President of the United States, I haven't the slightest idea what I did.
Well, I believe we raised it with you in one of the preparatory sessions, and Mr. Dean testified about it as the meeting in which you were trying to be brought back into the family, where the agenda was prepared, and I think efforts were made to have you stay on as Attorney General past the deadline which you had set for yourself.
Well, I didn't know that I wasn't a member of the family. The President of the United States, incidentally, never gave that indication to me. I never had anything but the finest relationship with him. Again, for the record, the only instruction the President of the United States ever gave me at any time after Watergate was to see to it that the Department of Justice and the FBI conducted a thorough, complete, intensive investigation, and I think the phrase that he used several times was, let the chips fall where they will. If that was the meeting, however, at which the President discussed with me my tenure in the Department of Justice, and I don't know if it was that date or not, I did have such a meeting, because I recall the President asking me to come up to see him on rather short notice. By way of preface, before the election, I communicated to the President through Mr. Mitchell the fact that I would like to stay as the Attorney General until September of 1973, which would be coterminous with the expiration of my term as President of the Federal Bar Association. My reason for doing so was one strictly of financial reasons. I'll have 3 children in college this year. My service in the government had depleted a rather modest estate, and I just could not afford to longer stay in the government of the United States. After the election, when I had meetings at Camp David, I went to Europe for 10 days and had meetings with respect to drug enforcement matters in London, Paris, Madrid, and Bonn. I was informed by Mr. Haldeman and Mr. Ehrlichman that my request had been acquiesced in, and then I had a subsequent meeting with the President in which he likewise said that that would be fine. At a meeting after the inauguration and before April 15, whether it's February 22nd or not, Mr. Dorson, the President called me in and he said, Dick, I don't want you to think about leaving as the Attorney General in September. He said, I understand your personal circumstances. It's going to be a hardship for you, but I have to have you stay until this Watergate situation is over. He said, I just can't have a new Attorney General, a confirmation and all the problems, and somebody coming in brand new right now. As I always have tried to do, I try to respect the wishes of the President of the United States. I said, I hope it's not going to be long after September. I won't be thinking of that date now. I want to get out of here as soon as I can, but I'll agree with you that I will not submit my resignation in September.
Mr. Kleindienst, I'm going to pass by certain other events that occurred in this period, including any role you may have played in the confirmation hearings of Mr. Gray, your receipt of any records from the CIA, and discussions as to the role you were perhaps to play in connection with this committee, and direct your attention instead at this time to a conversation I believe you had with Mr. Ehrlichman on March 28, 1973. Do you recall that conversation?
No, sir.
We have shown to the witness what purports to be a transcript of a conversation on March 28, 1973 between Mr. Kleindienst and Mr. Ehrlichman.
Is that the one that Mr. Ehrlichman taped?
That is correct,
Yes,
Mr.
then
Kleindienst.
I've had my memory vividly refreshed with respect to that conversation.
And Mr. Kleindienst, did Mr. Ehrlichman, before that conversation start, tell you he was taping it?
No, sir. If he had, some of the words that I used and that appear on this exhibit would not have been said by me, Mr. Dorson.
Well, in the interest of moving along, I do not intend to question you about the content of that conversation, but merely about Mr. Ehrlichman's not advising you. Do you know whether Mr. Ehrlichman made a practice of recording these calls?
I learned of this as a result of these hearings. I don't think I have language, appropriate language, in a public hearing of this kind to describe the reaction that I had when I learned of this. I think it's reprehensible. I think it's incredible. The concept of somebody at the White House taping a telephone conversation with the Attorney General of the United States when he's talking to them about business that relates to the President of the United States is just beyond my comprehension. Like I say, I don't want to be subjective, but I don't think I have at my command language that adequately expresses my feelings about this incident.
Mr. Kleindienst, does that document that I've shown you appear to be an accurate transcription of the conversation?
I think so.
Mr. Chairman, in the absence, may I request that that transcript be placed in evidence?
I would like to have the opportunity, for the benefit of two persons who used to be friends of mine, Senator Weicker and Judge Sirica, to explain some of the concepts that I had and why I used some of the language that I did as a result of my conversation with Mr. Ehrlichman.
Well, Mr. Kleindienst, just because I do not want to monopolize your time here, I just assume that that will be done at another occasion here. I can assure you, if nobody else does it, I will come back to it.
Thank you.
Let the record show the Ehrlichman tape of the conversation with the witness is the transcription of the Ehrlichman tape of his conversation with the witness will be marked appropriate as an exhibit and received in evidence as such.
Mr. Chairman, let the record also show that there's no reason for Mr. Kleindienst to use the expression, used to be a friend of mine.
Thank you, Senator.
Mr. Kleindienst, in early April 1973, did you have a conversation with Mr. Ehrlichman on the subject of Judge Matthew Byrne becoming the director of the Federal Bureau of Investigation?
On or about April 5th, as I recall, I was in Los Angeles, California, attending a regional United States Attorneys Conference. Either while I was there or before I left on the night before the meeting that I'm going to describe, I believe I got a telephone call from Mr. Ehrlichman or somebody on his staff indicating to me that perhaps the President was going to want to talk to me at San Clemente. I believe I indicated that my reservation to leave was Saturday morning because I either wanted to get home or had a meeting Saturday night in Washington, D.C. I was then informed that to stand by for a helicopter to come near the hotel where I was staying to early the next morning to take me to San Clemente for the purpose of meeting with them and the President. I believe later that night I was informed that the decision was made for me to go there, and at 8 o'clock in the morning I went to a lot near the hotel. A helicopter came, and I'm in San Clemente. That's the first and only time I was ever at San Clemente. My meeting started with Mr. Haldeman and Mr. Ehrlichman. Most of the meeting was consumed with a discussion based upon my recommendation of the selection of a special prosecutor for the so-called Watergate situation. This is a suggestion that I first started making to the White House in September of 1972, and a suggestion that I've made many times. The suggestion was rejected both by Henry Petersen and the White House for essentially the same reason. Mr. Petersen said that if you bring in a special prosecutor, that would be a slap at the career people in the Department of Justice and an insinuation that they haven't done their job. They're not entitled to that. And the White House kept saying to me that it would be a reflection upon me as the Attorney General if I had to bring in a special prosecutor. Somebody would say that I hadn't done my job. My answer to them at all times was, well, we've done a great job. If we can get a fair, objective, credible, outstanding lawyer with knowledge and experience to come in here and take a look at what we've done, I had such confidence in what we've done that he would say we'd done a good job, and I thought that would be good in view of the politics of the situation. And then secondly, I wanted somebody to make the ultimate prosecuting decision who was not a presidential appointee, so that persons who had legitimate interest in this, politically or otherwise, could not say that any decision, ultimate decision, was a political decision. And I thought that from the standpoint of the appearance of justice, the confidence of the people of the United States in our criminal justice system, that it would be a very worthwhile thing. I never publicly revealed these recommendations of mine. I always felt that the response by the career people in the department and the White House was legitimate and in good faith, and I never had the practice of calling a press conference every time somebody at the White House disagreed or the president disagreed with one of my recommendations. But in any event, by April 5th, apparently they were ready to discuss this matter very seriously. And we spent some time discussing how it would come about, who it might be, what his role would be, what delegation of responsibility I would give him, how could we select the person. And I had a lot of ideas because I'd been talking to quite a few people about it. And I even had some names. I think I had 3 in particular, and I remember Mr. Ehrlichman saying, well, come up with a list of 5 possible names. And I said, I'll try, but I don't know if you need 5. But in any event, that consumed most of the conversation. I recall the question of the new director, permanent director of the FBI came up, and they asked me for my recommendations. I had 2 names that I recommended to them and that we discussed that day. One was Henry Petersen, and one was Judge Byrne in Los Angeles. I think that the consensus of our conversation with respect to Mr. Petersen was that you couldn't find a better, more qualified person to be permanent director of the FBI, but because he had been in charge of the Watergate investigation at the Department of Justice as the Assistant Attorney General, he could be controversial and that he might have difficulty being confirmed. In other words, if you had him, you might have a Watergate hearing as part of his confirmation. I understood that and the reality of it, having gone through a confirmation hearing of my own a year before. And then they asked me why I was so strong on Judge Byrne. I think that they were surprised to learn of my very close personal friendship with Judge Byrne. I met Judge Byrne when I became the Deputy Attorney General. He had been appointed United States Attorney for the Central District of California, that is to say Los Angeles, which is one of our largest U.S. Attorney's office under President Johnson. When we came in 1969, there were many serious cases and matters that were still pending in his office. He came highly recommended by everybody at that time, the bench, the bar, Republicans, Democrats, and Mr. Mitchell and I prevailed upon him, if he would, to stay on for another year as the United States Attorney in this administration so he could administer the caseload that he had in that very large and significant office. He consented to do so, and I think that that was kind of an act of patriotism on his part to stay on. I think he's quite identified with the Democratic Party in California and discharge fairly and responsibly the duties of that very significant office under a Republican president. As a result of that, Matt and I became very good friends. As a result of that friendship, my estimation and opinion of him grew daily. From the standpoint of his intelligence, his ability, his knowledge, his conviction, his experience as a prosecutor, his whole concept of society, and his fairness. I was very pleased when Senator Tunney and Senator Cranston recommended him to be a federal district judge. The way we had allocated it, it was their turn to come up with one, and I wanted to suppress my pleasure to those 2 senators for fear it might prejudice Matt. He is an outstanding judge. And then I think, and I gave him those qualities. He's a bachelor. He's about 40 years of age. He's dedicated to the law. And I said, in these troubled times, as a result of Watergate, as a result of Pat Gray's misfortunes, that this would be regarded, I think, with complete credibility. There could be no charge of politics because of his bona fides as a Democrat. And then I said, you'll have a man who will be fair and forthright and honest in this job. I don't know whether Mr. Ehrlichman suggested to me that I contact Mr. Byrne or not. I do know that in that conversation I said, or I believe that I did, my recollection is, that I have not talked to Matt Byrne since the Ellsberg trial started. I said I've expressed good wishes to him through mutual friends in Los Angeles. but that he and I have just not talked together since the Ellsberg trial started. Neither one of us wanted, or at least I, and I'm sure he felt that way, wanted anybody to think that from the appearance of justice that I was going in his back chambers and trying to get some special consideration for the government in that very significant and vital case. I have no recollection of Mr. Ehrlichman ever indicating to me at that meeting that he himself was going to talk to Judge Byrne. Because of the standard that I had set for myself in not talking to Judge Byrne throughout this trial, if Mr. Ehrlichman had indicated to me that he was going to, I am confident that I would have said, John, you cannot do that while this trial is going on, or at least you should not. But really you, on behalf of the President, are really no different than I as, you know, a member of the President's family. In any event, when I first learned of the fact that Mr. Ehrlichman had contacted Judge Byrne, I know I registered a feeling of surprise that such a meeting had occurred. Now, I know Judge Byrne well enough to know that he did nothing improper as a result of that meeting, or those meetings, nor would he permit anybody else to put him in a situation of impropriety. The Ellsberg trial was just about ready to come to a conclusion. The evidence was just about in and was going to go to the jury. And because of the delay that had already occurred, I didn't think there was that kind of a problem. Mr. Gray was continuing to act as the acting director of the FBI, and I thought with great distinction. That is what I recollect of the Byrne incident.
Mr. Kleindienst, I just want to allude to a few of the subsequent events briefly at this time, however important they are. I do not want to pursue it in detail now. But am I correct that on the early morning hours of April 15th, 1973, you had a meeting with Mr. Petersen, United States Attorney Harold Titus, and the prosecutors at your home? It was just one of the prosecutors, and that was the chief prosecutor, Mr. Silver. And am I correct that this meeting dealt with the disclosures of Mr. Magruder and Mr. Dean to the prosecutors? Yes, sir. Following that meeting, am I correct that you made an appointment to see the President later in the day on April 15th, 1973? That meeting commenced at approximately 1 o'clock in the morning. It terminated around 5 o'clock in the morning. I was up at 8:30. As a result of that meeting, we agreed that I had to see the President. I put a call in the White House at 8:30. The President returned my call at 9:30. I told him it was absolutely imperative that I see him right away. He said that I have the Sunday service at the White House at 11. I told him that rather than go to church with my wife and children, I'd go up there and attend that service at 11 and be available to see him after that was over. I think the reception lasted until approximately 1 o'clock, and around 1 o'clock in the afternoon, approximately, I met with the President in his office in the Executive Office Building. Now, am I correct that at least part of the meeting was devoted to briefing the President, and that one of the decisions made on the afternoon of April 15th by you would be that you would, in effect, withdraw from the supervision of the prosecution of the Watergate case? The whole meeting was devoted solely to talking about the information that I had obtained that night and the consequences that inevitably must flow from it. Now, Mr. Kleindienst, I'd like to show to you a document which you provided the committee dated April 15th, 1973. First page is typewritten. The page under it is handwritten, and I ask you if you can identify that for the committee. Yes, I know what you have in your hand, Mr. Dorson. I furnished it to the committee. The document underneath in my handwriting is a document that I
die, and I'm sure he felt that way. Wanted anybody to think that, from the appearance of justice, that I was going in his back chambers and trying to get some special consideration for the government in that very significant and vital case. I have no recollection of Mr. Ehrlichman ever indicating to me at that meeting that he himself was going to talk to Judge Byrne. Because of the standard that I had set for myself in not talking to Judge Byrne throughout this trial, if Mr. Ehrlichman had indicated to me that he was going to, I am confident that I would have said, John, you cannot do that while this trial is going on, or at least you should not. But really, you, on behalf of the President, are really no different than I as, you know, a member of the President's family. In any event, when I first learned of the fact that Mr. Ehrlichman had contacted Judge Byrne, I know I registered a feeling of surprise that such a meeting had occurred. Now, I know Judge Byrne well enough to know that he did nothing improper as a result of that meeting, or those meetings, nor would he permit anybody else to put him in a situation of impropriety. The Ellsberg trial was just about ready to come to a conclusion. The evidence was just about in. It was going to go to the jury. And because of the delay that had already occurred, I didn't think there was that kind of a problem. Mr. Gray was continuing to act as the acting director of the FBI, and I thought with great distinction. That is what I recollect of the Byrne incident.
Mr. Kleindienst, I just want to allude to a few of the subsequent events briefly at this time, however important they are. I do not want to pursue it in detail now. But am I correct that on the early morning hours of April 15th, 1973, you had a meeting with Mr. Petersen, United States Attorney Harold Titus, and the prosecutors at your home?
It was just one of the prosecutors, and that was the chief prosecutor, Mr. Silbert.
And am I correct that this meeting dealt with the disclosures of Mr. Magruder and Mr. Dean to
Yes,
the
sir.
prosecutors?
Yes, sir.
Following that meeting, am I correct that you made an appointment to see the President later in the day on April 15th, 1973?
That meeting commenced at approximately 1 o'clock in the morning. It terminated around 5 o'clock in the morning. I was up at 8:30. As a result of that meeting, we agreed that I had to see the President. I put a call in the White House at 8:30. The President returned my call at 9:30. I told him it was absolutely imperative that I see him right away. He said that I have the Sunday service at the White House at 11. I told him that rather than go to church with my wife and children, I'd go up there and attend that service at 11 and be available to see him after that was over. I think the reception lasted until approximately 1 o'clock, and around 1 o'clock in the afternoon, approximately, I met with the President in his office in the Executive Office building.
Now, am I correct that at least part of the meeting was devoted to briefing the President, and that one of the decisions made on the afternoon of April 15th by you would be that you would, in effect, withdraw from the supervision of the prosecution of the Watergate case?
The whole meeting was devoted solely to talking about the information that I had obtained that night and the consequences that inevitably must flow from it.
Now, Mr. Kleindienst, I'd like to show to you a document which you provided the committee dated April 15th, 1973. First page is typewritten. The page under it is handwritten, and ask if you can identify that for the committee.
Yes, I know what you have in your hand, Mr. Dorson. I furnished it to the committee. The document underneath in my handwriting is a document that I wrote out in my office in the presence of Mr. Petersen after he and I had met with the President of the United States, in which I set forth the reasons why I had to recuse myself from any further contact or involvement in the Watergate case, and in which I designated him to substitute for me as the Attorney General of the United States in anything further concerning the Watergate case. I further requested that he communicate this decision of mine and the contents of this memorandum to the United States Attorney Titus, to Silbert, and to Acting Director Gray of the FBI. I signed it, and I had Mr. Petersen sign it, indicating the time that he received it. It was important for me to establish the time when I no longer had any connection with the Watergate thing. I then Xeroxed a copy of my handwritten statement and gave it to him, and I kept the original. And the top document that you handed me is the typed document of my handwritten document.
Mr. Chairman, I request that the document identified and summarized by Mr. Kleindienst be admitted into evidence.
It will be received and appropriately marked as an exhibit and admitted into evidence as such.
Mr. Kleindienst, what does the word recuse mean in this context?
It's a technical word used by lawyers, and particularly those in government service, which signifies that for one reason or another, usually ethical reasons, that you withdraw from any further participation in a particular matter.
Mr. Kleindienst, when did you first learn of the fact, which apparently is a fact, that White House employees or persons working at the behest of White House employees burglarized the office of the psychiatrist of Dr. Daniel Ellsberg?
I learned that amazing bit of information sometime in the morning of Wednesday, April 25th, 1973.
And how did you learn it?
Mr. Petersen called me and said that he had a very urgent matter, and could he come up to my office. I don't know if I had anybody in there, but if I did, I got him out. He came up in a minute and handed to me, without saying anything, a copy of a memorandum dated April 16th from Mr. Silbert to himself, a buck slip from him to Mr. Kevin Maroney, the Deputy Assistant Attorney General for the Internal Security Section of the Criminal Division, and a memo from a Mr. John Martin to Mr. Maroney, dated sometime that week. I do not recall the date of that. It would have been after the 16th of April and before April 25th. I read the two memos after I had recovered my composure and had uttered some of my abrupt remarks. He and I then began to discuss the dire, serious nature of this amazing revelation. We discussed it for some time. It had a fantastic potential effect upon the trial of the Ellsberg case. It had certainly a fantastic potential with respect to the constitutional rights of Mr. Ellsberg, a defendant. And I believe our conversation kicked around until just before noon. At noon, I had an appointment to go with Solicitor General Griswold to the Department of Defense and be with him at a luncheon in his honor by the Judge Advocate General's Corps of the United States Army. I remember in the car outlining a hypothetical situation to Dean Griswold as a means by which, as I did quite often, to get the benefit of his advice and his wisdom and his counsel. Prior to the time that I went to lunch, Henry and I had arrived without difficulty and simultaneously at two conclusions. Number one, that we had to transmit this information immediately to Judge Byrne through our chief prosecutor, Mr. Nissen, in Los Angeles without delay. And number two, that because of the explosive, just because of the nature of the situation, that I should immediately contact the president and inform him of this situation and also of what I was going to do. Before lunch, I then placed a call to the White House. Usually when you call and want to see the president, they want to know what you want to talk to him about. I was very insistent in this instance to say that it was a matter of great urgency, but I couldn't describe, the reason for the meeting. When I got back from my lunch in honor of Dean Griswold, soon thereafter I received a call from the White House that if I could come over right away, I could see the president. I did. I gave him, I had those memos, those papers with me. I had a couple of cases that, I could discuss in a little notepad, but I didn't give him those citations. He, without hesitation, one moment's hesitation, said that the course of action that I was going to pursue was the only thing possible to be done. He caused the memos to be Xeroxed. He kept a copy of the memos, and I left. The meeting didn't last very long because there was no problem in his mind or my mind or anybody else's mind as to what we had to do under the law.
Did you have an impression one way or the other as to whether this was the first time that the president learned of these events?
I don't know if I gathered that impression, Mr. Dorson. I know he was very upset about it. He was very upset about it.
Did he say whether this was the first time he'd heard?
To my recollection, he did not. And I just wouldn't know. The fact that he was so provoked, the language that he used to describe the idiocy of the event, indicated to me that he had not learned of it, except just soon, But I don't believe I asked him. It wasn't my habit to interrogate the President of the United States, and all I know is he was very, very provoked.
And was an announcement made later that day?
Well, either while I was at the President's office or when I came back, the memos were teletyped to Mr. Nissen, the chief prosecutor in Los Angeles, and Mr. Petersen then thereafter gave him instructions as to what he was supposed to do. I believe those instructions were that he was to give them to Judge Byrne and then be guided by Judge Byrne's decision.
And am I correct, Mr. Kleindienst, that approximately 1 week later you left the Department of Justice?
Yeah, let me explain the reason for the delay between April 16th and April 25th. I think one of the important things that had to be determined by the Department of Justice before a disclosure of this information would be made to Judge Byrne was whether or not the fact of the burglarization of Dr. Ellsberg's psychiatrist was known to anybody in the Department of Justice at any time before or during Dr. Ellsberg's trial, because that would be one of the most significant inquiries that the judge and the other side would have. Indeed, if it could be made known that any of our attorneys or the prosecutors were aware of this fact and did not disclose it, they would have been guilty of contempt of an order of the judge, and they would also have been guilty of dereliction in their duty as a prosecutor of the United States of America. The Martin Memorandum that was addressed to Mr. Maroney clearly and unequivocally set out the fact that nobody in the Department of Justice had any advance knowledge of this before or during that trial. And it was, I think Mr. Petersen was delaying bringing this matter to my attention until that fact could be ascertained, so that in no way was Mr. Ellsberg prejudiced, in the trial of this case as a result of either our knowledge of any of the contents, and I've subsequently learned that they didn't get any information out of the psychiatrist's office anyway.
Mr. Chairman, I have no further questions.
Minority Counsel Fred Thompson begins his questioning of former Attorney General Kleindienst in just a moment. Public television coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Fred Thompson, minority counsel for the committee, now asks Kleindienst about John Dean.
Mr. Thompson.
Mr. Kleindienst, as I understand it, Mr. Dean came to you shortly after the break-in and indicated that he was looking into the matter for the White House or keeping abreast of the matter for the White House. How did he...
I think he was a little bit more specific than that, Mr. Thompson. The representation that he made to me and to Mr. Petersen throughout was that he was doing this for the President of the United States and that he was reporting directly to the President. He had been delegated by the President to be posted and informed throughout the course of the investigation to enable him to report directly to the President of the United States.
Did you have any subsequent contacts with him that would indicate whether or not he was, in fact, carrying on what he described his job to be?
I had no reason to doubt that assertion by him until I met with the President of the United States Sunday afternoon, April 15th.
Did he tell you on more than one occasion that he was reporting directly to the President?
I would say just continually.
Was this a matter that concerned you somewhat, exactly what his role was?
I assumed that that's what he would be doing as counsel to the President.
Did you consider this a proper role for a man in his particular position as counsel to the President?
As counsel to the President?
Yes, sir.
thought it was what he might be there for. I had nothing but the highest opinion and estimation of Mr. Dean as a result of a year and a half that he served as a deputy to me when I was a deputy attorney general and throughout this whole situation. Had no reason to question that at all.
You stated that he approached you concerning the FBI files, and you in effect told him that if the president needed to see a particular file, you'd deliver that file yourself, and that you did not know that Mr. Gray was giving him files. I assume then, if we can reconstruct this matter, that he approached Mr. Gray after he approached you.
I don't know.
Did Mr. Gray ever tell you that he was giving files to Mr. Dean? Would you consider, with your relationship with the director of the FBI, if he was in fact giving files to Mr. Dean, would you consider this a matter that he would properly report to you or discuss with you before he would do so?
I don't know. I think if Pat, who I have a lot of sadness about some of the people involved in this, and I think Pat occupies one part of my heart. I think if Pat Gray had been aware of the fact that John Dean had made this request to me and I had said no, or if he had raised the question to me and I had said no, I am certain that Pat Gray would have, complied with my direction. The only way I can explain it is that I think Pat justified it in his own mind, and I think there is a basis for justifying it in his own mind. He had no particular reason to know how I felt about it. So I guess it's just a subject matter that when you're busy as the director of the FBI and the Attorney General of the United States is, it just didn't come up. I know if he had told me that, I would have specifically directed him not to do so.
Mr. Kleindienst, when Mr. Ehrlichman called you on April 14, did he discuss the fact that he was conducting or had conducted his own investigation?
Yes, he did, and based upon revelations made here, I assume that that's one of the calls that was taped. On Saturday afternoon of April 14th, I was again out at the Burning Tree Club. I want to tell the chairman that I only play golf on Saturday and I don't do it on Sunday, and a lot of these meetings occurred on Saturday, so I don't want you to think I'm completely profligate.
Well, the chairman would observe that the chairman, has never had a golf stick in his hand.
Well,
I've had found too many other things to do.
Well, I feel sorry for you, Mr. Chairman. Well, anyway, back at Burning Tree. About 3:30 in the afternoon, I got a call from Jan Oruska, Miss Oruska, who is Mr. Ehrlichman's secretary. And she said, Mr. Kleindienst, Mr. Ehrlichman is going to want you to come down to the White House and see him this afternoon. And I said, Jan, that's all right with me if I can come down right now, because I'm going to the White House Correspondents' Dinner and I have to be at a reception at 6 o'clock. And if it's going to be delayed, I will not be able to come down. She said, I'll call you right back. A couple of minutes later, she called me right back and said, where can you be on the telephone at 5:30? And I said, I'll be at home. She said, fine, Mr. Ehrlichman will call you at home at 5:30. I rushed home from Burning Tree, changed my clothes, and was dressed ready to go to be there by 6 so that after I talked to Mr. Ehrlichman, I could make my 6 o'clock reception. Mr. Ehrlichman started out, and again, I think he said general, but I'm not sure. I'd like to see the tape of it. General, I've been meaning to call you and give you a report, but I've been too busy and I haven't been able to do it, but I've got a report to make to you. And I said, well, what's that, John? And he said, well, I have been conducting an investigation for the president with respect to the possible involvement of White House and campaign personnel in the Watergate situation for the past couple of weeks. And I said, John, you mean you've been interrogating people with respect to their conduct? He said, yes, I have. And I think I remember saying, well, John, have you talked to anybody who indicated to you that they might have been involved in criminal conduct? And he said, yes, that's true. And I said, John, you want to be very careful. I said, that kind of information should go to the FBI. And if you don't turn it over to the Department of Justice, you might find yourself in a situation where you might be an accessory after the fact or obstruction of justice. My purpose was to try to help Mr. Ehrlichman out and give an indication of what the law was and what can happen if you do certain things. He said, well, it doesn't really make any difference anymore. And I said, well, why not, John? He said, well, Mr. Magruder has been over here at the White House this afternoon and telling us that he has been meeting with the United States Attorney's Office and giving them testimony and evidence that would implicate people high and low in the White House and in the campaign committee. I think I might have uttered some fantastic indication of surprise, and then he abruptly terminated the call, as I remember, by saying, have a good time at the White House Correspondents' Dinner, and the phone went down. Needless to say, I didn't particularly enjoy the dinner. Sometime that evening, I got a hold of Mr. Petersen and told him that I had to see him. And this is one aspect of it that I'm not precise about. My wife keeps telling me that I called Henry Petersen first, and I always believe that he called me. But in any event, I left the White House Correspondents' Dinner early. I usually stay. Gives me an opportunity to gig back members of the press after they've been gigging me all year. And I have so many friends among them. But in any event, I decided to leave early. And when I got home, I had a conversation with Henry. And he said, it's important that we get together with you tonight. That was around 12 o'clock. I live out in McLean. He and Titus and Silbert were there by 1 o'clock in the morning.
Did you ever have any other conversation with Ehrlichman as to the findings of his investigation?
No.
Did you ever find out what he, in fact, reported to the president?
No. Never have. He told me, he opened the conversation up by saying, I've been meaning to call you before now, which would indicate that he had an intent to do so but hadn't.
Your conversation with Titus and Silbert and Petersen, did they, was it about 4 hours, I believe from 1 in the morning until about 5 o'clock?
Yeah.
Did they tell you the substance of what Magruder and Dean had been telling the U.S. Attorney?
Yes, sir, and I got some of my wife's personal stationery and made rather copious notes of what they told me so I could report it to the president the next day.
All right, can you recount to us briefly what they told you at that time?
Well, they in effect summarized the testimony or statements or purported statements of Magruder and Dean, which in one way or another would implicate Mr. Mitchell, Mr. LaRue, themselves, Mr. Haldeman, Mr. Ehrlichman, Mr. Mardian, you name it. It was a very lengthy meeting. This is the first time since June 17th of 1972 that anybody had given me any credible evidence that any of these people were involved in any way in either the cover-up or that incident.
Did they tell you?
Two of those men are two of the closest friends I've ever had in my life, and I think one of the things that I did that night is I wept. But it was a long meeting, Mr. Thompson. And it was a comprehensive meeting, and I made comprehensive notes of what occurred.
Do you recall if they told you that Mr. Dean at that time had made allegations against the president concerning presidential cover-up?
No.
Did not?
They said that Mr. Magruder was not looking for immunity and that Mr. Dean was bargaining with his attorney for immunity, and that his statements to them were on a conditional basis through his attorney, predicated upon whether he got immunity or not.
So you went to see the president the 15th?
Yes, sir.
Same day. And did you substantially tell him what they had told you?
To the best of my ability, because I took the notes that I had written on my wife's blue stationery and I had them in my pocket, and I read from my notes.
And what was the president's reaction?
He was dumbfounded. He was very upset. He was Very upset.
I believe you mentioned in an interview that he was partially consoling you.
Well, I was very upset about this, Mr. Thompson. I don't think since my mother died when I was just a young boy that I've ever had an event that has consumed me emotionally with such sorrow and sadness as this situation. And he was very considerate of my feelings.
Mr. Kleindienst, did you have occasion any time after the break-in in 1972 of talking to the President either in person or by telephone about the Watergate matter?
I didn't. I know I had a conversation with him almost immediately afterwards.
Do you recall what was said in that conversation?
Well, what was said about that is, he said, Dick, I told him what we were doing, and he said, Dick, you've got to have a thorough, intensive, complete investigation of this. And I think that's when he first used the term, let the chips fall where they will. During the summer, we had the Republican convention. I was gone for approximately a month up in the Poconos, and then the campaign came along. I didn't have many conversations with the President during that period of time, none that I can specifically recall. I had 2 meetings with him up at Camp David after the election and after I had returned from Europe. We didn't have to talk much about the Watergate. I knew what I was doing, he knew what I was doing, but the extent to which it was brought up was in the same context.
Mr. Kleindienst, I have no further questions. Thank you, sir. Thank you, Mr. Chairman.
Did John Ehrlichman tell you he was bugging, use that word unadvisedly, rather than recording, your conversation with him?
No, sir. If I ever felt that he had, I don't know if I'd ever talk to him again.
Now, you stated, as I understood your testimony, that the President indicated by his conversation when you reported what you knew about the Watergate affair to him that...
What meeting are you talking about, Mr. Chairman?
The 15th,
yes,
I believe, of April, that he indicated by his reply that he didn't know, that he was ignorant about the Watergate affair.
Well, I would say that the information of the nature that I described with him would have come to his attention contemporaneously. If Mr. Ehrlichman is talking to Magruder all afternoon, the day before, I would just assume, although he didn't say, that Mr. Ehrlichman would have made a report like this to the President. But I would gather from my meeting with the President that he had no such knowledge until immediately prior to my meeting, Mr. Chairman.
Yes. Now, do you agree with me that of all the human beings on the face of the earth, that the one who knows most about this is the President himself? That is, about the President's state of knowledge?
You mean that the one person who knows most about this situation?
Yes. No, the one that knows more about what the President's state of knowledge was between June the 17th, 1972 and April the 15th, 1973 is the President himself.
Well, Mr. Chairman, I would agree that the President knows more about what he knows than what I know.
That's what I would think, yes.
Yeah. I know more about what I know than he knows what I know.
Yeah. And in July, sometime between July the 7th and August that 9th, I believe you said, John Ehrlichman called Henry Petersen and entered a protest that he was Harrison, former Secretary of State's, because he was the prosecuting attorneys were Harrison, Secretary of State's, because they were calling upon him to perform an obligation which devolves upon all citizens of the United States.
That's essentially it. I think Mr. Petersen will be a better witness as to the conversation between Mr. Ehrlichman. My attention really wasn't so much consumed with what Ehrlichman said to Petersen and Petersen said to Ehrlichman. I was interested in Mr. Ehrlichman not giving directions to people in my department.
He was a person that had been delegated with the President with a tremendous governmental power, John Ehrlichman, undertaking to dictate to the Department of Justice how witnesses should be treated.
Yeah, I think Mr. Ehrlichman made a mistake on that. He never did it again, and he probably wishes that he hadn't done it.
Well, now, as I understand from your testimony, if I'm wrong, you can let me know. You agreed that Assistant Attorney General Petersen could excuse Stans from going before the grand jury and let him testify by deposition in
Yes, sir.
some private offices or public offices apart from the grand jury?
Mr. Petersen made that recommendation to me, and I will take the full responsibility for that, Senator Ervin.
Well, that troubles me a little bit because of my conviction that all men, regardless of whether they're princes or peasants, or former cabinet members and just ordinary Americans, ought to stand equal and be treated equally before the law. It also gives me misgivings for another reason. Under the statute, we have grand juries composed of anywhere from 16 to 23 men, and it's a part of the judicial process that they shall have an opportunity to cross-examine a witness.
May I make a point right there, if I please, Mr. Chairman? I think one of the things Mr. Petersen said to me when we discussed this thing was that if the grand jury, when they received his written testimony, had any reason for wanting to interrogate Mr. Stans directly, that then Mr. Stans would be required to go before the grand jury.
Well, don't you agree with me that a grand juror could cross-examine Mr. Stans better than he could a piece of paper?
Sure.
With some words on it?
I think, and I'm not trying to rationalize or debate the matter with you, Mr. Chairman. You take the situation, the context in which I found it, there was no reason to suspect Mr. Stans of illegal conduct. I know that in this administration with, let's say, very important Democratic officials, they had a procedure like this, so. But I think now, with the hindsight that we are able to exercise, maybe I would have done something different.
Well, I think that when John McCormick was excused from going before the grand jury, that was also an affront to justice. Now,
I'm not prepared to dispute that, Senator. That's why I personally will take the responsibility personally for
I'm not saying anything, I'm not insinuating there's anything more than their judgment. I'd like to make that plain.
I understand that, but I want to make it clear here that I'm not trying to impose the responsibility for that decision on anybody else but myself.
And I might confess that I have an overriding sense of curiosity as to what Secretary Stans stated in his deposition. I've asked for copies of the deposition, but it appears not to be forthcoming.
Well, there's another law, I think, Senator Ervin, that precludes or prohibits the disclosure of testimony before a grand jury to anybody.
Yes, I'm not asking for testimony before the grand jury. I'm asking for the testimony taken before the prosecutors. That's quite a different situation.
No, that was testimony taken for the purpose of the grand jury, and it was given to the grand jury.
But I know of no law which exempts testimony taken before prosecutors. It's only testimony taken before grand juries. I don't want what is taken before the grand jury. I want what is taken before the prosecutors. Now, this troubles me not only from the fact that Stans was given, notwithstanding the fact that I think presidents and secretaries have feet of clay just like the rest of us and are entitled to no special consideration. But it also troubles me. Well,
The demonstrators who interrupted Chairman Ervin at this point attempted to read a statement protesting alleged CIA involvement in domestic intelligence operations. Capitol Police escorted the 9 men and women from the hearing room, but on orders from the chairman did not arrest them. Some of the young people claimed to be members of a group called the National Caucus of Labor Committees of New York City. Outside the building, about 50 other demonstrators circled and chanted slogans criticizing the Central Intelligence Agency.
Stan's attorneys had a copy of the deposition.
Yeah. Yeah. The lady will please desist from her conversation. I would suggest that the police put those people under arrest. This seems to be a conspiracy to disrupt the meeting. No, wait. No. We might as well. Well, just exclude it. The committee will resume. I'll just make one other observation rather than a question. This causes me misgivings because Secretary Stans testified before this committee that the treasurer of his committee disbursed in cash thousands of dollars to Liddy, that his treasurer remonstrated with the unwisdom of disbursing this money, and that at the suggestion of rather inspired with this remarks, that he went to and talked to Mitchell with it, and if it's quite possible that if Stans had gone before the grand jury, some inquisitive grand juror might have broke this whole story in July or August 1972, and this nation might have been spared the agony it's gone through since. Now, with reference to, I appreciate your commendation of, do you know whether Stans' attorneys were given a copy of the deposition?
No, I do not, sir.
I appreciate your commendation of the FBI investigation. A lot of innocent things sometimes impede an investigation. For example, this committee has information to the effect that the only question asked of Sloan, who had disbursed thousands of dollars of campaign funds in cash, was whether Baldwin, the man who bugged the Watergate from the Howard Johnson, was on the committee payroll.
I find that hard to, I'm not saying that that's true, not true, but, you know, until Judge Sirica entered an order which compelled me and other officers of the Department of Justice from discussing this thing, and because of the political nature of it in '72, it was with great pride that I was publicly saying all over the United States the nature of our investigation. I think I refer to the fact that as of that time, in the middle of summer, before they went to the grand jury, 14,000 man-hours, 1,700 witnesses, 333 agents, 53 out of 59 field officers, some witnesses interrogated 2 and 3 times, practically everybody at the campaign committee, people at the White House. And I thought that was a remarkable achievement of the FBI. And I think the FBI is a great institution.
Well, I do too. Yeah. I do too, but I think that maybe like Homer sometimes it might nod just a little bit.
Well,
I don't think, I know one thing.
They're human beings too.
From my long experience in the practice of law, that if you don't ask the right questions, you don't get the right answers.
But again, I think, Senator, and I'm not saying this to self-serve myself, but for the career people of the Federal Bureau of Investigation, in a very, very unusual situation, I had nothing but pride and admiration for their professionalism and their constancy, and as I say, giving the Congress its due, giving the press its due, giving the judiciary and Judge Sirica its due. I'm sad to say that not enough has been given to the career people of my department and the FBI for what they did in this situation.
Well,
and I want to be here to make that testimony for them.
Well, I appreciate your loyalty to them, and I trust they're deserving of it. We do have testimony before this committee from Mr. Sloan that he told some of the prosecuting attorneys about the disbursement of this money to Liddy, and also about the fact that Magruder had attempted to persuade him to commit perjury rather than reveal the truth, and that he did that before the indictments were returned.
I didn't know that.
And we also, Mr. Ehrlichman, who expressed opinion on many points, he said that the reason that they did that, he thought, was because they decided that they would try the case in their own minds, and they decided that Magruder was telling the truth and Sloan was not.
Well, you know, when you have in our system of criminal justice, as you know, Senator Ervin, you know, you have to have evidence to indict somebody. We don't put people on a rack and extract the truth out of them. We don't crush their fingernails or beat them over the head. And prosecutors, if they are responsible, they shouldn't, it seemed to me, on mere allegation and suspicion,
well, I'm not,
seek the indictment of somebody without evidence.
I'm just pointing out the fact that these facts did exist. I don't aver that to do that. Human errors of judgment sometimes impede us reaching the truth.
Sure.
And
sure.
I don't want you to think that any questions I've asked you or any observations I've made reflect or intended to reflect in any way on you. My contacts with you have impressed me with the fact that you're a rather forthright individual, and I think that this whole thing might have been avoided if some other people in the government had emulated your example when you told John Ehrlichman and John Dean there were certain things you wouldn't permit to be done.
Well, I'm a human being, and I make my mistakes and have my fallibilities, Senator Ervin.
Senator Baker. Mr. Chairman, thank you very much. Mr. Kleindienst, reiterate what the chairman has just said. As a matter of fact, I had planned to call attention to what I believe to be a series of facts and circumstances to which you've testified or about which this committee has taken proof from other witnesses that seem impressive to me in the context of the questions I'm about to ask you. It appears that when on June 17th, 1972, you were approached on trying to get these Watergate burglars out of jail, you in fact said no, they're going to be treated like everybody else. Is that essentially correct?
Yes, sir.
And when John Dean asked for FBI files, you in effect said, if the president wants FBI files, let the president ask, but you're not going to get them. Is that right?
Yes, sir. Or anybody else.
And when John Ehrlichman called your people and complained, and then called you to complain about the way certain matters were being held, you told John Ehrlichman, don't you talk to my people anymore. If you want to talk to me. Is that essentially correct?
Yes, sir.
And when you received information about the Ellsberg break-in, you found it to be of extraordinary importance, and you went to the president and talked to him about it.
Yes, sir.
And when on April 15th, 1973, the U.S. Attorney's Office and others came to you at the late hours of the night and laid out a detailed case of extraordinary involvement by White House officials, apparently, and by committee to re-elect officials, apparently, you promptly set up a meeting with the president. Is that right?
Yes, sir.
And you told the president about it.
Yes, sir.
And when you told the president about it, you wrote a note on the spot, virtually, saying that because of my personal and professional relationship with some of the people that may be charged with crimes, mentioning John Mitchell and others, that I recused myself and require of Petersen that you assume these responsibilities and act as Attorney General. Is that right?
Yes, sir.
Well, on that basis, Mr. Kleindienst, I join in the chairman's statement. I think if more people had acted in that way, that the great trauma that we know as Watergate might very well not have happened or not continued, at least not into the cover-up phase. Now, let me move on then to two or three other things. The chairman and I joust from time to time about that grand jury appearance. And And at the time the matter first came up, I confess I did not know there was legal precedent for taking proof outside the presence of the grand jury. And that precedent was brought to my attention. So as the chairman properly says, it's not illegal to take depositions and submit them to the grand jury. It then becomes just a matter of judgment, as distinguished from illegality. I still confess I'm surprised at that procedure and that precedent for it exists through the appellate courts. But nevertheless, I believe you've now indicated that in hindsight, and we're blessed with hindsight in this hearing, that in hindsight it might have been better to do it another way. Let me clarify.
That's one of the difficulties of being a prosecutor. You know, you have facts and circumstances at the time, and then in a proceeding such as this, and I think the chairman knows that I'm in hearty approval of these proceedings, or let's say a special prosecutor, they come back in and look over your shoulder and say, now, with all the facts before us, you know, why did you use such bad judgment and did what you did? You know, that's the difficulty of being Henry Petersen or Dick Kleindienst or Earl Silbert, you know, and having your conduct examined.
That's the penalty for being a United States Senator, too, and you look back and say, why did I vote the way I did on a particular measure sometimes? But
I've raised that question in my mind.
Well, I've raised that question in my mind about the Justice Department a few times, so I guess we're about even. But what I'm really going to get into next will be the final preamble to the rather more detailed or rather more philosophical inquiry. I would like to know in greater detail about the conversation Mr. Thompson asked you about with the President about 1 o'clock in the afternoon on April 15th, 1973. By the way, I assume that conversation was taped if it was in the EOB office. Did you know those conversations were being taped?
No. Oh, I did not.
Have you ever asked for a copy of that tape?
Well, I've written a letter to Mr. Wilson, the attorney for Mr. Haldeman and Ehrlichman, making a demand upon them to furnish me copies of any tapes they have in their possession. And I've likewise written a letter to Mr. Garment to request copies of any tapes that they have in their possession between me, Mr. Ehrlichman, and Mr. Haldeman.
Have you had a reply to that?
No, sir, I have not.
Would you like to join us in our lawsuit? No. I withdraw that question, Mr. Could you did refer to notes, rather extensive notes that you took. Are those notes in your possession?
No, sir, they're not, and I've tried to find them for a hard-nosed 50-year-old geezer like myself. I was in kind of a state of shock from April 15th to April 29th, and I don't know what happened to them, Senator Baker.
All right, well, let's try to reconstruct it for a little while. I hope somebody's keeping time on me because I don't want to run over 10 minutes. Rather than go through the detail twice, that is, once when it was told to you and you took notes, and the second time when you told the President, let's talk about what you told the President.
Well, I told him what I had written down on my notes.
All right,
what
was
I took copious notes. Well, it was the summary of the statements made to me primarily by Mr. Silbert of what Mr. Magruder had been telling the prosecutors for a week and what Mr. Dean had been telling for a week. And it was with respect to particular individuals. The primary thrust of it was the efforts made by many to you use the term cover up, you know, and to obstruct the FBI investigation of the Watergate incident during the summer. It described these meetings from Magruder's point of view with Mr. Mitchell, the 3 meetings. Mr. Dean apparently was telling them information and conduct by him that was completely inconsistent with everything that Mr. Dean was telling me from June 17th up until, you know, shortly before April 14th. I don't pretend to remember it all.
Well, there are 2 or 3 important points. Let me try to reduce it to that. The information you received from the prosecutors on the early morning of the 15th of April 1973, essentially was a repeat of the Magruder and Dean testimony before the U.S. attorneys or the grand jury.
That's all it was.
All right. And in that, I assume from the testimony we've received from Magruder and Dean, they were saying, in effect, that they didn't know about it, or let me think now. Dean, I guess, would have said he didn't know about it beforehand and began to suspect afterward and told the president, or rather assumed that the president knew something in September of 1972. I'm thinking the Dean testimony.
To the best of my recollection, the information given me by Mr. Silbert that night and the notes that I took did not in any way implicate the President of the United States.
Did you mention the September meeting?
I can't recall any specific dates, Senator Baker.
If you had to judge, would you say that there was any part of that conversation that said that the President knew or had reason to know of the alleged cover-up prior to March 1973?
Nothing was said to me that night that would implicate the President of the United States, to my recollection.
We have evidence that Mr. Dean talked to the President in March.
Well,
obviously the President knew something. I'm not quite sure what Mr. Dean told the President, but we have his testimony before.
I don't know either. Mr. Petersen, I understand, is going to be called to testify. He's had quite a traumatic experience in this tube. I don't think as intense as mine. He has a very good memory and recollection, and I think I would really rely or be willing to rely more on Henry's recollection of the information that he got before that meeting and what they gave me that night.
All right. Let's go to the meeting with the President then, if we depend on Mr. Petersen to tell us what he told you and elaborate that subject matter further with that witness. I must ask you, Mr. Kleindienst, a little more about the President's reaction. Particularly, did he give the appearance of a man who received information the first time, or one who had some familiarity with the subject?
Well, he gave me the impression of a person who either received it from me the first time or at least contemporaneous. And the reason why I put that qualification on it is as a result of Mr. Ehrlichman's telephone call to me the evening before at 5:30. And I would just, and I'm now speculating that based upon, the proximity of Mr. Ehrlichman to the President, that if Magruder was up there in the White House Saturday afternoon telling them what he'd been telling the U.S. Attorney's Office, I've just got to believe that Mr. Ehrlichman called up the President and said, I've just talked to Magruder and I've got some very interesting information for you. But I know that the President's attitude and response to the information that I gave him was such that it was at least of a contemporaneous knowledge and one of he was just very upset about it, and he was very concerned about it, and he was very hurt by it, and he was very troubled by it.
Did he make any statements that he'd heard this from Dean before or hadn't? Or did he make any statements, this is the first time I ever heard this, or any statements to the effect that I'd wondered about it, but when you tell me, Dick, I believe it? I'm just trying to fantasize.
Not that I recall, Senator, and I was very upset that day. I know John Mitchell is one of the best friends I've ever had. I love him, I admire him, and it just broke my heart that his name was even mentioned in this thing, and the President was spending part of his time to help me with a personal situation. But I do not recall the President saying anything like that.
Well, I guess the summation then of your recollection is that the President gave the impression of receiving the information for the first time or having received much of the information shortly before your meeting with him.
Yes, sir. That's how I would interpret his conduct, what he said, his demeanor, and his attitudes.
And you've requested tapes of the copies of the tapes or the
I have not
opportunity to listen to
requested
those
copies
tapes?
of tapes of meetings that I had with the President of the United States. I have requested copies of tapes with Mr. Ehrlichman and Mr. Haldeman.
I believe I'll yield at this point, Mr. Chairman.
Senator Talmadge.
Mr. Kleindienst, why did you resign as Attorney General of the United States?
Well, it was just a combination of events, Senator Talmadge. I had to recuse myself on the morning of the afternoon of April 15th. I suppose the most pressing, important, significant matter before the Department of Justice as of that day was this Watergate situation, which meant that I, as the Attorney General, could not act as the Attorney General in our most significant matter. Then came the Ellsberg psychiatrist burglary. And then came the situation with respect to Mr. Gray and the documents that he received and subsequently destroyed. By the time those events had unfolded in my life, I really had arrived at the conclusion in my own mind that I could no longer function as the Attorney General of the United States. And here I am back at Burning Tree again, but that weekend prior to April 29th, they had a member golf tournament. And I remember talking to 4 people out there whose judgment I respect a great deal prior to Sunday morning, and told them of my decision. 3 agreed with it and 1 disagreed, the 1 being one of my senators from Arizona. I then had determined my own mind on the following day, Monday, to tell the President that I had to leave the office of Attorney General. It just was an impossible situation for me, Senator. And then around noon of that day, I got a call from the White House. The President wanted to see me. And I remember saying to myself and to them, 2 of these gentlemen, that I'm glad that I'm going to be able to see the President today. I didn't know what he wanted to see me about, and that I'd be able to give him my decision. And then that was the Sunday when he discussed with me the resignation of Mr. Haldeman, Mr. Ehrlichman, and Mr. Dean, and the appointment of Attorney General Richards.
Would it be fair then to summarize your resignation in saying that you had a feeling of unhappiness and frustration about the turn of events?
And then also, Senator Talmadge, you can't, I think from the standpoint of our fellow citizens, maintain an appearance that justice is being evenly and impartially administered when you have a person such as I, who is in the office, even though I recuse myself, and be involved in the investigation and the criminal justice process with respect to men like Mr. Mitchell and Mr. Mardian, and the proximity that I had with them, and have names like Mr. Haldeman and Mr. Ehrlichman and Mr. Dean, Mr. LaRue, and other men with whom I'd had a very close, intimate relationship for some 4.5 years. It just seemed to me that just from the standpoint of the administration of criminal justice in the United States, that Richard Kleindienst should no longer be the Attorney General, and it was the saddest realization I've ever had to make in my life.
There's one other thing I don't understand, Mr. Kleindienst, and Senator Baker touched on it. You indicated in your conversations with the President of the United States, when you informed him of events that you discovered from the Assistant Attorney General of the United States testifying in the grand jury room, an element of surprise by the President of the United States and perhaps a previous lack of knowledge about those events. Yet the President's statement himself that he issued indicated startling new information was discovered on March 21st. Now, your conversation with the President was some 3 weeks subsequent thereto. Yes. Apparently, the President had had previous startling information. Do you have any idea what that was?
No, sir.
Would you testify again that, to the best of your knowledge, and of course you're a skilled lawyer, that the President, at the time he talked with you, indicated no previous knowledge whatever of that subject matter?
Senator, he might have said something to me going back to March 21. I have no recollection of it. And I don't think that I would be a reliable person with respect to precise recollection on the events that occurred on April 15th. I was up all night. I went to bed at 5. I didn't get any sleep. I got up out of bed at 8:30. And I don't think I would trust myself as a precise witness on the events of that day.
There's one other thing you may want to comment on, and this is this famous tape conversation that Ehrlichman made of you. And you quoted in there, is Sirica is really lousing this thing up. What did you mean by that?
I had to call Senator Weicker and Judge Sirica the day after this was made. And the documents that he received and subsequently destroyed. By the time those events had unfolded in my life, I really had arrived at the conclusion in my own mind that I could no longer function as the Attorney General of the United States. And here I am back at Burning Tree again, but that weekend prior to April 29th, they had a member golf tournament. And I remember talking to 4 people out there whose judgment I respect a great deal prior to Sunday morning, and told them of my decision. 3 agreed with it and 1 disagreed, the one being one of my senators from Arizona. I then had determined my own mind on the following day, Monday, to tell the President that I had to leave the office of Attorney General. It just was an impossible situation for me, Senator. And then around noon of that day, I got a call from the White House. The President wanted to see me. And I remember saying to myself and to them, 2 of these gentlemen, that I'm glad that I'm going to be able to see the President today. I didn't know what he wanted to see me about, and then I'd be able to give him my decision. And then that was the Sunday when he discussed with me the resignation of Mr. Haldeman and Mr. Ehrlichman and Mr. Dean and the appointment of Attorney General Richardson.
Would it be fair then to summarize your resignation in saying that you had a feeling of unhappiness and frustration about the turn of events?
And then also, Senator Talmadge, you can't, I think from the standpoint of our fellow citizens, maintain an appearance that justice is being evenly and impartially administered when you have a person such as I who is in the office, even though I recuse myself, and be involved in the investigation and the criminal justice process with respect to men like Mr. Mitchell and Mr. Mardian, and the proximity that I had with them, and have names like Mr. Haldeman and Mr. Ehrlichman and Mr. Dean, Mr. LaRue, and other men with whom I'd had a very close, intimate relationship for some 4.5 years. It just seemed to me that just from the standpoint of the administration of criminal justice in the United States, that Richard Kleindienst should no longer be the Attorney General, and it was the saddest realization I've ever had to make in my life.
There's one other thing I don't understand, Mr. Kleindienst, and Senator Baker touched on it. You indicated in your conversations with the President of the United States, when you informed him of events that you'd discovered from the Assistant Attorney General of the United States testimony in the grand jury room, an element of surprise by the President of the United States and perhaps a previous lack of knowledge about those events. Yet the President's statement himself that he issued indicated startling new information was discovered on March 21st. Now, your conversation with the President was some 3 weeks subsequent thereto. Yes. Apparently, the President had had previous startling information. Do you have any idea what that was?
No, sir.
Would you testify again that, to the best of your knowledge, and of course you're a skilled lawyer, that the President at the time he talked with you indicated no previous knowledge whatever of that subject matter?
Senator, he might have said something to me going back to March 21. I have no recollection of it. And I don't think that I would be a reliable person with respect to precise recollection on the events that occurred on April 15th. I was up all night. I went to bed at 5. I didn't get any sleep. I got up out of bed at 8:30. And I don't think I would trust myself as a precise witness on the events of that day.
There's one other thing you may want to comment on, and this is this famous tape conversation that Ehrlichman made of you. And you quoted in there, is Sirica is really lousing this thing up. What did you mean by that?
I had to call Senator Weicker and Judge Sirica the day after this amazing document hit the streets. Judge Sirica is one of the fine federal judges in the United States. He and I are close personal friends. I have nothing but the highest estimation for him. Also, as a lawyer, Senator Talmadge, I have never publicly ever said a critical or derogatory thing about a judge in my life. What I meant by that statement was that as a result of the sentencing procedures of Judge Sirica, and I think that lawyers could argue, as to the propriety of it, and there's a means by which you test that out in an appeal, not in public statements. It prevented us from getting Liddy, Hunt, and the other 5 back before a grand jury after their conviction and sentencing immediately to interrogate them under immunity to find out what they knew. They did not testify at their own trials. And it's a standard procedure of the Department of Justice, Senator Talmadge, as your prosecutors everywhere. If you have a conspiracy-type situation, when you've convicted a person or persons and they're sentenced, then you bring them back before a grand jury, you put them under oath, and you give them immunity, and then you say, now tell us everything you know. And if they refuse to do so, they can be punished, for contempt. That's what we wanted to do. Judge Sirica, as a result of his sentencing procedures, and I know Judge Sirica believes firmly, because he's a firm believer, that he was doing the right thing. It just didn't suit our purposes at the Department of Justice. We wanted to get at Liddy and Hunt and the rest of them immediately.
Now, one final thing. I believe you testified that you had written Mr. Garment, counsel to the President, requesting a copy of the tapes that Mr. Ehrlichman made of you.
Yes, sir.
In your conversation. Has your view of executive privilege changed since you testified before congressional committees on April the 10th, 1973?
Easy, Mr. Chairman. From the standpoint of the law and the Constitution, my opinions as a lawyer have not changed. And I was rather flattered that Attorney General Richardson, who I think is a much better lawyer than I, came up with essentially the same opinions. From the standpoint of policy, and I never got around to my second round, Senator Talmadge. My first testimony was as a lawyer talking about the Constitution, and then I was prepared the next week to go up there on behalf of the administration and discuss the policy with respect to executive privilege. As a matter of constitutional concept, it's exactly what it was then. From the standpoint of policy, I think executive privilege should be used very sparingly, as it has been throughout history.
You don't believe that evidence of a cover-up of a crime would come under the purview of executive privilege, do you?
Senator Talmadge, if the President of the United States wants to exercise, based upon the doctrine of the separation of powers, a privilege not to give to the judiciary or to the Congress of the United States any document in his possession, I think under the Constitution, that is his constitutional right.
Even if it's evidence of a crime not
Yes,
related in any way whatever to the performance of his duty in office?
Yes, sir. That is my opinion. I said that several months ago.
Didn't you write a memorandum different from that at one time? I thought I had read it on one occasion.
Oh, gee, if I did.
I thought I saw a memorandum that you stated on one occasion, where if the President could prevent a witness from appearing before a committee, that he could protect all of the several million federal employees in the performance of their duty?
Well, the only memorandum I know I wrote was the testimony that I gave before the United States Senate, and that was prepared testimony that I read. I'm not familiar with any other memorandum that I wrote myself, Senator Talmadge, and that document is before the United States Senate, that document and my testimony.
And you would state again that no matter how heinous the crime may be, the evidence of that was in the President's possession, had nothing related, no way related whatever to the performance of a governmental duty, it would still come under the doctrine of executive privilege?
Well, under my understanding of the Constitution and the law, and incidentally, there aren't any cases in this area. I think the last case of the Supreme Court was, I think, around 1830, having to do with a post office contract. There just isn't any legal literature on the subject matter, Senator Talmadge, and the reason why there isn't is that this, throughout the decades, has been a political matter, you know.
So your conclusion is based on a judgment rather than judicial interpretation?
My understanding of an interpretation of the Constitution of the United States, a document that I revere with very much.
I'm certain that you do, but I don't see how a government can function if we take the position that each of the three separate branches of government are a government unto themselves and not subject to the system of checks and balances that must be applied to all.
Yeah. Well, I think as a result of events and circumstances, and when I read the newspaper, that question might soon be answered for us, Senator Talmadge, by the judiciary, you know.
Thank you very much, Mr. Kleindienst. I have no further questions.
Thank you, Senator Talmadge.
Senator Gardner. Mr. Kleindienst, some of the people in the White House who've been before us as witnesses were not too happy about the appointment of this committee. As a matter of fact, they were rather concerned and nervous about it. You had a reaction. What was your reaction?
Well, I think my reaction was this. I think under our Constitution, with its great protections for individuals who are accused of crimes, that first you should prosecute somebody under the law so that they are guaranteed their rights under the Constitution and they can get a fair trial. And I think I'm now an individual, I'm not an officer of the United States government, and many might disagree with my opinion. I think I would have preferred to have permitted the Department of Justice to go ahead and prosecute everybody based upon the evidence. And then I've always said that there is an appropriate forum for the Congress of the United States to publicly go into and examine the conduct of public officials. Now, it's said that the public's right to know is more important than whether or not 2 or 3 people are prosecuted. My personal feeling is that the public's right to know should not be paramount to safeguards specifically inserted in the Constitution of the United States for the protection of an individual. Because the essence of our Constitution is that it seeks to protect individuals and not society, you know. And I guess we could all debate this. But I have never uttered a word in my life that the Congress of the United States or the Senate of the United States should not ever be vigilant and available to examine the conduct of public officials and the exercise of their public trust.
Well, that was my recollection.
Yes, sir.
Setting the timing aside of when we would hear them and when the prosecutors would examine them and prosecute.
Yes, sir.
As I recall, you publicly stated that this was probably a good forum and a healthy thing for the political side of the country to inform the public.
We're consumed now, it seems to me, Senator Gurney, with the negative aspect of Watergate, and very few people, it seems to me, take time to, you know, write about the triumphs, you know, of this situation. The triumphs are many. It proves to us that the institutions of freedom in this country are vital and that they are at work. People say that we don't have freedom of the press. We've got the most free press in the world. Our criminal justice system works. Our judiciary works. The Congress works. And then also out of all of this, and I've been a citizen politician for many years, I think as a result of these tragic revelations, that voluntarily politicians and office holders in this country for decades are going to have imposed upon them a higher standard of conduct than they ever have had before. I don't think any candidate running for any high office in this country is ever again going to want to say, well, you're involved in a Watergate situation. You can't legislate morality. You can't legislate men's hearts. And I think that really the decades ahead for my children, my grandchildren, is going to show and demonstrate a much higher level of conduct in American politics. And that's a great achievement for America.
Well, I couldn't agree with you more. I think you're absolutely right. I think it will have a ventilating and a cleansing effect, and I think politics and government will be the better for it.
Yeah. And some people have despair, but our country is so great and so strong that the idiocy of a few people, can't shake the foundations of this great society and this great democracy.
On that same subject of good and bad, put it that way, I'd like to examine into this FBI thing a little more, because I think the FBI has been a great institution in this country. And
still is.
Still is, and from the evidence and testimony I've heard, I think they did a pretty thorough job, but I'd like to examine one or two little aspects of perhaps why they weren't able to come a little closer to finding out some of the broader implications. For one thing, when FBI people interview, they do it on a voluntary basis, don't they? And they can't swear a witness. They simply go and interview him.
And also, if somebody is a putative defendant, he has the right to take the Fifth Amendment and not talk to
That's right. He doesn't even have to meet with them if he doesn't want to.
And also, if people lie to the FBI, unless you have some evidence brought forth by somebody else, because of our protections of due process, the FBI doesn't get the guy slammed against the wall and crack him between the teeth and say, now tell me the truth. We prohibit that kind of interrogation.
The problem, I guess, was that there was a cover-up. And people weren't advancing information.
I've arrived at that conclusion, Senator Gernon, along with a lot of other
I think that's what we found here in these many weeks.
Yes, sir.
One question on that meeting with the president. I'm not sure that it was covered.
What meeting is that, sir?
This is the April the 15th Sunday meeting.
Yes, sir.
Did the president did he tell you in the meeting what he had been advised previously by John Dean?
No, sir.
That was
not to my recollection.
Not discussed.
No, sir. I was more interested in telling him what I knew and then dealing with the consequences of that knowledge on my part, my own deep feelings, and what to do next. The decision to, my recommendation to have Henry Petersen, act in my place instead, getting Henry. Henry was working on his boat and came in with his first meeting with the president with tennis shoes and a dirty T-shirt. I was very embarrassed. Going back to my department, executing the document by which I recused myself, and then going home.
Your logs show a number of phone calls and meetings during this period of time from the June 17th break-in until, through almost your resignation. Phone calls with Colson, for example. Did those cover Watergate at all?
Never recalled ever talking about Watergate with Mr. Colson.
There are also a number of telephone conversations with Mr. LaRue. Did you ever discuss Watergate with him?
Never.
And also one or two with Haldeman. Did you discuss Watergate with him?
Never.
There were a few phone calls with Mr. Krogh. What were they the subject of?
I think, and that was brought to my attention by Mr. Hare of the committee yesterday, that I had some conversations with Mr. Krogh on Monday, the day before the general election. I think you'll also see on that day there must have been 60 or 70 calls. I had meetings with Mr. Colburn, who was Director of the United States Marshal Service, and and Chief Wilson of the Metropolitan District Police. Those conversations had to be with respect to problems involving demonstrators in anticipation of the election returns the next day. Mr. Crow, one of his assignments was to coordinate on behalf of the White House, the District of Columbia Department of Justice in this situation. Nothing with respect to this situation, Dr. Ellsberg, or anything else. I never heard of the so-called plumbers until it became publicly revealed.
Did the President at any time during all this period of time instruct you to go soft or slow upon this FBI investigation?
Never, at any time.
One thing about these affairs is that some people get brushed with tar when I don't think that's probably a fair thing. I must say, as far as you're concerned, and I think this is a good time to bring it out, that when you departed, you were lumped with Haldeman, Ehrlichman, and Dean. And I thought this was most unfortunate myself, because actually you were not in their class, I guess we might put it that way, in any respect. Do you want to comment on that?
No, the President asked me whether I would consent to have my name mentioned that following night. I did, and I would prefer not to make any other comment about it.
But in any event, your resignation was your own decision, and you were the one who suggested to the President that you resign.
Yes, sir.
Thank you. So,
Senator Inouye.
The taping of conversations is a subject explored by Senator Inouye when we return to the hearings. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Senator Inoue of Hawaii now asks Kleindienst about some taped telephone conversations.
Thank you very much. Mr. Kleindienst.
Yes, sir.
In response to a question relating to the famous conversation you had with Mr. Ehrlichman, which was electronically recorded, I believe you said that you just couldn't find the appropriate words to describe this, but you used two words, that it was reprehensible and unethical. Now, was it reprehensible because Mr. Ehrlichman could make self-serving statements, whereas you, not knowing that this was being recorded, would make statements which
I think my attitude is a little bit more subjective than that, Senator. I have never taped a telephone call in my life. I've never had it transcribed or written down. I think on a couple of occasions since I was in the department, because of an unusual call, I had my secretary make notes on another line, and that was a very unusual situation. But when you are dealing in good faith with people who you regard with trust and confidence, who are with you discharging a mutual obligation and undertaking, in this case on behalf of the President of the United States, to me it's the grossest breach of good faith imaginable for one person to make a tape recording that conversation without telling the other person. And if I had suspected that Mr. Ehrlichman was doing that without telling me, I would never speak to him again.
On April the 15th at about 1 p.m., you've testified that you had a meeting with the President to advise him of the conversation you had at your home early that morning.
Yes, sir.
Where was this meeting held, sir?
In my home?
No, I mean with the President.
Oh, in his office in the Executive Office Building.
Were you aware that this office was electronically wired to
No, sir.
tape your conversation?
No, I don't have the same feeling about the President of the United States.
You didn't consider that reprehensible?
Well, I don't. If I was ever president of the Chamber of Commerce, I wouldn't do it. I'll never be president of the United States. I don't like it. I was surprised to learn of it. I think I was in Europe a couple of weeks ago when I heard of it, and I gave one of my characteristic attitudinal responses. I don't personally like it, but I do distinguish between a president and somebody like Mr. Ehrlichman talking to me, both of us who are working on behalf of the President when our business was for the President of the United States.
Then you had another conversation later that month, at which time you advised the President of the break-in into Dr. Fielding's office. Where was this meeting held?
That was likewise in his office at the Executive Office Building.
And you were not aware that this
No,
conversation was recorded?
I did not know that any conversation that I had with the President of the United States was recorded until a couple of weeks ago when I was in Europe on business.
In July of 1972, you've testified that you received a call from Mr. Ehrlichman relating to Secretary Stanz's appearance before the grand jury. And you've testified that you felt that Mr. Ehrlichman was involved in an act constituting obstruction of justice. I believe you used these three words.
No, it could have been construed as that. I think my attitude then was that Mr. Ehrlichman and I had to feel then he was pressed with burdens that the President or imposed upon him or he imposed upon himself. He had no background or experience in the criminal law. I just thought it was kind of a stupid mistake that he made. And I was more concerned, Senator, to have a very precise, clear understanding with Mr. Ehrlichman that that would not happen again in the future.
Didn't you think this was important enough for your reporting to the President personally?
No. He treated it lightly at the end and said, don't worry about it, it won't happen again. I called the President of the United States very seldom in my 4.5 years in the government. I tried to not impose myself upon him or insinuate myself upon him. I was prepared, however, to request a meeting immediately with the President if Mr. Ehrlichman had persisted in his original attitude that he would feel free to do this. Because I said to John, I said, then I'll come down and we'll meet with the President. And if the President tells me that you'll have that authority, then I will submit my resignation as Attorney General of the United States. It was not necessary for me to have that meeting, Senator.
Mr. Ehrlichman, you've testified that when you first learned about the break-in, I believe from Mr. Petersen,
yes,
Mr. Kleindienst, I'm sorry. Sir.
Yes, sir.
Yeah.
I'm flattered by the mistake, Senator.
You testified that your reaction was one of shock, and you considered...
On the break-in?
Yes.
On Mr. Petersen's call to me? No, because he didn't know much about it at 8 o'clock on Saturday morning, June 17th. The one that shocked me was Mr. Liddy coming out. I recollect saying that Mr. Mitchell told him to come out and fill me in, you know. The thing that shocked me was his fantastic statement that maybe people who were employed by the White House or the campaign committee were involved or were arrested last night. That floored me.
Mr. Liddy was known to you. You worked with him on Operation Intercept. He was a member of the Justice Department, and I'm certainly aware that he was counsel to the committee to re-elect the President.
I did not know that latter, sir. But my association with Mr. Liddy was very minimal and very brief, as I described in 1969, and I don't believe I ever ran into him or ever saw him again until that.
He must have had some standing with you, because I doubt if you would have responded to someone saying, come here, come here.
Well, I knew him, Senator, and Mr. Moore, who did have standing with me, was with him. Mr. Moore and I were directly associated together in the Department of Justice when he was the Deputy Director of our Public Information Office.
Realizing the explosive potential of this break-in, because the break-in involved the headquarters of an opposition political party, didn't you feel it was important enough to directly advise the President of this conversation with Mr. Liddy?
Well, I don't think I would advise the President. The investigation got underway immediately, and it was known within hours or shortly thereafter, days, essentially what Mr. Liddy told me, that is to say, and I think Mr. McCord was identified almost immediately after they got rid of the aliases, and he was further identified as being employed by the campaign committee. That became public knowledge almost immediately thereafter, Senator.
My final question for this round, sir. In July of 1972, Mr. Baldwin, do you recall Mr. Baldwin, who was involved in the break-in?
I know the name, that's all.
Cooperated with the prosecutors and advised them that 2 phones in the headquarters of the party had been bugged, one belonging to Mr. Larry O'Brien and the other to Mr. Spencer Oliver. Were you aware of this, sir?
I don't recollect whether I was or not, whether Mr. Petersen told me that or not.
Well, for some unknown reason, when the FBI went through the complex, the headquarters complex, they just removed one bug, the one in Mr. Larry O'Brien's, and did not remove the one in Mr. Spencer Oliver's. Were you aware of this, sir?
No, sir.
Now, on September the 13th, the Democratic National Committee requested the phone company to sweep that area to have another look at it, and at that time they came across this bug in Mr. Oliver's.
In a phone?
Yes, phone. Were you aware of this, sir?
Oh, gee, I might have been aware of it, Senator. I have no present recollection of it.
And after that, the FBI conducted a very intensive investigation. They interviewed 80 members of the McGovern Campaign Committee and the Democratic National Committee. Weren't the FBI people aware of Mr. Baldwin's advice to the prosecutors that there were two bugs?
I don't know. I think Mr. Petersen might have better knowledge of that, or the FBI itself. I don't know.
I've just been notified that my time is up. I thank you.
Thank you, Senator Noya.
Senator Weicker.
Listen, you didn't take a swing at me, and I'm not going to take a swing at you. No, I wanted to add to Senator Baker's comments earlier, where he cited those instances where you had tried to live up to the spirit of the job which you held, both in what you did and in the way you related to others. I just wanted to add to that list the fact that when importuned to take a swing at the junior senator from Connecticut, you told him you wouldn't do it.
Well, I was trying to talk him out of it, and Senator, I was trying to use vernacular and suggestive language that would be calculated to talk him out of it. And that's why I might have used some language that I did. I'm not trying to ingratiate myself. You and I have had a very warm, friendly relationship, Senator, and I have a high regard for you.
Thank you very much. And I've already expressed myself on that point. Let me get to some facts here which I think might be helpful to our investigation. In the statement of April the 30th, 1973 by the President stated, "As a result, on March 21, I personally assumed the responsibility for coordinating intensive new inquiries into the matter, and I personally ordered those conducting the investigations to get all the facts and to report them directly to me right here in this office." Did you receive such orders from the President of the United States on March the 21st?
I have no recollection of talking to the President about that. I might have, but I don't recollect it, Senator Weicker.
Well, I should think that would be a pretty significant event, as obviously the language of the President in the statement is very strong. Those conducting the investigations to get all the facts, to report them directly to me right here in this office. I imagine if you received such an instruction, it would come to your recall now.
I have no recollection of that.
Now, Mr. Kleindienst, I can't, unfortunately, leave your resignation at the point where you indicated to this committee that you preferred not to comment.
Yeah,
I too, in addition to, I believe it was Senator Gurney, found it rather strange to have you lumped in here in this same statement, I might add, with Messrs. Haldeman, Ehrlichman, Dean. And so I am going to ask you the question as to whether or not this matter was not discussed with the President prior to this April 30th statement, whether or not, and I'll just get them all on the table and let you answer them in your own way, you preferred to announce your own resignation, whether or not the President prevailed upon you not to announce your own resignation, but to be lumped in with this group.
Well, I think the President and I had, by different routes, arrived at about the same conclusion. Obviously we had, because Mr. Richardson was up at Camp David that afternoon And I think the President had made the decision himself that he had to get another Attorney General. I had arrived at it independently. The President discussed specifically with me the fact that he wanted to announce my resignation the next day, and he asked me to permit him to do so. I consented, and I would prefer not to comment further about it. I've had a lot of great things in my life, and I've had some unpleasant things, and that's just all part of life.
I know, Mr. Kleindienst, but I think it is important to this committee to understand exactly what transpired in that instance. Did you want to resign yourself and make your own announcement?
Well, I informed the President when I first got up there that I had arrived at the soulful conclusion that I had to leave. And I think the President rejoined by saying, I think you're right. A couple of months before, our conversation was that he wanted me to be sure and stay past September when I left. I think one of the things he said, I got to have a whole Attorney General. I can't have half an Attorney General. And then came the conversation with respect to the manner in which it was going to be done. He asked me personally if I would permit him to do it then, and he wanted to be able to announce the change in the government and Mr. Richardson's appointment. And I consented to that.
In other words, it was his desire that you be put into this group. It was not your desire.
He asked me to permit him to announce my resignation then, and I consented to it, Senator.
I still have to ask the question, why you were not permitted to go ahead and announce your own resignation?
Because the President asked me to permit him to do it that Monday night.
When you first arrived at Camp David, did you want to announce your own resignation?
Yes, sir, I had, and so informed him before our conversation started.
And so it was at the importuning of the President, you did not announce your own resignation, but rather went along with his request to be put into this group. Is that correct?
Well, he's the President of the United States. I was serving him. He asked me to do it. I did.
I'd like to, if I could, ask a few random questions until my time expires. The sequence insofar as Mr. Gray is concerned, April the 5th, he withdraws his name for consideration before the Senate. Is that correct?
Yes, sir. I believe that's the date, April 5th.
And I believe also at that time you wrote a very warm personal note of appreciation to Pat.
I have the highest regard for Pat Gray. I think he's one of the finest men I've ever known in my life, and I feel very sorry for him.
Now, on April 27th, following the conversations in your office, on the 26th, he steps down.
Yes, sir.
Now, what transpired in the meantime here, or more specifically, at what point did you become aware that apparently both the President and certainly Mr. Ehrlichman and Mr. Dean had come to the conclusion that Pat Gray would not be a man for the directorship of the FBI?
Well, you have to distinguish between, I guess, the events that occurred after April 5th, when it was, I think, indicated sometime around that time, and before April 15th, Mr. Gray's nomination had been withdrawn from the Senate. And then after April 15th and before April 30th, I had a meeting with Mr. Gray and Mr. Petersen in my office in the middle evening around 8 or 8:30, and the next day he then resigned as the acting director of the FBI. I don't know when I learned of the decision that Mr. Gray's name would be withdrawn from the Senate to be the permanent director. I'm sure I would have known about it around the time.
Around what time?
Well, the time that it was withdrawn. His nomination was withdrawn.
You know that we have testimony, Ms. Kleindienst, before this committee that would indicate that both Mr. Ehrlichman and the President had soured on Pat Gray in around March the 6th or March the 7th.
Yeah, I didn't know about that. I know, I guess, as of the time I was out in San Clemente around April 5th, that I must have known that the decision was made because we were talking about my recommendations for a person for the President to nominate to be the next permanent director. So I guess I knew about it prior to April 5th. I don't believe I was informed that day of the decision. I think I probably knew that before.
Now, in testimony yesterday, Mr. Gray indicated to the committee, I think I'm correct in my paraphrase, that when they met in your office on the evening of the 26th, that you advised Mr. Gray that you thought it best that he step down.
Yes, I did, and Pat really didn't agree with that. I called the President, gave him a report of our meeting, what Pat told me. I said, Mr. President, my recommendation is that Pat step down. Pat doesn't feel that way about it. And then my recollection is, Senator, I read Pat's testimony yesterday, but my recollection was that I said, Pat, tomorrow you have a meeting with the top people of the FBI and get their reaction as to whether or not, as a result of this situation, you can credibly serve as the acting director until a permanent director comes along. He seems to recall it that was his own thing. Maybe not, I don't know. In any event, the next morning he did meet with the top people of the FBI, and he called me and said that, and I recall it saying that you're right, you know, the people here do not feel that I can credibly remain as the acting director. And then I recall it, I said, well, Pat, I think that you ought to call the President yourself and submit your resignation to him this morning, and you do that directly. Now, that's my recollection of it.
I have
incidentally,
no
Senator
dispute with that recollection, but may I just ask one question? I don't want to interrupt you, please.
Well, I want to set the record straight on one thing. You recall Mr. Gray had made an offer to the members of the United States Senate that they could have access to the FBI files, and then that order was rescinded. I believe that you were scheduled to go up there on a Saturday morning to see them.
That's correct.
And that I called you personally and said that I had ordered that to be rescinded. No one else was responsible for that decision except myself. I disagreed with the position taken by Mr. Gray in his confirmation hearings, and that I was the one, as the Attorney General of the United States, who rescinded that offer by Mr. Gray. And I think I called you personally, and it wasn't a pleasant task for me to call you personally that I had rescinded it. And I think there was something said yesterday to the effect that somebody else had made that decision. Nobody else did. I made that, and I want to take that responsibility.
The last question, because my time is up. When you called the President, did the President tell you that Pat Gray should step down on the evening of the 26th?
No, I think I gave him my recommendation, and I also, to the best of my ability, reported Pat Gray's position on it. And I think the President then said to me, well, if Pat doesn't want to resign, you know, immediately or right now, I'm not going to require him to do so until we can analyze the matter further or get some additional information. That was the President's posture.
Thank you, Mr. Kleindienst. My time's up.
Senator Montoya.
Mr. Kleindienst.
Yes, sir.
About how many times did you speak to the President between June 17th and the time of your resignation?
How many times?
Yes.
Boy, it would be a guess. The committee has in its possession my telephone logs that would more accurately reflect that. I would say 10 or under times, and that's just a guess, Senator Montoya.
10?
10 or under, and that's a guess on my part.
How many times did you visit with him at the White House during this time?
That's from June 17th, the Watergate situation, Senator?
Yes.
I don't believe, although I could be mistaken, that I visited with him after June 17th at the White House until I returned from Europe after the election, and then I had 2 meetings with him at Camp David.
Were those the only 2 meetings, either at the White House or Camp David?
To the best of my recollection, sir. And I could be wrong, and again, my appointment book or my logs would be the best evidence of that.
Did you, during those meetings or during those telephone conversations, discuss Watergate with the President?
Well, in a very broad way. I didn't know much about it. I was in charge of the investigation. I had confidence in it. I would have indicated to him what I was doing, what the FBI and the criminal division and the prosecutors were doing, generally.
Did you discuss with him the possibility that some members of the White House or the CRP might be involved?
I had no basis for such a discussion. I have no evidence of that, of any credible nature until April 15th, 1973.
Did he ever ask you any questions as to whether, from the evidence or state of the evidence that you had, there might be some involvement by personnel from the White House?
Not that I recall, because Senator Montoya, if I had come into possession of evidence of that kind, I like to think, and I am confident of the fact, that I would have informed him immediately.
Who would the President go to for an investigation of this type? Would he go to the Department of Justice?
Well, the Department of Justice, through the FBI and the U.S. Attorney's Office, had a prodigious investigation interrogating all kinds of people up there. I think by the time on or about March came along, Senator Montoya, instead of 1,700 people being interviewed, the interviews had gone up to 25, 26, or 2,700 people.
Well, who was actually in charge of all this investigation? The Department of Justice?
Yes, sir. The FBI, the Criminal Division, and the U.S. Attorney's Office.
And would that be you as the head of the Department of Justice and those working under you?
Yes, sir.
And do you have any knowledge whether or not the President talked to Mr. Petersen about this investigation at any time?
I am almost positive that Henry Petersen never talked to the President of the United States until Sunday, April 15th, 1973.
Then I will read to you, give your answers, the statements contained in the President's address of April 30th, 1973. Last June 17th, while I was in Florida trying to get a few days' rest after my visit to Moscow, I first learned from the news reports of the Watergate break-in. I was appalled at this senseless, illegal action, and I was shocked to learn that employees of the Re-Election Committee were apparently among those guilty. Here he says, I immediately ordered an investigation by appropriate government authorities. Now, he did not talk to you about this, so apparently the President was wrong in this statement. Well, let me read further. As the investigations went forward, I repeatedly asked those conducting the investigation whether there was any reason to believe that members of my administration were in any way involved. I received repeated assurances that there were not. Then...
May I comment right there, please?
Yes.
I think that is a fair statement for the President to make, because John Dean was over in my office on the Monday, found the break-in and was there quite continuously, and his purpose in being there, according to his representation, was to get general information from me and Mr. Petersen. And I think it would be logical that Mr. Dean was going back and reporting, I thought, to the President. I don't know if he was or not, but at least to Mr. Ehrlichman or Mr. Holland.
Well, he said, I repeatedly asked those conducting the investigation, Mr. Dean was not conducting the investigation.
Well,
then...
right there, Senator Montoya. I don't believe I talked to the President on Saturday, June 17th. I might have, but I know I talked to him sometime immediately thereafter, and my conversation with him and the direction he gave me, he didn't have to say, now, Kleindienst, you know, you've got to go out there and investigate this. I think I understood what my duty was, but there was no doubt in my mind as to what the President wanted to have done in this thing. If he didn't want to have it done, I don't think I would have been there.
Well, why would the President couch his statement in these specific terms?
I don't know.
All right, now, let me read the next
comments that I've made.
Let me read the next paragraph. As a result, on March 21st, I personally assumed the responsibility for coordinating intensive new inquiries into the matter. And I personally ordered those conducting the investigation to get all the facts and to report them directly to me right here in this office. Now, if you state that the President never talked to you about this, and to your knowledge, he did not talk to anyone in the Department of Justice, could it be possible that he was talking to the United States District Attorney downtown?
No, I construe that statement as of March 21, Senator Montoya, to mean that he was having, as I learned subsequently, Mr. Ehrlichman to conduct an in-house investigation. That's based upon what Mr. Ehrlichman told me Saturday evening, April 14. That's what I would assume the investigation was an in-house, non-Department of Justice investigation.
Well, Mr. Ehrlichman testified that there was really no investigation going on his part, and Mr. Dean has also indicated that he was just going around trying to find out what was being done, that's all. But the actual investigation was being conducted by the Department of Justice.
Yeah, we never stopped our investigation. At no time did the Department of Justice ever consider that the Watergate case was closed.
Now, did it ever occur to you that you might visit the President and inform him as to what you might be reading in the newspapers and what curiosity was being aroused in your mind as to possible implication on the part of people at the White House or at the committee to re-elect the President?
I didn't have any reason to do that. There are people up there who read the newspapers and can brief the President on that.
Yes, but you were in charge of the federal investigation, and you were the Attorney General
Senator Montoya,
of the United States.
With God as my witness, not until the night of April 14th or between the hours of 1 and 5 o'clock in the morning in my home on Sunday, April 15th, was I ever given any credible evidence by anybody that would indicate the criminal culpability or complicity of any top White House or campaign people in this entire matter. As soon as I got that information, I immediately set in motion a meeting with the President of the United States.
You were being briefed quite constantly at the Department of Justice about the state of the investigation,
yes,
were you not?
Yes, sir.
And wasn't there any evidence indicating complicity on the part of people at the CRP?
No, sir.
During those briefings, any
No,
evidence brought to your attention?
No, sir. Henry Petersen and I speculated almost constantly, particularly after the trial and Judge Sirica's sentencing procedures, that it was just possible that Gordon Liddy or Mr. Hunt or one of the five, if we could get them before a grand jury, give them immunity and compel them to testify, could have evidence to offer that would involve somebody else. But I remember Henry Petersen saying to me, even after the McCord statement, that standing by itself with just hearsay and speculation and conjecture, that document itself did not provide evidence with respect to the guilt of anybody else.
I'll ask you one more question. When Mr. Ehrlichman was testifying before this committee, I asked him if the White House knew of the burglary of the Ellsberg psychiatrist's office on or about September 4th, why didn't you tell the Department of Justice? And he indicated in his answer that that information had been imparted to the Department of Justice.
That's absolutely untrue.
All right. Now, I have it here in the transcript. I have the transcript.
To my knowledge, that's untrue.
Yeah. Well, I have it here in the transcript, page 555. My questioning starts. Well, there is one thing. This is a question of Mr. Ehrlichman. Well, there is one thing that strikes my fancy, Mr. Ehrlichman, that the burglary was committed on September 3rd or 4th of 1971, that you knew about it a few days later upon your return from Cape Cod, that Mr. Liddy knew, that Mr. Krogh knew, and that presumably other people in the White House knew. Then why did it take them until April 15th, 1973, for the U.S. District Attorney here in the District of Columbia, Mr. Sealbert, to first find out of that burglary and then have to transmit that news to the Department of Justice?
Senator Montoya, the memorandum from Mr. Silbert to Mr. Petersen, dated Monday, April 16th, said that an unidentified source has informed us yesterday, Sunday, April 15th, about this situation. One of the things that Mr. Petersen told me was that that unidentified source in the Silbert memorandum to him was John Dean. And John Dean is the one who told the prosecutors on Sunday evening, April 15th, about the Ellsberg break-in.
I'm not questioning your veracity. I'm just pointing out that perhaps Mr. Ehrlichman deceived this committee with that statement.
I don't want to comment on Mr. Ehrlichman's testimony. All I'm saying to you is that to my knowledge, the knowledge of Earl Silbert and Henry Petersen and the responsible people of the Department of Justice, the first knowledge that we ever had of the break-in of Dr. Ellsberg, psychiatrist, was Sunday evening, April 15th.
Thank you, sir.
Thank you, sir.
I have no further questions. I think you've been rather thoroughly interrogated. I do have two observations, one of which will be no surprise to you, and that is I find myself incapable of accepting the theory that the President has a constitutional power to suppress testimony about criminal acts on the part of members of the executive branch of the government. I can't reconcile that notion with the very simple words of the second article, which say that which prescribe the President's duty in these words: he shall take care that the laws be faithfully executed. Now, my other statement is I would like to, in fairness, state that during the time you were in the Attorney General's office and this committee was in existence, that you manifested a willingness to and desire to cooperate with this committee to the fullest possible extent.
Thank you, sir.
Senator Baker.
Mr. Chairman, thank you very much. I also do not have further questions. I might make, as I have previously, a remark of thanks to Mr. Kleindienst for his cooperation and for his testimony today. I think it's very helpful. And to say one word about the question of the scope and extent of the doctrine of executive privilege, I note with great interest the disagreement between the chairman and the witness on that subject, and they're both distinguished legal authorities. One, a former Attorney General of the United States.
One not as distinguished as the other.
One, a former Attorney General of the United States, and the other, the possessor of one of the original copies of the Constitution. But I might say that my father taught me that you can try to settle a lawsuit all your life, but the court finally decides.
That's why we have courts.
And that's one reason I'm glad we file suit. There may be a great quarrel about whether we have authority to sue or whether the President should or should not have to yield up these tapes under one of the other doctrine or theories that set out the litigation. But finally, unless the court ducks the issue, and I very fervently hope they do not, finally, then, the court will decide, and my distinguished chairman and my distinguished former Attorney General will not have to argue about that because the law will be what the court says
Right.
it is.
On the doctrine of separation of powers, that's going to be decided by the judiciary and not by the Senate or by the executive office.
It's like the young lawyer I mentioned earlier who was arguing a case before the Supreme Court. The Chief Justice said, "Young man, that's not the law." And the young fellow says, "Well, it was the law until Your Honor spoke."
I guess that's right.
Thank you, sir.
Senator Talmadge. Senator on our way.
Thank you. I just have a few questions. Mr. Kleindienst, you're aware that Mr. Ehrlichman met with Judge Byrne while the judge was presiding over the Ellsberg case.
I learned that, yes, sir.
Did you think that this was highly improper?
Boy, I know that I, as the Attorney General of the United States, and as an officer, dated Monday, April 16th, said that an unidentified source has informed us yesterday, Sunday, April 15th, about this situation. One of the things that Mr. Petersen told me was that that unidentified source in the Silbert memorandum to him was John Dean. And John Dean is the one who told the prosecutors on Sunday evening, April 15th, about the Ellsberg
I'm not questioning your veracity. I'm just pointing out that perhaps Mr. Ehrlichman deceived this committee with that statement.
I don't want to comment on Mr. Ehrlichman's testimony. All I'm saying to you is that to my knowledge, the knowledge of Earl Silbert and Henry Petersen and the responsible people of the Department of Justice, the first knowledge that we ever had of the break-in of Dr. Ellsberg, psychiatrist, was Sunday evening, April 15th.
Thank you, sir.
Thank you, sir.
I have no further questions. I think you've been rather thoroughly interrogated. I do have two observations, one of which will be no surprise to you, and that is I find myself incapable of accepting the theory that the President has a constitutional power to suppress testimony about criminal acts on the part of members of the executive branch of the government. I can't reconcile that notion with the very simple words of the second article, which say that which prescribe the President's duty in these words: "He shall take care that the laws be faithfully executed." Now, my other statement is I would like to, in fairness, state that during the time you were in the Attorney General's office and this committee was in existence, that you manifested a willingness to and desire to cooperate with this committee to the fullest possible extent. Thank you, sir. Senator Baker.
Mr. Chairman, thank you very much. I also do not have further questions. I might make, as I have previously, a remark of thanks to Mr. Kleindienst for his cooperation and for his testimony today. I think it's very helpful. And to say one word about the question of the scope and extent of the doctrine of executive privilege, I note with great interest the disagreement between the chairman and the witness on that subject, and they're both distinguished legal authorities. One, a former Attorney General of the United States.
One not as distinguished as the other.
One, a former Attorney General of the United States, and and the other the possessor of one of the original copies of the Constitution. But I might say that my father taught me that you can try to settle a lawsuit all your life, but the court finally decides.
That's why we have courts.
And that's one reason I'm glad we file suit. There may be a great quarrel about whether we have authority to sue or whether the president should or should not have to yield up these tapes under one of the other doctrine or theories that set out the litigation. But finally, unless the court ducks the issue, and I very fervently hope they do not, finally then the court will decide, and my distinguished chairman and my distinguished former Attorney General will not have to argue about that, because the law will be what the court says
Right.
it is.
On the doctrine of separation of powers, that's going to be decided by the judiciary and not by the Senate or by the executive office.
It's like the young lawyer I mentioned earlier who was arguing a case before the Supreme Court. The Chief Justice said, "Young man, that's not the law." And the young fellow says, "Well, it was the law until Your Honor spoke."
I guess that's right.
Thank you.
Senator Talmadge. Senator on our way.
Thank you. I just have a few questions. Mr. Kleindienst, you're aware that Mr. Ehrlichman met with Judge Byrne while the judge was presiding over the Ellsberg case.
I learned that, yes, sir.
Did you think that this was highly improper?
Boy, I know that I, as the Attorney General of the United States, and as an officer of the Department of Justice that had a case before Judge Byrne, it would have been highly improper for us to have done it, and to have done it only through our prosecutor in the presence of the attorneys on the other side, regardless of what the situation was. Whether or not the same restrictions would apply to a person on behalf of the President of the United States, I'm doubtful, Senator Noyu, in all fairness to Mr. Ehrlichman, because the mission was very limited and very specific. It had nothing to do with the case. I think just generally speaking, because of the nature of the Ellsberg trial and the involvement of the administration and the Department of Justice and its controversy, it was, in my opinion, probably ill-advised, just because from the appearance, of the administration of justice. My knowledge of Judge Byrne, however, is such that I can't imagine a circumstance existing under which he would ever permit himself to be compromised or in any way interfere with the administration of his duty as a federal judge.
Was it highly improper to involve the President of the United States? Testimony shows that the President was brought into the conversation, even briefly.
I understand that the President just walked out and said hello and went back, and all I know about it is what occurred here in this hearing, Senator Noyu.
Canon 9 says a lawyer should avoid even the appearance of professional impropriety. A lawyer should promote public confidence in our system and in the legal profession. You don't think that this...
Well, Senator, I don't know, and I'm trying to be fair about this, I don't know whether what Mr. Ehrlichman did was as a lawyer, as an officer of the court. He wasn't representing the United States in that thing. He had nothing to do with the trial. I think I would prefer to characterize Mr. Ehrlichman's role there as an agent of the President of the United States pursuing an objective of the executive branch of the government. And I don't know if that canon would be applied to him in that situation.
In the hierarchy of the Justice Department, are you considered superior to Mr. Al Patrick Gray, the director of the FBI, Mr. Gray?
Well, I don't consider myself superior to anybody. I think Mr. Gray was under the authority and jurisdiction of the office of the Attorney General.
Were you in a position to direct him or to give him orders?
I believe so, and I have done so from time to time.
And did he have a responsibility to report to you, sir?
Oh, sure. But he also had responsibilities to discharge. I had nothing but the utmost confidence and trust in him. The department is a big one. It's got 50,000 employees, 17 divisions. I met with Pat Gray quite frequently. He attended our staff luncheon every Friday noon, and he also was a close friend of mine, Senator. He was going to be the Deputy Attorney General, and if and when I got confirmed as the Attorney General, then Director Hoover passed away, and I was in the forefront of those recommending Mr. Gray to be the permanent director and to succeed Mr. Hoover. So I've had nothing but the closest, finest relationship with Pat Gray, and he and I, well, we're kind of both stubborn people, but we never had a problem between us, and it was never a question of my ordering Pat Gray. We had a discussion, and I would make a recommendation, and I can't ever recall a recommendation in the discharge of his official duties of mine that he didn't follow.
Did Mr. Gray ever tell you about the instructions he received from Mr. Dean and Ehrlichman to destroy classified papers?
Yes, he did. He told me that on the evening of April 25th, the night before he withdrew as the acting director of the FBI.
He didn't tell you in the year 1972?
No, sir. That's the first time I had ever heard of that situation, was that night, Senator.
Do you think he should have told you as soon as he received those instructions?
Gosh, Pat Gray has lived a great life, a great patriot, and I think he made one mistake. I think it's going to burden him the rest of his life. Sure, he didn't, and that's an incident, and I would put that against his career of service and what I know about him as a man, and just say, well, here's a human being that made a mistake.
Were you aware, Mr. Kleindienst, of the attempt made by Mr. Dean to influence FBI investigations of Mr. Ogario and Mr.
No,
Dahlberg?
sir.
When did you learn of this, sir?
Well, most of that testimony vividly came to my attention. That's the CIA situation.
This is when Mr. Dean told Mr. Gray to stop the investigation on Mr. Ogario and Mr. Dahlberg. Mr. Dahlberg, as you know...
Senator Inouye, I might have been informed of that last summer, but I have no specific recollection of it. Mr. Petersen would have been the one who would have known about that if he thought there was a serious interference with the orderly work of the department. I know that Henry would have come to me, and I think I have an idea of what I might have said to John Dean. Inasmuch as that kind of an incident didn't occur, I don't think that I knew about it or it was regarded as a serious interference with our work.
As Attorney General, did you know a Mr. Ken Kachigian?
Ken?
K-A-C-H-I-G-I-A-N.
Not that I don't believe so, Senator.
Mr. Haldeman had, in his testimony, said that Mr. Kachigian had prepared a report which indicated that demonstrations and other violent activities were carried out under the guidance of agents of the opposition party. Were you aware of that?
No. I was, for 4.5 years, responsible for the coordination of the efforts of the executive branch of the government regulating demonstrations and dissent, and probably had more information about it than anybody in the United States. I have never heard of that name, and I don't recall ever talking to Mr. Haldeman about it or ever getting a memorandum or a report from him.
As the person in charge of this investigation, were you aware of any involvement of the Democratic Party or the candidates, Mr. McGovern, Mr. Jackson, Mr. Humphrey,
Oh,
Mr.
I think
Muskie?
the only incident that I was ever aware of, there was the president during the campaign was to make an appearance in Los Angeles. And the reason why I became aware of it, I was out there speaking myself. As a matter of fact, I had a speech canceled because the president was going to be there. And I think in the McGovern headquarters in Los Angeles was used by some to organize a demonstration against the president's appearance in Los Angeles. I think that's the only incident that I was aware of.
Was this a violent demonstration involving...
I don't know. I think that there was quite a lot of preparations made, and I think that the president had to change his plan and arrive at the hotel by a helicopter as compared to what otherwise he wanted to do.
Other than that, you're not aware of any involvement?
I received no report of any arrests or anything like that, Senator Noyer.
I thank you very much, sir.
Thank you, sir.
Senator Garney.
I have no further questions, Mr. Chairman.
Senator Montoya.
I have no further questions, Mr. Chairman.
Senator Wyckoff.
Just two brief questions on the Ellsberg matter. When you notified the president of the break-in at Dr. Fielding's office, did he exhibit surprise at the information you gave to him?
Well, I know he was very provoked, Senator Weicker. I think we could have had a contest on which one of us, was the most irritated by it. I don't know whether I could testify whether he had had any prior knowledge of it. And it was not my habit to interrogate the President of the United States.
But did you have prior knowledge of the fact that since the inception of the Ellsberg matter that the President had taken a rather personal role in that?
No, sir. I never heard about the plumbers or...
I'm not talking about the plumbers. I'm talking
About the Ellsberg break-in?
No, not the Ellsberg break-in. The Ellsberg matter.
Oh, the lawsuit?
The entire matter, the lawsuit, from the matter from its inception.
I don't know. I might have discussed briefly with the President about the Ellsberg suit. I know I would have talked to Mr. Ehrlichman about, our position on the suit and our desire to do everything possible to convict Mr. Ellsberg of the crimes that we alleged in our complaint. But I never had anybody interfere with me in that.
I'm not talking about interference. I don't mean to give that impression.
I didn't need anybody to put me down the road on that lawsuit, and I don't recall having any conversation with the President about it.
Do you recall receiving a call from the President requesting a progress report on the Ellsberg case and getting in touch with Mr. Mardian and then getting in touch with the President at Camp David?
Could have, but I don't recall that.
Now, do you think the President's surprise or his being provoked, I guess is the exact term that you used, at the information that you gave to him, do you think it was because the information was public or because of what had happened?
Oh, well, it's the manner in which he characterized the act itself left it unmistakably clear to me that he had a very negative attitude about that conduct.
I have no further. Yes, just one comment I'd like to make, Mr. Chairman, because it was something that Mr. Kleindienst said, which I couldn't have agreed with more. I find it a little hard to reconcile with your definition of separation of powers, but I noted in your comments on our democracy how you stated that the emphasis of our democracy is to protect individuals rather than society.
To me, that's the foundation of our government and our Constitution.
I think it is, too.
And distinguishes it from almost every other government in the world.
I think it is, too, that the individual is important. Each one of us.
Each one of us.
Is important. Far more important than society, and certainly there are none of us that are better than anyone else, if you will. And yet it seems to me that some of the things that went on in this period of time were done in the name of society, with the protection of the individual, sometimes being disregarded to a certain extent. And I wonder how you, for example, in this latest exchange here with the committee, equate this deep feeling that you have, and I feel exactly as you do on this point, with the fact that, in fact, if the President has information which could involve the, let's say, freedom of someone, such as the tapes might relate to the freedom of a particular individual, never mind the constitutional confrontation between the committee and the executive branch of government, but information that might relate to the freedom of a particular individual, that he wouldn't be obliged under the Sixth Amendment of the Constitution to hand that information over. How do you relate those two?
I'm just a private individual now, Senator, and I haven't thought about my attitudes on that, and I would like to be excused from doing so right now.
I have no further questions, Mr. Chairman.
Mr. Chairman, I've got to say I thought there for a minute that the witness was going to say he's just a country lawyer.
Well, as a matter of fact, that's all I am, Senator.
Mr. Kleindienst, do you recall an October 24th, 1972 meeting with Richard Helms at which certain records of the CIA were turned over to you?
Yes, sir, I do.
And what did you do with those records?
The day before, I believe, Ambassador Helms called me and said that Silbert had requested the CIA to supply some written information to it. He said, I have no objection to giving that to the United States Attorney's Office. However, I would like to deliver it to you personally so that you could pass the admonition to the U.S. Attorney's Office that some of the material could be, if it was revealed, could interfere with the mission of the CIA. He agreed to come into my office the next day. He came in with his general counsel. He had an envelope in his hand. As soon as he got there, I called Henry. Henry came up. I explained the situation to Henry. Henry took the envelope and left to go to his office with Mr. Houston, the general counsel of the CIA. Ambassador Helms, who he and I have a very warm, friendly relationship, stayed for a couple of minutes and chatted, and he left. And that's all I know about the incident.
Now, your records show a few contacts in early 1973 with Jeb Magruder. Do you recall what those were about?
Yes, sir. He was working for the inauguration committee. I intended to host at my home during the inauguration a party for everybody who was here from Arizona. And I was talking to Magruder throughout that period of time to get assistance and help from him to make that possible.
Do you recall attending a luncheon with Mr. Ehrlichman and Mr. Dean between the time of the conviction of the Watergate defendants and the time of their sentence at which the subject of possible leniency for the defendants came up?
I didn't when I talked to you or Mr. Harry yesterday. I talked to Mr. Petersen yesterday to see if he could recall anything. And I now remember that at a lunch that I had there, I think we had several matters to discuss. The question came up as to the procedures of sentencing. What happens? And Mr. Ehrlichman didn't have much of a knowledge of the criminal justice system. And I think they were just talking about what happens when somebody is convicted of a crime, how the sentences meted out, what is the probation report, what happens when you go to jail, when are you eligible for a pardon, when do the circumstances arise for executive pardon, and it was a technical procedural discussion that I had. No individual's name was mentioned at that time.
When Mr. Petersen came to you on the early morning hours of April 15th, I believe you indicated that no information was imparted to you that Dean could implicate the President of the United States. Is that correct?
That is correct.
Was there any explanation given as to whether Mr. Dean was holding back things or relying on executive privilege or anything of that nature?
I think that Mr. Silbert, to the extent that at least I believed at the time, that he gave me in summary form every bit of relevant information that he had obtained from Mr. Magruder and Mr. Dean. I believe that at the time.
When did you first learn that Patrick Gray had burned the Hunt file?
The night before he left the Federal Bureau of Investigation.
During the time you were Deputy Attorney General, were you aware of the nature of the political activity by Mr. Mitchell, including specifically any contacts he may have had with Mr. Liddy?
I was never aware he had any contact with Mr. Liddy. My custom when I was the Deputy Attorney General was to meet Mr. Mitchell at 9 o'clock and at 5 o'clock every day when we were both in town. Immediately prior to March 1, when Mr. Mitchell left, I recollect once or twice seeing Mr. Magruder in his office when I came up from my 5 o'clock meeting. When I arrived, Mr. Magruder would leave and I would have my 5 o'clock conference. And that's just about the extent of my knowledge with respect to Mr. Mitchell's association.
One final question, Mr. Kleindienst. While you were Attorney General, did you engage in any partisan political activity?
With the exception of one occasion after I was confirmed by the United States Senate and I went back to Phoenix, Arizona, when the Trunk and Tusk Club gave a dinner in my honor, and that's a Republican club, I have never attended a political meeting, a Republican Party meeting of any kind since I entered the Department of Justice on January 29, 1969.
I have no further questions, Mr. Chairman.
On behalf of the committee, I want to thank you for your cooperation and for your appearance here today. And as far as I know, you're excused from further attendance on the committee unless we notify you again.
Thank you, Senator. Thank you, gentlemen, for your courtesy.
The committee will stand in recess until 2 o'clock.
After the lunch recess, a new witness, Assistant Attorney General Henry Petersen, comes before the committee, and we'll have that testimony in just a moment. In the meantime, public television's coverage of the Senate Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Back from lunch, the senators now begin questioning Assistant Attorney General Henry Petersen.
Committee will come to order. Counsel will call the first witness.
Mr. Henry E. Petersen.
Mr. Petersen, will you stand and raise your right hand? Do you swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, but helps you God?
I do, sir.
You might state your name and occupation and residence for the record.
My name is Henry E. Petersen. I'm Assistant Attorney General of the Criminal Division, United States Department of Justice. I reside at 916 Daleview Drive, Silver Spring, Maryland.
Counsel will interrogate the witness.
Mr. Petersen, how long have you been Assistant Attorney General in charge of the Criminal Division, Chief of the Criminal Division?
January of 72, I believe.
And prior to that appointment, Mr. Petersen, what position did you hold in the Department of Justice?
Immediately prior to that, I was acting Assistant Attorney General for the period October 71 to January 72. Prior to that, Mr. Dash, I was Deputy Assistant Attorney General in the Criminal Division.
And when actually did you first join the Department of Justice Criminal Division?
I first joined the Department of Justice in 1947. I joined the Criminal Division in, I think it was June 1951.
Now, Mr. Petersen, how and when did you first learn of the break-in of the Democratic National Committee headquarters at the Watergate on June 17, 1972?
Approximately 8, 9 o'clock in the morning, while I was at the breakfast table, I received a call from United States Attorney Harold Titus of the District of Columbia, who advised me that 5 people, whose identities even at that point were somewhat in doubt, have been arrested at Democratic National Headquarters in possession of what was considered to be at that time explosive equipment.
Did you follow up on this call?
At that point, I called the Attorney General at his home and told him about it, primarily because I didn't know what the security arrangements were at the Republican National Committee or Committee to re-elect the President or whatever political office they had. And if indeed persons had intentions of trying to demolish the Democratic headquarters, I thought the same might be in offing for Republican headquarters, and I thought he ought to be forewarned.
Well, how soon did an investigation under the sponsorship of the Department of Justice begin in this case?
The investigation was underway at that time. Mr. Titus' staff has already been alerted, and he had assistants working on the matter at that point with the Metropolitan Police Department and the FBI, who were just coming into it.
Now, what role as Chief of the Criminal Division did you play with regard to the United States Attorney's Office investigation?
A general supervisory role, Mr. Dash. One of the early questions I had to decide was the degree of supervision that should be involved. And since we knew at the close of Saturday, June 17th, that what we had thought to be explosive devices was electronics, listening devices, and that an individual named E. Howard Hunt was possibly implicated as a result of the fact that some of his checks or some of information relating to him had been found at the scene, that there were immense political repercussions possible. And I decided at a very early stage that that investigation ought to be as isolated from the political element as it could possibly be. And I suggested that Mr. Titus appoint his principal assistant, Earl Silver, to conduct the investigation in his office and report to Mr. Titus and to myself on a daily basis, oral reports on a daily basis.
What was your relationship with the Federal Bureau of Investigation during the investigation? Did you get any kind of reporting from the FBI?
Well, the FBI, of course, reported. Their reports to the prosecutors, Mr. Silbert and company, were more immediate than their reports to me. Their reports to me had to wait the normal process of the bureaucracy, the preparation of the reports and the submission through normal channels, whereas the prosecutor on the scene was getting the witness statements almost immediately. But the reports were coming over to me rather slowly at first, very slowly. As a matter of fact, when the publicity developed with respect to Baldwin's cooperation, I still did not have Baldwin's statement in my office. I had to call the Bureau and ask them to send it over. They sent a whole package of reports at that time.
Now, was this slow reporting to you, or did the prosecutors, the United States Attorney's Office, have that report?
Well, they had the 302, yes. It was just
just how it came up to your office
yes,
as chief of the criminal division.
That's correct. I was hearing about it from Mr. Silbert.
Now, shortly after the break-in, do you recall receiving a telephone call from Mr. Kleindienst, who was at the Burning Tree Country Club?
Mr. Kleindienst and I communicated 3 times on Saturday, June 17th. The first call I placed approximately 8 o'clock in the morning. The second call I was about to place when, indeed, if I had not heard his testimony or had discussed it with him, I would have said I placed the second call, but he tells me he did. But in any event, since I don't recall it, I'm sure he's true. I placed the third call. The third call I communicated to him, and he was making a speech at the Statler Hilton Hotel, and I had to run him down through the security services down there, and we had to speak very guardedly. And what I was trying to import to him was that documentation relating to a White House consultant had been found at the scene. And I thought it was important that he have that information.
Well, did he tell you about a meeting he had, or an encounter really, at the Burning Tree Country Club with Mr. Liddy shortly after the break-in?
Yes, recently. The second call, whether I made it or he made it, I remember predominantly because he said, Henry, I want these people treated the same as everybody else. I conveyed to him at that point the information about the electronics equipment. And I guess I thought it a little odd that he should make that statement because I didn't know how any other way to treat them. But I don't recall him telling me that Liddy was there. If he did, I simply don't remember it.
Now, what were your relationships with Mr. John Dean at the White House during this period of time?
Good, good. John Dean, I guess, was kind of an unofficial liaison with the Justice Department since he had been there, and we knew him. He had worked in the Deputy Attorney General's office. He was in communication with us frequently with respect to interpretations of the Corrupt Practices Act. So we had frequent dealings. Relationships were good.
Well, did he inform you that he was in charge in any way, or the liaison between the White House and any investigation
Not
going on?
Not at that stage, Mr. Dash. I suppose the practice of discussing this matter with John Dean arose at the first instance out of the request of Mr. Silbert and the FBI, or rather out of their complaints that the White House was dragging its feet at
you know about when this took place?
This was early in the investigation. People were to be interviewed and appointments were not being kept or they were being delayed or what have you, and they would call upon me to expedite them, and I would call John Dean, and I have to say that whenever I called him, he was frankly helpful.
Now, do you recall a meeting on or about June 20, 1972, in Mr. Kleindienst's office where Mr. Dean was, and which Mr. Dean made some statements to you, according to his testimony, that this investigation could go very high, in fact, might involve the White House. It didn't. In fact, he testified he didn't know how far it might go.
Well, I remember the circumstance. I don't remember it as Mr. Dean testified to it. I was called up to Mr. Kleindienst's office. Mr. Dean was already there. They asked for a status report, and I gave them a general status report of the nature of the investigation. We had some discussion. I think commonplace discussion. My God, what's happened? Who's doing this? And what type of a situation is this? And I told him, and I remember the words very distinctly, I said, John, I don't know who I'm talking about, but whoever is responsible for this is a damned idiot. And there's only one thing that the President of the United States can do, and that's cut his losses. And the way that he should do that is to instruct the Attorney General publicly to run an all-out investigation and let the devil take the hindmost. And that ought to be done immediately. We had some discussion of that. And finally, Dean said, well, the President's out in San Clemente. I said, well, it's important enough for somebody to go out there And Mr. Kleindienst said, John, set that up. Dean then got up to leave, and we had some conversations about the investigations. And I told him I had no intention of conducting a fishing expedition, but we were certainly going to conduct a thorough investigation of this matter. Later on, I asked him what had been decided, and he said, yes, somebody's going to go out, but it's been decided that it should be me. And
meaning Mr. Dean?
Mr. Dean, rather than Mr. Kleindienst, which I thought was a little awkward, but quite honestly, I took it as another indication, or as an indication that perhaps the Attorney General, who I think most highly of, was perhaps not in the best graces at the White House, and that they'd rather have Mr. Dean brief the President. Well, after that, there was an all-consuming silence. I never heard anything, and I finally asked Dean about it, and he said, oh, yes, you're to run an all-out investigation, but unfortunately, we never heard anything from the President. If I can jump ahead, in my later conversations with the President on April 15th, I told him this. And he said, one, Dean had never come to him. I said, well, if it occurred again, and I certainly hoped it didn't, I'd be up there knocking on the door myself.
Well, do you recall, let me just read the portion of the testimony that Mr. Dean gave us on page 2179 of the transcript, and which he indicates that Mr. Kleindienst had another meeting while you were up there, Mr. Kleindienst's office, and that you and he went to Mr. Kleindienst's back office. And he says, to the best of my recollection, we did not discuss specifics. Rather, it was a general discussion. I told him I had no, meaning you, Mr. Petersen, I had no idea where this thing might end, but I told him I did not think the White House could withstand a wide-open investigation. Do you recall him saying that?
Do I recall him saying that?
Yes, to you.
No, I do not. I do recall some discussion. Some concern about, this ought not to be an excuse in a political year to run a general probe of the White House. I had no problem agreeing with that. I certainly didn't conceive the occurrence as a specific crime, as an excuse for me to run a general investigation of the White House and all its activities. And I assured him there'd be no fishing expedition so far as White House activities were concerned in this investigation, but that we would run a thorough investigation of burglary.
Now, Mr. Petersen, do you recall having any conversation with Acting Director of the FBI, Gray, over giving Mr. Dean investigative reports such as 302 files?
Conversation with Mr. Gray?
With Mr. Gray.
I had no conversation with Mr. Gray about investigative reports until sometime after April 15th, when we discussed
No, I'm addressing myself now to the time while the investigation was focusing on the White House staff and also on the Committee for the Re-election of the President.
Absolutely not. Now, I can't elaborate on that. I don't want to anticipate your question.
Well, I guess the next question is, did Mr. Dean ever ask you for permission to have 302 files, raw files of the FBI?
No, sir.
Well, did it ever come to your attention that such raw files were being used by Mr. Dean, that he had them in his possession during any inquiry that he was making?
No, sir. Mr. Kleindienst called me at one stage, and I recall the incident very vividly. It was on telephone, and he said, I've just spoken to John Dean, and he has asked if he can have the FBI reports. And I answered him very quickly and very abruptly and said, well, tell him no. And I was so abrupt that he just started to laugh. The reaction was, well, you're a big help. And I then was a little embarrassed to think that he might feel that I was inconsiderate of his relationships with the President of the White House. And I said, well, now, hear me out. If the President calls you up and says, I want those reports, you click your heels and say, yes, sir. Or if they want to send down a memorandum and say, from the President, and say, send those reports over to X, Y, or Z, I said, we can do that, but we ought not to give those reports on an oral request to any White House staffer. And he said, I think I agree with that. That's the last I heard of it.
What was the basis, Mr. Petersen, of your decision to safeguard these reports?
Prudence. Prudence. I didn't think there was I had no suspicion of John Dean as such. Indeed, on April 15th, when I heard by his own admission that he was involved, I was the most surprised person in Washington, I guess, Well, it was simply prudence. I didn't think, and when Mr. Hunt, who had worked over there, was involved, and where there was so much opportunity for cynicism, that prudence dictated that we should make those reports available. I thought that Mr. Dean, if he was, as I understood, charged by the President to keep abreast of this situation, was entitled to ultimate facts, but I didn't think he needed evidentiary fact.
Were you aware of any practice in the past of providing the 302 or raw FBI files to White House staff persons on request?
No, sir, I was not.
So that this would be an unusual request so far as you were concerned?
Would be an unusual request so far as I was concerned. But I have to add, Mr. Dash, that the best witness on that would have to be somebody from the FBI, because I would suspect that that request would go directly to them in many instances.
Well, let me ask you about that. If the request went specifically to the FBI, would the director of the FBI or the acting director of the FBI be under an obligation to check with the Attorney General before he acceded to such request?
Well, like in all things, I think maybe sometime, I don't want to sound like a lawyer, which I am, sometimes yes and sometimes no. If it were, for example, a background investigation of Henry Petersen, who were a White House appointment, and they wanted to see them, I'm sure they'd be just happy to carry them over there. But if it were an investigation of somebody who was closely tied in with some suspected wrongdoing, I think again, prudence would dictate that they go to the Attorney General.
And if it involved actually sending over a large number of 302s involving the investigation of the FBI while questions were being asked of staff members of the Committee for the Re-election of President, what would your thinking be?
Well, again, I think that's imprudent. You know, it's very hard to say, well, you can't have that. We suspect you of wrongdoing to another government official. You don't do that. At least I do not. But nonetheless, I would think that, well, in your position, it might be wise for you not to have these reports to prevent embarrassing questions from being asked.
Well, I think we may have had some description of this in the past, but perhaps you can add this to the record. Exactly what is included in a 302 file?
The statement of a witness.
And is it an evaluated report?
No, sir. It's a statement of the witness as given to the FBI agent.
And that might include just anything the witness might say, which might be based on rumor or gossip or anything.
That's right. That's right.
Now, by the way, during this period of time, actually early in the investigation, were you aware of any restrictions on the investigation placed by the President concerning national security or CIA involvement or the internal investigative unit at the White House?
Well, I suppose I have to answer that no. I had some discussions with Mr. Gray concerning the potential of CIA involvement. And one such discussion was on July 5th, and he had come to my office to discuss the matter. And he had some prior communications with the CIA personnel, and he indicated that there was some, he had been led to believe that there was some CIA involvement. And I said, Pat, you can't accept that. At least you can't accept that orally. You better get that in writing. And if you accept it, I'm not going to be bound by it, because I just don't believe that. It's too convenient. And he agreed with that. But that was the only, he came back later and said, well, that there apparently was no CIA involvement. But well, I had no other communications with
Well, the President, in his statement of May 22, did state that he asked Mr. Haldeman and Mr. Ehrlichman to restrict the investigation so as not to reveal national security matters or CIA involvement. Did Mr. Haldeman and Mr. Ehrlichman get in touch with you as Chief of the Criminal Division and tell you or convey that instruction of the President to you?
No, sir.
Now, were you aware, by the way, that there were of the meetings that Mr. Walters had with Mr. Gray concerning the question of CIA involvement? On June 23rd, and some later meetings that Mr. Dean had with Mr. Walters concerning this.
I was not aware at all of the Dean meetings until the recent disclosures. I was aware that Mr. Gray was in touch with Mr. Walters to try and determine whether or not there was any CIA involvement in connection with the Mexican transactions.
And he later reported to you that he had learned there was no CIA involvement.
That's right.
Now, did you ever discuss with Mr.
Dash, I guess I ought to qualify that. I think that's in the record that there is some CIA assistance with respect to E. Howard Hunt, and there may have been, but on the direct question with respect to the Mexican transactions, no.
Yes, and Mr. Petersen, I'm confining these questions now to the very early period within actually a week or so after the break-in. I think the testimony before the committee is that Mr. Helms spoke to Mr. Gray on June 22nd and said there was no CIA involvement, and the meetings between Mr. Haldeman, Mr. Ehrlichman, Mr. Ambassador Helms, and Mr. Walters was on June 23rd. And then shortly afterwards, as a fact on the same day, on June 23rd, that General Walters spoke to Mr. Gray. It's in that area, that time period, that I'm directing my question.
I have no such instructions, sir.
Now, did you ever discuss with Mr. Dean, Mr. Magruder's appearance before the grand jury?
Yeah, John Dean called me at the time of Magruder's appearance before the grand jury and asked how Magruder made out. I didn't know. And I called Earl Silbert, and he said, well, you know, as you all know, he was up here as a very articulate young man, and he described him as such and said he's a good witness in his own behalf, but Henry, nobody believes the story about the money. And, you know, that's, in those words are what I told
Now,
Mr. Dean.
did you know what that was all about, what they were talking about?
Well, we were focusing on the money, Mr. Dash. You know, we couldn't, maybe it's a poor boy syndrome, but we couldn't imagine how $350,000 was just tossed out and nobody wants to know where it went or what it was used for. And, of course, the grand jury didn't, well, the poor boy syndrome, too, I guess. They couldn't understand that either.
Were you aware of the fact that Mr. Sloan told the prosecutors, Mr. Silbert, of Mr. Magruder's efforts to have him pick a different sum of money that he paid to Mr. Liddy?
I wasn't aware of it at the time. I was subsequently aware of that, and of course, you know, talked to Earl Silbert about it, and they went into it in the grand jury, and it
When
came
you say
out,
subsequently aware, was that prior to the indictment?
I think after, Mr. Dash, but what it came down to is it was one-on-one. There was a conflict. Yeah. Sloan was a good witness in other respects.
Actually, you said that Mr. Dean called you about how Mr. Magruder made out. This was, I take it, after his final appearance before the grand jury?
Well, after his appearance before the grand jury, I don't know whether...
Had he shown some interest prior to that? Because I think there were 3 appearances that he had.
Well, yes, of course. You know, first of all, the statements were at the White House. Coming out of the White House, that John Dean was charged with preparing a report or what have you. John Dean's statements to me were, I'm responsible to keep the president informed. And, you know, if I get in there and he asks me a question, he really chews me out if I don't know the answer. And, Henry, you got to keep me posted on these things. And they wanted to know if there was going to be a newsworthy item. They'd like to know about it at or about the time it happened. So to that extent, I tried to keep him informed of the ultimate facts. And when I didn't, he would call.
Right, and therefore you did tell him that he had got through the grand jury. Now, can you recall a time when Mr. Ehrlichman got in touch with you concerning the appearance of Mr. Stans before the grand jury?
Yes, sir, I can.
Can you briefly tell the committee about that in your own words?
Well, I can't give you the date, Mr. Stash. I think the date can be isolated. It was during the summer. It was before the indictment. It can be fixed because it was immediately before the return date of the subpoena that was served on Mr. Stans. I received a call at 11:45 at my home. I was sitting at the kitchen table, and it was Mr. Ehrlichman. And he charged Earl Silbert with harassing former Secretary Stans. And I told Mr. Ehrlichman that Mr. Silbert wasn't responsible, that I had approved that, and that it wasn't a harassment, that it was true that he had been interviewed at least twice by the FBI, but we simply, I'm hesitating because I want to be fair to Mr. Stans. Basically, his testimony, his interviews were the same as he gave the committee. Let me put it that way. As I recall his appearance up here, there was some question about whether the committee believed his statements that he didn't know what happened to the money, that all he did was collect it. We had the same difficulty, and we felt that if that was his story, that we ought to have it under oath. So to that extent that we were calling him basically the third time to get that tied down, that was right.
But what did Mr. Ehrlichman want?
Well, what did he want? I asked him that question twice, and he never spelled it out except to stop harassing Mr. Stans. And I said we were not harassing him. And he charged that Earl Silbert was acting like a local prosecutor. Well, Mr. Silbert is a local prosecutor.
Well, did you get the impression that Mr. Ehrlichman was perhaps asking that Mr. Stans be excused from going to the grand jury?
Well, that's what he was driving at. I asked him twice what he wanted, and he never answered, other than to say stop harassing. I asked him, I said, well, if Stans has a problem with the subpoena, why doesn't his lawyer call me? And he says it wasn't necessary, that Ehrlichman was calling me. And we ended up telling him to tell his lawyer to call me.
Did Mr. Kleindienst later speak to you about the same matter?
Mr. Kleindienst called me Sunday evening, the day after, and said, are you upset? And I said, about what? And he said, about the Ehrlichman call. And I said, no, I'm not upset. I was a little mad, but it's his mistake, not mine, that I thought it was highly indiscreet. And Kleindienst said, well, what's it all about? And I told him that we wanted Stan's testimony under oath. And he said, well, why don't you come on down early in the morning? I've got to see Ehrlichman about this, and you and Silver come on down and give me a briefing. And we met, I think it was in my office at 8 o'clock the next morning, and briefed Mr. Kleindienst on the status of the investigation. And I told him, I said, there's no need for you to be concerned about me. No point in going over to the White House and getting a fight about me. He can't do anything to me. We get his testimony. Because I did discuss with Mr. Silbert and Mr. Kleindienst whether or not we should make a concession. One of the concessions that we did make was that we would take his testimony on what I describe as grand jury conditions, that is, under oath, without his lawyer being present, in order to avoid publicity. And
were you aware, by the way, before that, were you aware, or did Mr. Kleindienst tell you of his telephone conversation with Mr. Ehrlichman?
No, sir, I never heard of that. Indeed, I didn't know from whom he had learned of the conversation until very recently.
Right. Now, you said you did agree on a concession. Could you tell us, where was Mr. Stans interrogated?
He was interrogated in my conference room by the prosecutors on the case, with a reporter present and no one else.
And not before the grand jury?
No, sir.
Who else, by the way, was given a similar concession during the investigation?
Colson, Crow, and Young, I believe.
Colson,
Crow,
Young. And was this requested by anybody at the White House?
I think it was requested by John Dean in order to avoid publicity.
Is there any special reason? Is that the reason, to avoid publicity, that this concession was given to White House?
I don't think, no, that's all. Frankly, Mr. Dash, the most difficult judgments I've had since I've been in the Justice Department are decisions with respect to public officials.
Right.
Because the concerns are tremendous. You err seriously if you don't conduct an investigation where it should be conducted. And if you do conduct an investigation where it should not be, you do a terrible disservice to the public official involved. It's no help to say, well, Mr. Public Official, we want you to know you've been cleared, and we're sorry about all the publicity. That's a very serious thing. And I have in the past made that type of concession to avoid that type of publicity. And I've tried to resolve these problems by conducting, where necessary, investigations of public officials in as discreet a fashion as possible until we could be precisely sure of our facts. And then you can open up and go to the grand jury.
But you are aware, Mr. Petersen, that when you do this, as you did in the case of Mr. Stans, that you do prevent the opportunity of grand jurors who might ask questions that might open up certain areas.
obviously. But you see, Mr. Dash, not all witnesses go before a grand jury.
I know.
Grand jury doesn't get the opportunity to question everybody in every case.
Now, by the way, were you aware that Mr. Stans himself or his attorney received a transcript of his statement that he gave under these circumstances?
I'm not aware whether he did or not.
Would there be any policy about his getting it if he had asked for such a statement? Would a witness, for instance, appearing before the grand jury?
Would not get it, and I would say, since we were doing this under grand jury's conditions, I would not suppose that he did get it, but I don't know whether he did or not.
Now, the scope of the investigation itself, who set the scope of the investigation in this case? Was it set by the prosecutors?
Well, I'm not sure I understand what that means.
What actually was considered within the scope of the grand jury's investigation and was not within it?
Watergate was considered within the scope of the grand jury investigation. Federal corrupt practices violations I wanted handled separately, and they were handled to the extent that we could do so, and I think invariably we did accomplish it, by the fraud section of the criminal division with whatever United States Attorney's Office was involved. So to that extent, we tried to separate the two. Now, they couldn't remain inseparable. There were some witnesses who were common to corrupt practices violations that were before that grand jury, and where they were, we tried to combine both efforts and have them all questioned by Silbert at one time.
Well, now, did you participate in a decision not to get into the so-called dirty tricks activity of Donald Segretti when they came out?
Well, sure did.
Could you recall, did Mr. Dean raise that question with you?
No, sir. Well, I don't know whether he did or not. I don't recall him raising it. That question was raised with me by two people. One, Earl Silbert, who said, in effect, we're not experts on the Corrupt Practices Act. We don't see any violation, do you? And I said, no, not on the basis of what we have. This is around August or September. The FBI in October, Charlie Bowles, who was in charge of the accounting and fraud section, called me and said, Henry, we're not investigating these. Do you see a violation? And I said, no. Dirty tricks per se are not a violation to my knowledge. Now, the only violation we've been unable to uncover in connection with these things is the failure to accurately subscribe to a political statement that's promulgated. That failure to so subscribe with being in violation of 18 U.S.C. 612, and that's what the investigations have gone off on. But mere dirty tricks, oral false scheduling, for example, or passing an item of information on was not a violation to my knowledge.
Now, Mr. Segretti was called for questioning before the grand jury. Do you recall telling Mr. Silbert to limit his investigation of Mr. Segretti to the so-called Watergate activities and not to get into the dirty tricks?
Yes, sir, I did indeed. What we were after was the relationship between Hunt. I misspoke myself, Mr. Dash. I don't remember that. I was confusing with Kalmbach. To Segretti, we were trying to relate his relationships to Hunt and whether or not they had any significance to the Watergate thing. Now, I'm unsure here whether or not I knew at that time that he had some relationship to Kalmbach.
Well,
in any event, I told Silbert I didn't want him getting into the relationships between the president and his lawyer, or the fact that the president's lawyer might be involved in some, what I thought, legitimate campaign activity on behalf of the president.
Do you recall, Mr. Petersen, this conversation that Mr. Dean testified to on page 2245 of the transcript? He said, after my conversation with Chapin, I called Mr. Petersen at the Department of Justice and explained the problem that was confronting Segretti. I told Petersen that to the best of my knowledge, Segretti had no involvement in the Watergate incident, but he had had dealings with Hunt in connection with some campaign activities he had been performing for the White House. I also informed Petersen that he was being paid by the president's personal attorney, Mr. Kalmbach, and that he had been recruited by Chapin and Strawn. And I said that these facts, if revealed, would obviously be quite embarrassing and could cause political problems during the waning weeks of the election. And Mr. Petersen said that he understood the problem and would determine what could be done. Do you recall that conversation?
I don't remember it in those terms. It could well have been. I certainly told Silbert that I wanted him to confine his investigations to Watergate, and I remember my statements. So I don't regard this crime as an excuse for us to run a general investigation of the White House and the entire Republican Party.
Now, it did turn out, did it not, that a grand juror, actually, in the jury did ask Mr. Segretti certain questions that brought out the names of Mr. Chapin and others. Are you aware of that?
I've heard about it. I often wondered whether that was by chance or whether that was Earl Silbert's way of disagreeing. But
I know. Now, do you recall having a conversation with Mr. Dean with reference to responding to Congressman Gary Brown's letter concerning the Patman Committee investigation?
Yes, but that's a very confused situation. He mentioned it to me, and he seemed to think I would have the letter, and I did not. The letter was in the deputy's office. Ultimately, I was consulted with respect to the letter, and I do remember Mr. Dean asking me what our policy was with respect to congressional committees. And I told him that our policy was, one, to advise them if there was a pending prosecution, and ordinarily our relationships were good enough so that we could do that informally and work it out, and our problems were general with the investigative committee, like the McClellan Committee and what have you.
Were you aware that the Patman Committee was in fact planning to call or subpoena a number of the witnesses that would be involved in the criminal prosecution?
Only from the public press.
And was it your position that such a congressional committee might prejudice the criminal prosecution?
On the Corrupt Practices Act, we don't see any violation, do you? And I said no, not on the basis of what we have. This is around August or September. The FBI in October, Charlie Bowles, who was in charge of the accounting and fraud section, called me and said, Henry, you know we're not investigating these. Do you see a violation? And I said, no. You know, dirty tricks per se are not a violation to my knowledge. Now, the only violation we've been unable to uncover in connection with these things is the failure to accurately subscribe to a political statement that's promulgated. That failure to so subscribe would be in violation of 18 U.S.C. 612, and that's what the investigations have gone off on. But mere dirty tricks, oral false scheduling, for example, or passing an item of information on was not a violation to my knowledge.
Now, Mr. Segretti was called for questioning before the grand jury. Do you recall telling Mr. Silbert to limit his investigation of Mr. Segretti to the so-called Watergate activities and not to get into the dirty trick?
Yes, sir, I did indeed. Well, you know, what we were after was the relationship between Hunt. I misspoke myself, Mr. Dash. I don't remember that. I was confusing with Kalmbach. To Segretti, we were trying to relate his relationships to Hunt and whether or not they had any significance to the Watergate thing. Now, I'm unsure here whether or not I knew at that time that he had some relationship to Kalmbach. Well, in any event, I told Silbert I didn't want him getting into the relationships between the president and his lawyer, or the fact that the president's lawyer might be involved in some, what I thought, legitimate campaign activity on behalf of the president.
Do you recall, Mr. Petersen, this conversation that Mr. Dean testified to on page 2245 of the transcript? He said, after my conversation with Chapin, I called Mr. Petersen at the Department of Justice and explained the problem that was confronting Segretti. I told Petersen that to the best of my knowledge, Segretti had no involvement in the Watergate incident, but he had had dealings with Hunt in connection with some campaign activities he had been performing for the White House. I also informed Petersen that he was being paid by the President's personal attorney, Mr. Kalmbach, and that he had been recruited by Chapin and Strawn. And I said that these facts, if revealed, would obviously be quite embarrassing and could cause political problems during the waning weeks of the election. And Mr. Petersen said that he understood the problem and would determine what could be done. Do you recall that conversation?
I don't remember in those terms. It could well have been. I certainly told Silbert that I wanted him to confine his investigations to Watergate, and I remember my statements. So I don't regard this crime as an excuse for us to run a general investigation of the White House and the entire Republican Party.
Now, it did turn out, did it not, that a grand juror, actually, in the jury did ask Mr. Segretti certain questions that brought out the names of Mr. Chapin and others. Are you aware of that?
I've heard about it. I often wondered whether that was by chance or whether that was Earl Silbert's way of disagreeing, but...
I know. Now, do you recall having a conversation with Mr. Dean with reference to responding to Congressman Gary Brown's letter concerning the Patman Committee investigation?
Yes, but that's a very confused situation. He mentioned it to me, and he seemed to think I would have the letter, and I did not. The letter was in the deputy's office. Ultimately, I was consulted with respect to the letter, and I do remember Mr. Dean asking me what our policy was with respect to congressional committees. And I told him that our policy was, one, to advise them if there was a pending prosecution, and ordinarily our relationships were good enough so that we could do that informally and work it out, and our problems were general with the investigative committee, like the McClellan Committee and what have you.
Were you aware that the Patman Committee was in fact planning to call or subpoena a number of the witnesses that would be involved in the criminal prosecution?
Only from the public press.
And was it your position that such a congressional committee might prejudice the criminal prosecution?
Yes, sir, and I signed a letter. That letter was prepared by my staff and the Office of Legal Counsel. It was sent to Congressman Patman, setting forth our positions and the fact that under the Laney case, the government is regarded as a monolith, and the actions of the congressional committee are attributable to the prosecution in that, and it might result in prejudicial publicity, yes.
Did you later learn what happened to the subpoenas that were proposed to be sent in the Patman Committee investigation?
I have no idea about that.
As a matter of fact, the vote was against subpoenaing them, and that investigation never got off the ground.
Yeah, I understand there was such a vote.
Now, in October, Mr. Petersen, October 24, 1972, do you recall receiving certain documents from Mr. Kleindienst, which had been turned over to Mr. Kleindienst by the CIA relating to Mr. Hunt's activity?
Yes, I do, Mr. Dash.
Now, in October 24, were these just documents, or did they include photographs? Do you know?
My recollection is that there was a series of photographs attached to the package. I guess to recount the situation, I was called up to Mr. Kleindienst's office. Mr. Helms and his counsel, Larry Houston, were there. They expressed some reservations about potential embarrassment to the CIA, and that they were there with certain information as a result of questions generated by Mr. Silbert. They hoped that it would not be necessary to disclose them. I took the information and left with Larry Houston, sat down and examined their concerns, and related to the help that had been furnished to CIA, and there was one possible, wholly unrelated, valid CIA activity involved, which they were most desirous of protecting. I assured them that we would try and do that, made arrangements to get Errol Silbert over there, and we went over the documents. We studied those photographs, and we couldn't make any sense of them at all.
Mr. Petersen, to refresh your recollection, could you recall that there were actually two times you may have received certain documents? Once, documents alone from Mr. Kleindienst on October 24th, and some documents in which photographs were attached sometime in the early part of January 3rd?
No, I don't remember
Does that
any
show?
January 3rd, Mr. Dash. We got some documents from CIA in October and some documents from the CIA in December. Now, I could be mistaken. They may have been attached to December documents. My recollection is they were in the October package.
Well,
I'm not sure.
may I show you a copy of a memorandum dated December 5, 1972, and attached to it are Xerox copies of photographs, and see if this are the records that you did receive.
I recognize one, which is a picture of Mr. Liddy in front of a stationer's store, which has on the sign on the window, Xerox copies while you wait. I recognize that one. I recognize another one in which there is an address, 11923, on the building with a car outside. I recognize another one in which there is written in on the
and actually, what
two automobiles, reserved Dr. Fielding, reserved Dr. Rothberg.
Right, and actually what you did receive were Xeroxes of photographs, not photographs themselves.
That's right.
And did they appear something like these Xeroxes, which I've now shown you, or are they little?
Those I've mentioned to you, yes, sir.
Yes. Now, when you received these, was there any indication to you as to what investigation these photographs related to?
No. We were investigating in the course of the, some activities of Hunt and Liddy out there in California, trying to figure out why and what its relationship to Watergate was. And Silbert and I sat down and went over these documents, and we couldn't relate them to anything. Later at the point, we asked CIA, I guess, and they didn't have any descriptive data or for negatives or actual photographs or anything that would assist us.
Were you aware of the Special Investigating Unit, which has been called the Plumbers, that was in the White House?
No, sir.
Did your criminal division play any role in the investigation of the Pentagon Papers leak?
No, sir.
Were you aware of the investigation that this so-called investigating unit was making of Dr. Ellsberg, or his psychiatrist?
Sir.
And when you noticed, I think there was some evidence that some of these photographs referred to a Dr. Fielding. Did you know who a Dr. Fielding was?
No, sir.
Or whether or not he was related in any way to Mr. Ellsberg? No. So that in receiving these documents, would it be fair to say that they did not put you on notice of any break-in or effort to break in to Dr. Fielding's office?
They did not.
Or did it have any relationship to an investigation of the Justice Department's investigation of Mr. Ellsberg? Or the prosecution that was going on?
We didn't relate those documents to the Ellsberg case until, I think, at the time of Mr. Krog's affidavit in connection with the Ellsberg matter.
Mr. Chairman, I'd like to have the memorandum of December 5, 1972 with the accompanying Xerox copies of photographs marked appropriately for identification and admitted in evidence.
That will be done.
Now, Mr. Petersen, around December 22nd, 1972, in connection with hearings on Mr. Bittman's motion, as I understand, concerning certain items that were taken out of Mr. Hunt's safe, did Mr. Dean tell you that he had given certain items from Mr. Hunt's files to Mr. Gray?
Yes, we had an old afternoon session which started around 2 or 2:30, in which we were interviewing Mr. Dean, Mr. Fielding, Fred Fielding of the White House staff, and Bruce Curley, with respect to their search of Mr. Hunt's office immediately after it was ascertained that he had some part in the break-in. Mr. Bittman, in his motion on behalf of Mr. Hunt, had alleged that there were 2 notebooks present among Mr. Hunt's possessions that were not accounted for in the FBI inventory, and we were trying to determine where they were, if they existed. Did the FBI agents have them? Did Dean, Fielding, Curley come across them? Did they retain them, or what have you? And we spent all afternoon interrogating those three people, anticipating that they would be called as defense witnesses on the motion to suppress. Approximately 6:30 that evening, my recollection is we were interrupted with news of DiCarlo commutation. Mr. Dean pulled me aside and said his statements in there were true, that he had given everything to the FBI, but to some documents he had given to Mr. Gray personally. And I said, well, John, I just want to know one thing. Are they related to Watergate? And he said, they're absolutely unrelated. I said, well, if you're asked that question, you're going to have to tell the truth. And I remember his answer very vividly. He said, Henry, I'll tell the truth. I'm not going to lie for that damn Ehrlichman. I may lie for the president, but I'm not going to lie for him. And I said, well, more than that, John, I'm willing to take your word that they're not related to Watergate, but defense counsel's not going to be. Now, if you're asked that question, those documents are going to have to be produced, and you better talk to Pat Gray about it. He said he would. We broke up on that note, and we were going to get back to it. I was off on the Christmas holidays, and when we came back, negotiations were undertaken with respect to the plea of guilty by Hunt. And at the suggestion of prosecutors, I approved the acceptance of a plea to 3 counts, a conspiracy count, burglary count, and the eavesdropping count, which, as I recall, would have subjected them to about 25 years. And the court went as one better and insisted they plead to everything, which they did. Well, of course, with the acceptance of the plea, the motion to suppress was not pressed. And, of course, I guess I just no longer had in the forefront of my mind those documents or that question with respect to those notebooks.
Well, did there come a time when you followed up and asked Mr. Gray whether or not he did receive certain documents out of Mr. Hunt's safe from Mr. Dean?
During the course of Mr. Gray's confirmation hearing, he had occasion to call me about some point. And in the course of that conversation, I asked him very casually if he had ever received documents from John Dean from Hunt's safe or office, which were not given to the agents, and he said no. The next occasion came on or about April 15th, when John Dean was being debriefed by the prosecutors, and he related this to him, and Silbert asked me about it, and I said yes. Told him I'd asked Pat Gray, and Pat Gray had said no. But I went back to Pat Gray, either on the 16th or the 17th of April, and asked him again. Told him what John Dean had said, and he said, Henry, that's not so. About this time, I was having some discussions with the president about it. I had imparted this information to him, and he said, well, I think Dean's telling the truth on this. You ought to ask Ehrlichman. Well, when I left there, I went over to Ehrlichman's office, and he was not there, and I frankly didn't bother going back to him. We double-checked with Dean's counsel, and they were sure of it, and I went back to Mr. Gray the following week, around the 25th, 26th, and asked him again, and this time he said yes, that he had received such documents, that they had implied that he ought to destroy them, that he had taken them home over the weekend and brought them back and tore them up and threw them in a burn basket. And I said, well...
Did he tell you why he had destroyed them? Whether he was acting under instructions?
Well, he just... I asked him one if he read them, and he said no, and I said, well... He said, well, they just said they were politically sensitive.
Did you say he did not know the contents of the papers?
I asked him if he read them, and he said he did not.
Who did you say that Mr. Gray went to before he burned them?
He went to Connecticut.
Yes.
He was in the travel status, as I recall his statement to me. And after he received the documents, he was going up over the weekend or to make a speech, and he took the documents with him, and he told me he then brought them back to the office and tore them up and pointed down to the basket beneath them and said, I put them in there, and they were...
Without reading them at all?
Without reading them.
Now, by the way, on the 26th, which was now quite some time beyond the period we had been talking about, Mr. Gray has testified that on that day, and apparently that's the day he did admit to you that he destroyed the documents, that you said to him that you were scared and that you and he, Mr. Gray, were expendable and Mr. Haldeman and Mr. Ehrlichman were not expendable. Did you say anything like that to him, and if so, why?
I'm not sure you have the time right, Mr. Dash. As I recall it, that was the night before Mr. Gray resigned. It was the day in which this item that we're discussing was publicized. And I received a call from the President, as did Mr. Kleindienst, in the evening. And the President asked me whether or not I thought Mr. Gray ought to resign. And I told him that I thought Mr. Gray's position was untenable. And he said, well, discuss it with the Attorney General. He, too, had talked to the Attorney General. And, of course, I did discuss it with the Attorney General, and pursuant to the President's instructions, we asked Pat Gray to meet us. And we did meet in the back office of Mr. Kleindienst's office. And we discussed the situation. And in my conversation with the President, I expressed some sympathy for Mr. Gray, who I think most highly of. I have no hesitancy. I like the man very much. And I told the President, Mr. President, I think he's an innocent victim. And the President said, yes, Henry. He said, maybe, but there are going to be a lot of innocent victims before this is over. So it was in that context, the context of commiseration. I didn't want to be there. We were in effect suggesting that the man resign. And when Mr. Kleindienst went out of the room to talk to the President again, I said, Pat, we're all going to be embarrassed before this is over. I'm scared. I mean, we have a constitutional confrontation here. We have the presidency of the strongest nation in the world teetering in the brink. Now, I don't remember saying that we were expendable and Ehrlichman and Haldeman were not, but I may have.
Well,
I was upset, yes.
By the way, are you aware that Mr. Gray's testimony is that he informed you on April 17th that he had received the documents? You aware that that earlier time that he gave you that information?
No, sir. My recollection is that I went to see him on the 16th or 17th and he denied it. I went back to see him the following week after double checking with Silbert and Dean's counsel and the President and what have you. And it was Tuesday of that week, I think, maybe the 25th, 26th.
Now, Mr. Petersen, do you recall that sometime after the conviction of the 7 Watergate defendants and the sentence, having lunch with Mr. Kleindienst, Mr. Dean, and Mr. Ehrlichman, and a question of leniency for defendants coming up?
No.
I mean, you having lunch with Mr. Are you? Let me rephrase the question. Are you aware of a lunch that Mr. Kleindienst had with Mr. Dean and Mr. Ehrlichman, in which a question of leniency came up concerning the defendants in the Watergate case?
Well, I'm aware of a time when I received a telephone call from Mr. Kleindienst, who said, I'm just now leaving the White House and I'm on my way to the airport, and on the way by, I'll stop by and you be downstairs and I'll pick you up and you can ride out to the airport with me and get some information from you. And I can't fix the date except that it was a time when Mr. Kleindienst was going to Boston and he was meeting his wife at the airport. We rode out to the airport and he said, I just had lunch with Dean and Ehrlichman, and they raised the question of whether or not leniency could be accorded these defendants. And I said, absolutely not. I said, indeed, we're going to do just the contrary. It's not the practice in the District of Columbia to recommend specific terms, jail terms, but it certainly is a practice to recommend for jail or no jail, and we intend to recommend jail time for these people. And beyond that, after they are sentenced, we intend to call them back and immunize them in order to compel their testimony as to whether or not other persons are involved, and if they're contumacious and refuse to testify, they'll be held in contempt. So we discussed more what the procedure was, the sentencing procedures, and when they'd be sentenced and what have you, and he finally said, well, do me a favor. Go on back and go on over to the White House and tell those crazy guys over there what you just told me before they do something they'll be sorry for. And I said, well, okay. And I went back to my office, and on the way back I thought, I haven't been over there yet, and this is not the time to go. So I called John Dean on the telephone and told him, John, there's no point in my coming over there. We're going to recommend jail time, and these people are going to be immunized. And we then discussed what immunity meant, what the alternatives are, and what they are is, one, you can be contumacious and you go to jail almost immediately, or you can lie and take your risk that the government will be able to prove it, which may give you a little bit of time, or you can cooperate. And I spelled those out for him, and that ended the conversation.
All right, now, we've had testimony from Mr. Kleindienst, and I think Mr. Kleindienst indicated that you perhaps would be our better witness as to what occurred on April 14th, which led also to a meeting on April 15th with the President. What actually led to the meeting that you had with Mr. Titus, Mr. Silbert, Mr. Glanzer, Mr. Campbell on the 14th of April?
Mr. Silbert was trying to get me all throughout the day on the 14th of April. I did not get home until approximately 6 or 7 o'clock in the evening. I called him and he said it was imperative that he, Titus, Silbert, Glanzer, meet with me immediately. So I agreed. So we set up a meeting in my office at 8:30 that night. They came down and they launched into the fact that they had made a breakthrough in the Watergate case, and that it was of significant proportions, and that they were in the course of attempting to negotiate an agreement for John Dean's testimony, and they had received certain information from him in the course of the negotiation, which they had agreed not to utilize unless some type of an agreement was reached. They had received also testimony from Jeb Stuart Magruder, which seemed to corroborate the skeletal facts that Mr. Dean had given them, and that on the basis of all these facts, they concluded that Mr. Mitchell, Mr. Mardian, Mr. LaRue, Mr. Magruder, Mr. Ehrlichman, Mr. Haldeman, Mr. Dean were putative defendants.
Now, when you had that information, did you call Mr. Kleindienst or did Mr. Kleindienst call you?
That was the night of the White House Correspondents' Dinner, and had great difficulty in getting in touch with Mr. Kleindienst, and we tried finally left word for the White House to get in touch with his car, radio car, and he called me, or I guess around 12:30 after the dinner. We then made arrangements to meet at his home. And Mr. Titus and Mr. Silbert and I arrived at his home around 1:30 or 2 o'clock in the morning, and we proceeded between then and 5 a.m. to give him a recitation of what we thought was in the offing and who was involved.
And I take it these are the same facts that you had been briefed on by the prosecutors.
Right. And of course, it was the unanimous recommendation of all of us that he inform the President immediately because of the implications. This was really the first information that we had that tied it to people of the stature of Mr. Mitchell, Mr. Haldeman, Mr. Ehrlichman.
And did you set up a meeting, or did Mr. Kleindienst set up a meeting with the President?
Mr. Kleindienst agreed that he would set up such a meeting with the President, and as I recall, he said he was going to, there was a prayer breakfast over there, and he would attempt to set it up while he was there. I next heard from Mr. Kleindienst approximately 2 o'clock Sunday afternoon, and he asked me to come down to the office, and I did so. And while there, he said he was going to go and see the President again around 3 or 3:30, and maybe it'd be a good idea if I come with him. And I said, okay.
And was it at this time that you and Mr. Kleindienst gave a complete briefing as to what you had learned from the prosecutors
Yes, sir.
to the President?
Yes, sir.
Can you tell the committee what the reaction of the President was at that time?
Well, I guess the reaction of the President was, I guess, one of concern, but I remember remarking to Mr. Kleindienst how I admired his calm. I would have been cussing and fuming. He was concerned, and you have to understand that I had seen the President only in ceremonial occasions or briefing on legislation. He didn't know me from Adam.
This was your first face-to-face meeting with the President then, wasn't it?
And yes, in any type of situation where he was relying solely on my advice. And here I was there recommending that two people who he had known and worked with for years be dismissed.
Who were they?
Mr. Haldeman and Mr. Ehrlichman.
What was his reaction to that recommendation?
He understood my concerns, and he appreciated my candor and my concern for the presidency, and my position was that I can't guarantee you that we have a criminal case at this point, but I can guarantee you that these people are going to be a massive source of embarrassment to the presidency, and for that reason I think that the best thing that you could do would be to get rid of them immediately.
Did
The
you have
president's response was interesting. He said yes, but he owed them an obligation of fairness too. And I didn't disagree with that. If somebody come in and said to my two assistants, you got to fire them immediately, I'd take time to look.
What office?
He took longer than I would have liked. I guess I was a little impatient, but he did it, and that was the important thing.
What office was this meeting held in?
It was in the old executive office building.
Yeah. Were you aware at the time, Mr. Petersen, that these conversations were being taped?
No, sir, but it didn't surprise me. I would have anticipated. I think if you had asked me, I would have thought that that was a fair possibility. And frankly, let me say for record, I have no objection. I think the chief of state ought to do it.
Now, did you make any recommendation with regard to Mr. Dean?
Yes, I did. The president said, Haldeman and Ehrlichman deny this. I've got to find this out. Dean, in effect, has admitted it. Should I request his resignation? And I said, my goodness, no. Now, here's the first man who's come in to cooperate with us, and certainly we don't want to give the impression that he's being subject to reprisal because of his cooperation. So please don't ask for his resignation at this point. And the president agreed to hold off until he heard from me further on that issue. That carried on until about 26th or 27th of October, and in a statement on the telephone, I reached the conclusion after discussions with Silbert that we had reached an impasse in our negotiations with Mr. Dean.
You don't mean October, you mean...
You're right, Senator. April, excuse me. We had reached an impasse in our discussions with Mr. Dean, and that I could no longer justify the president's not asking for his resignation. And
prior to that time, Mr. Petersen, do you recall having a discussion with the president concerning immunity that might be afforded yes. Witnesses? Could you tell us briefly about that?
Well, I think that started the preceding Wednesday. Mr. Ehrlichman had called Mr. Kleindienst, and Kleindienst called me up there and said he just had a call from John Ehrlichman, and Ehrlichman wanted to say he didn't think any White House aides ought to be immunized. And it didn't make much of an impression on me, and I just made a witticism that, well, tell Ehrlichman he can't count on it. And I didn't think anything more about it. Of course, when I learned at the end of the week...
But at this time, Mr. Dean was in his conversations or cooperation
that's right.
with the
prosecutor. At the end of the week, when I learned that Dean was cooperating, well, it made more sense. Well, the president took it up, and the president's... well, we went on with this for about 2 or 3 days, and we had a difference in viewpoint, of course. One, the president's concern... I hope I accurately reflect them, but it seemed to me the president's concern was that from a public relations point of view, certainly he wanted to leave the impression that he, as president, was not causing persons who were in the upper echelons of his administration to be immunized and freed from liability. He wanted to make certain that in that respect no one got the impression that they were getting favored treatment. Well, I understood that to be a consideration, but I also understood that if it were in the interest of the prosecution, that it might be necessary to immunize some high echelon person.
Did you explain that to the president?
I did indeed.
And did you get an understanding as to who would make the ultimate decision on immunity?
Yes, sir, I did.
And who would be given that ultimate decision?
Me.
Now, did it come a time...
At that point in time.
Yes. Did it come a time about April 18th that the President called you concerning the immunity question?
Yes.
Could you tell us briefly about that call?
The President called me, as I recall, it was in middle or late afternoon, and said that as a result of his conversation with the President, he felt like he'd been misled. Dean said he had been immunized, said the President. And I said, Mr. President, that is not so. We are in the process to determine whether or not he should be immunized, but we have made no decision, and so far as formal immunity is concerned, only I can grant it. Prosecutors don't have the authority. I'm certain that's not so, but I will check. I called Earl Silbert and he said, of course, just what I said, and I said, oh, that's fine, but going back to his counsel, and his counsel agreed, no, we're just in a preliminary negotiation, and no immunity has been offered or accepted. When I called the President back, I told him that, and he said, well, you know, I have it on tape if you want to hear it. And I said, no, I don't want to hear it, because I don't want to get anything except what we're getting from John Dean directly.
Now, when he said he had it on tape, did he indicate it was a tape of Mr. Dean?
No, he did not, and I didn't ask him. No.
Is that where the matter stood?
That was where the matter stood, yes,
right.
sir.
Now, Mr. Petersen, on April 16th, did you receive a memorandum from Mr. Silbert concerning the Ellsberg psychiatrist break-in?
Yes, sir, I did.
And was that the first time that you learned of that break-in?
To be precise, I ought to correct that. The memorandum was dated April 16th. I think I received it on the 17th, Mr. Dash.
Right. And is that the first time that you learned of the break-in?
I think Earl told me on the telephone, this is what he told us, I'm sending you a memorandum.
And what did you do when you received that memorandum?
I sent it to Deputy Assistant Attorney General Kevin Maroney and said, Kevin, check this out. Let me know what there is about this. Mr. Maroney came back with a note from him and a memorandum from one of his staff in which they said, we have no such information, nor does the FBI. Then we asked them to check whether or not there was a psychiatrist involved and what have you, and they did, and they turned up from the FBI records that an individual by the name of Fielding had been interviewed. Well, that clicked. That led us to the photographs, and then we made the connection. I advised the President of that and kind of in response to his, well, what's new? And I told him that we had received this information.
Did he indicate that he knew anything about that break-in when you told him about it?
No, he did not. Mr. Dash, you have to be very careful there. I'd like to rephrase the question for you, if I can. I suppose the question would probably be, did he indicate he knew anything about it, rather than anything about the break-in? And the President said, when I told him, I know about that. That's a national security matter. You stay out of that. Your mandate is to investigate Watergate. Now, he didn't say he knew about the burglary. He said he knew about the report. And I think that's a vital distinction to be recognized.
By the way, when were you reporting this to the President?
It was on April 18th, sir. And he said stay out of it. And after I got off the telephone, I called up Mr. Silbert, and I called up Mr. Maroney and said to Mr. Silbert, I said, the President said stay out of it, Earl, and that's it. And I called up Mr. Maroney and said, just forget it. Then I proceeded to ponder the situation. I discussed it with some of my staff, some in terms of the actual. And the question involved was whether or not it was producible under Brady versus the United States, which holds that exculpatory material should be made available to the defense. Well, there are two views of Brady. One, that anything that may lead to an acquittal should be produced, and another, only that which goes to guilt or innocence is producible. And obviously the prosecution usually takes the more narrow point of view. And under that narrow point of view, namely that this did not go to guilt or innocence, it was not producible. And we stood on that for a day or so, and then I rationalized that that might be true, but this was really not the case to test that. That I thought if we tested it in this sort of case, we'd probably lose it. and that it was such a celebrated case, and it certainly had political overtones, that this type of thing ought to be disclosed. And but I really didn't quite know what to do. Mr. Kleindienst had recused himself of Watergate, and finally, on the 25th, I went on up to Mr. Kleindienst's office and said, "Look, you're out of Watergate, but you're not out of Ellsberg. I need some help." And we spent most of the day talking about this, and he solicited some independent opinion and concluded that I was right, that indeed it should be disclosed. And I said, well, you know, the President's given me a...
You communicated that to the President?
I told Mr. Kleindienst that the President instructed me to forget about it, and that nonetheless I thought we ought to go to the President, and if he was unhappy about it, we'd simply have to take the consequences. And Mr. Kleindienst agreed to that. And he went to the President, and the President agreed. And may I say, Mr. Dash, that I've been distressed by some of the criticism, press, and maybe even other places, that about the President on that score, and I think it's wholly unwarranted. He took a position with me, and I think I can count myself as not the most senior, but at least a senior official in the administration. We disagreed with it. We went back to him, and he finally agreed to us. And I think the ultimate thing is that he came out with the right answer, and I think he had every right to expect us to come back to him if we disagreed. And so I think the criticism is wholly unwarranted.
Mr. Petersen, did you receive a call from the President on April 30, 1973?
Yes, sir.
And could you tell us what that call was about?
April 30th, 73,
Yes.
He called up and said, "You can tell your wife that the President has done what needed to be done, and I want to thank you for what you've done." To the extent that that requires some explanation in the course of our conversations, I was impressing upon the President that the situation, so far as I was concerned, was degenerating, and it was vitally affecting the people's confidence in the White House. And I related to him a conversation that I had with my wife at the breakfast table, in which she had said, "Do you think the President's involved?" And I related that to the President, and I said, if I reach the point where I think you're involved, I've got to resign. If I come up with evidence to you, I'm just going to waltz it over to the House of Representatives. I said, but what's important is that my wife, who's no left-wing kook, is raising these questions of me, and that indicates to me that you got a most serious problem. And that affected the President quite strongly. And when he called me on April 30th, he made that point.
And this was the day that he announced the resignations of Mr. Haldeman, Mr. Ehrlichman, and the leaving from office at his request of Mr. Dean.
That's right.
I have no further questions, Mr. Chairman.
In a moment, Petersen is asked about his report to President Nixon on the involvement of Dean, Ehrlichman, and Haldeman. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Returning to the hearing, Minority Counsel Fred Thompson begins his questioning of Petersen.
Mr. Thompson.
Thank you, Mr. Chairman. Mr. Petersen, let me ask you a few more detailed questions about your meeting with the President on April 15. You stated that you told him on that occasion that although you possibly didn't have a criminal case against Haldeman and Ehrlichman, that it could be very embarrassing to the presidency. What information did you have on Haldeman and Ehrlichman at that time? What had Dean told the prosecutors about Haldeman and Ehrlichman's involvement in the Watergate matter?
Well, we had not too much on Mr. Ehrlichman at that point. We had Dean's statement that Ehrlichman had told Dean to deep six certain information recovered by Dean from Mr. Hunt's office. If you don't mind, I'm referring to my notes on this. Two, that Mr. Dean had said that Ehrlichman, through Dean, had informed Liddy that Hunt should leave the country. Hunt corroborated this in part, in that he testified that Liddy had told him that Liddy's principals wanted Hunt out of the country. Hunt did not testify with respect to or identify Ehrlichman. That's the basic information, only information we had on Ehrlichman at that point.
Had he said anything at that point about furnishing money to the defendants or the defendants' families, or Ehrlichman's approval of money being raised and distributed to the families?
Yes, I think that was mentioned well, that Ehrlichman had said, well, tell them we'll do what we can. You know, it was not specific with respect to any specific amount of money.
Was Kalmbach mentioned in this regard?
Kalmbach was mentioned, but not with any definitive nature of the allegations against him. Only that...
The major emphasis was on the Deep Six comment.
So far as Ehrlichman was concerned.
So far as
Haldeman was concerned, Dean had allegedly told Haldeman that there was a series of meetings, 3 in number, and with John Mitchell, which took place in Mitchell's office.
I'm sorry, what did you say?
Dean had told Haldeman, according to Dean, that there was a series of meetings, 3 in number, in Mitchell's office, at which Liddy, Magruder, Dean, and Mitchell were present. And at each of these meetings, the Liddy operation was discussed, the purpose being to obtain information about Democratic presidential contenders. On 2 occasions, Mitchell refused to authorize the budget proposals, the first being for $1 million and the second $500,000. On the 3rd occasion, Mitchell approved a reduced budget of $300,000. The operation was described as Operation Gemstone. Magruder had said that the budget information was given to Strawn. Magruder also said that the information given to Strawn was for delivery to Haldeman. Magruder was not in a position to say that Strawn actually received actually delivered the information, or that Haldeman actually received it. Dean stated that after the second meeting with Mitchell, Liddy, and Magruder, he returned to the White House and relayed the information to Haldeman, and the nature of the proposals were discussed, and stated that we ought not to have any part of them. Dean stated Haldeman agreed, but I pointed out to the President that apparently no one took the laboring oar to try and stop them. And I thought that that was certainly a responsibility of someone like Haldeman. Magruder further stated that he caused to be delivered to Strawn for transmittal to Haldeman a summary of the intercepted conversations. Again, I told the President Magruder was not in a position to say that Strawn actually delivered that information. Strawn at that point was being interrogated, and there was some indication that he might be willing to cooperate. And I told the President those negotiations were underway, and we thought that they would ultimately bear fruit, and that that would in effect give us 2 and possibly 3 witnesses against Haldeman. And that was a very dire situation, and while I couldn't say we had a criminal case at the time, certainly one was in the offing.
All right, when did you make those notes?
Sir, the president asked me to reduce what I said to him in writing about those 2, Haldeman and Ehrlichman, and I did that and gave it to him on April 16th.
And that's the same thing that you have before you right now?
Yes, sir.
Would there be an objection to making that a part of our record?
No,
if we
sir.
could, at subsequent time, make a copy of that, unless you have an extra copy.
I don't know whether I have an extra copy, Mr. Thompson, but I'll be happy to give it to you, and you give me a copy back. That will satisfy me.
Would that be agreeable to the chairman?
Let the record show that the notes identified by Mr. Petersen will be appropriately marked as exhibited and admitted into the record as such.
All right, Mr. Petersen, so essentially what you had then, to go in a little bit more detail, you've touched on this, is one White House member, Mr. Dean, telling some very significant and dire things about 2 other White House members, Mr. Haldeman and Mr. Ehrlichman. What was the president's reaction to this situation? Did he express particular belief or disbelief in any version or any individual, or how did he evaluate the posture of those 3 men?
I think it's fair to say he was kind of upset about Dean. He said that when he first learned about this, that there were some more difficult problems in store for him than he had anticipated on March 21st, and he had asked John Dean to reduce those to writing and sent him up to Camp David to do so, and apparently Dean was unable to reduce them to writing, and the president commented, I suppose, that because of his involvement. And he was concerned that perhaps Dean was trying to lighten the load on himself by impeaching Haldeman and Ehrlichman, and the question in his forefront of his mind was the validity of the Dean information. That was the importance of the Magruder and information, and the possibility of Strawn coming through as a corroborating witness.
Did he say precisely what Dean had told him on March 21st?
No, sir, he did not.
How did
Indeed, he said that he told Dean to go up and write a report, and he never got such a report, and Dean was unable to write it.
But how did you phrase it a moment ago? What did he say about the 21st meeting?
He first learned that, well, the words are mine, not the president's. He first learned that there was more significant problems than he had anticipated on March 21st.
Did he indicate that on March 21st he had learned what you were telling him? Or
no, sir, he did not. What he did suggest was that after Dean had failed to provide him this written report, he had told Ehrlichman to conduct an investigation. Now, I never asked him for the product of Ehrlichman's investigation, nor do I know what it consisted of.
Did you ever discuss with the president the possibility of his talking to Liddy or Liddy's lawyer?
No, sir. During the course, I did suggest to the president that he ought to hear John Dean himself, that he ought to hear from John Dean what John Dean was telling the prosecutors, to aid the president in making up his mind with respect to his future course of conduct towards Haldeman and Ehrlichman. At my home later that Sunday evening on April 15th, Charlie Schaffer, Mr. Dean's lawyer, called, and present were Mr. Silver, Mr. Glanzer, stated that Dean, had had a call from Mr. Ehrlichman, who wanted to meet with Dean and requested our advice. We told him not to meet with Mr. Ehrlichman, but that it would be perfectly agreeable to meet with the president. Thereafter, he called back and said that Mr. Dean had sent a message back to the White House suggesting that he would be happy to meet with the president and what have you. The president called me that evening and said he had received that message and should he meet with him, and I said by all means. He called again to say, one, that the meeting had been set up. He called then again around 9:30 or 9:45. I did not know that Mr. Dean was still there, and said that he had received information that Liddy was waiting for some sort of signal from the White House or the President as to whether or not he should be cooperative or testify. And the President charged me with conveying that information to Mr. Liddy. I got in touch with Mr. Tom Kennelly, who's local counsel for Mr. Liddy, passed that message on to him. I was there after a call around midnight by Mr. Maroulas, who's principal counsel for Mr. Liddy, and imparted the same information, namely that if Mr. Liddy was not cooperating out of any sense of misguided loyalty or loyalty to the administration or what have you, that he was misguided and the President wanted him to cooperate. And Mr. Maroulas thanked me for the information, and that was it. We have not heard from Mr. Liddy.
Did the President ever tell you anything else that was discussed in his conversation with Dean on April 15th?
No, I did not want to hear it. And the reason I did not want to hear it is because we were in a negotiation with Mr. Dean. And that negotiation was predicated upon certain promises, that he would make certain disclosures to us in order for us to determine whether or not immunity should be accorded. Upon our representation that we would not use that information directly or indirectly against him if no deal was struck. So I did not want to receive information that came from Mr. Dean, from any other source, in order to keep that situation, very difficult situation, as clean as it could possibly be. The President offered to let me hear the tape, and I didn't want to hear it.
Up until the time of, April 30, when Dean was discharged, had Dean told the prosecutors anything that would in any way implicate the President in obstruction of justice or anything along those lines? Did he mention a September the 15th conversation, for example, that he had previously told the President these matters and the President had failed to act?
No, sir, Mr. Dash. As late as April 27th, I can be very certain about that. On April 27th, I received a call from the President who said, do you have any information that would reflect on the President in this thing? I said, no. And he said, would you come over? And I did. Went over to the White House, and he repeated the question, and I said, no. I said, I don't have that type of information. I'm sure the prosecutors do not. If they did, they'd convey it to me immediately. And we discussed it.
Did you state the basis of his concern?
Yes. The two reporters, one from the New York Times, one from the Washington Post, had posited the question at the White House press office, with the implication that this information was in the hands of the prosecutors. Well, he said, well, would you mind calling to make doubly sure? And I did not.
What exactly? What information? That the President was somehow involved?
Somehow involved. It was just as general as that. I said, yes, I would call. I went into the cabinet room and made a call, called Earl Silbert, and told him of the report that had been received at the White House press office, and he said absolutely no, there was no such information available.
All right. And I understand you say that on April 15, when you discussed the fact that you felt Haldeman and Ehrlichman should be dismissed, the President said in effect that shouldn't Dean be dismissed also? They all seemed to, he seems to be involved to a certain extent.
It was certainly clear that the President wanted to treat all three alike.
And that because of your suggestion, evidently, the President waited until April 30 before dismissing Dean.
That's right.
And he was kept on the staff primarily, as far as you know, because of your request that
in the interest of the prosecution, yes, sir.
Yes, sir. All right. Thank you, Mr. Petersen. No further questions, Mr. Chairman.
Mr. Petersen, is it not a part of the judicial process that witnesses shall go before grand juries if they are able-bodied and available so that grand jurors may interrogate them?
That the grand jurors may interrogate them? Yes, sir.
Yes. Now, I'm not an expert on federal statutes, but I've searched in vain for any federal statute or any rule of court which would exempt from a personal appearance before a grand jury any witness who is able-bodied and readily available to the grand jury. Is there any such statute?
No, sir.
Now, there were three White House aides, Colson, Young, and Crow, and former Secretary Maurice Stans, who were exempted from going before the grand jury in person.
I think we ought to clarify that, Mr. Chairman. Colson, Crow, and Young, I don't believe were subpoenaed. We just decided that we wanted their testimony, we wanted it under oath, and we did not use the subpoena process. So to that extent, there's a distinction between what we did with Stans. At the outset, we were going to take Stans for the grand jury, and we issued a subpoena for that purpose. Yes. So that's a distinguishable situation.
Now, there is no statute that allows a witness to be exempted from going before a grand jury to avoid publicity that's distasteful to the witness.
No, sir. I think it's a question of fairness versus prudence.
Now, as you correctly stated, all witnesses don't go before grand juries. But isn't it customary, indeed, isn't it a proper practice to send before a grand jury every witness whom the prosecutor has reason to believe can give testimony which would afford a reasonable basis for indictment against anybody?
With all deference, Mr. Chairman, I think that's too general. You know, many times we present only the minimal number of witnesses and rely on hearsay information, which is admissible in a grand jury. For example, we might put 2 bureau agents on who implicate 7 people.
Well,
and rather than call all the witnesses that would be necessary at the trial, we just call 1 or 2 for a grand jury.
Well, it certainly is desirable to send for the grand jury every witness that can furnish a basis for the indictment of a person who otherwise might not be indicted, isn't it?
You know, you say desirable, and I guess that's right. But, you know, what I want to try and portray is not every witness in every investigation goes for a grand jury. Indeed, in most investigations, most witnesses do not go before a grand jury. Now, I think, again, to be perfectly candid and honest with you, you have to distinguish between the types of investigations. A matter of presentment, you know, where the case is open and shut and the investigative agency has dug it up and there's no problem, the agent can go in and 1 or 2 witnesses and you put it in. Now, in an investigatory grand jury where you're really out swinging and you've got to get them under oath and you want the compulsion of the grand jury appearance, you're right. It customarily is the practice to bring them all aboard.
Well, very shortly after the break-in was discovered, the prosecutors were in the possession of evidence which showed that the 5 burglars caught red-handed in the Watergate 4 of them had in their possession monies which were traced to sums or checks contributed to the re-election campaign, weren't they?
Checks, sir?
Yes.
And cash.
Cash. Which was traced.
To
yes, checks which had been donated to the re-election campaign.
Right. Yes.
Now, didn't that indicate to your mind very grave suspicion that the tracks led from the Watergate into the committee to re-elect the president?
Bet you sure did. You know, but here's the point, Mr. Chair. And that was visceral. We didn't have the evidence. We had 5. We added Hunt and Liddy by dint of investigation. You know, I never believed that Liddy was the be-all and end-all, but, you know, I could not, as Assistant Attorney General, come out as a public official and say there's more involved because I couldn't prove it.
Well, you had the serial numbers, evidence of the serial numbers of the bills from the Miami Bank, didn't you? Which showed they'd come out of the proceeds of these checks.
Yes, sir.
You had the fact that Liddy was the chief counsel of the Stans Committee to re-elect, the Finance Committee to re-elect the president.
Absolutely.
You had the fact that McCord was the chief security officer of the Mitchell Committee to re-elect the president, and you had the fact that Hunt was acting in collaboration with Liddy and McCord.
That's right.
Now, you also knew the fact that Morris Stans was a man that had control of the money of the Finance Committee to re-elect the president.
Yes, sir.
And you got some evidence, didn't you, pretty early, that he kept large sums of cash in safes in his offices.
Yes, sir.
And you had the fact that Mitchell was a political chairman and that Magruder was the deputy political chairman under Mitchell.
Both Mitchell and Magruder appeared.
And also you had available the testimony if Stans gave the same testimony he did before this committee. You had the testimony from Stans to the effect that Sloan, the treasurer, had expressed misgivings about paying large sums of cash to Liddy on the orders of Magruder, and that Stans had gone to had come back to Sloan and reported he had consulted with Mitchell, and that Mitchell said it was all right to pay the money to Liddy to Liddy on Magruder's orders.
Yes, sir.
Yes. And still no effort was made to indict Stans or Magruder.
No, that's not correct, Senator.
Or Mitchell on that evidence.
That's not correct, Senator. We just didn't have the evidence. We had real strong suspicions. We had a real gut reaction. We didn't believe that story, but we couldn't prove the perjury, for one thing.
Well, what story was it you didn't believe?
We didn't believe that Magruder, Porter, Mitchell, Stans didn't know what that money was for, that they gave $350,000 to Liddy or thereabouts, whatever the amount was, and he just expended it. That was the story.
I know.
And that was the reason.
You didn't believe that story, did you?
No, but that was the reason. Now, you're talking about the conduct of the investigation.
Yes.
And here's what we had in mind. We recognized that there were problems in that case, but all the evidence showed was that Liddy and Hunt were involved. That was the reason at a very early date, as early as November, we decided, one, we'll prosecute them, and two, after they're prosecuted, we'll immunize them. Now, one of the things that, you excuse me, Senator, I got to get something off my chest.
Yeah.
You know, I resent the appointment of a special prosecutor. Damn, I think it's a reflection on me and the Department of Justice. We would have broken that case wide open, and we would have done it in the most difficult of circumstances. And do you know what happened? That case was snatched out under us when we had it 90% complete.
Yes.
With a recognition of the Senate of the United States that we can't trust those guys down there. And we would have made that case, and maybe you would have made it different. But I would have made it my way, and Silver would have made it his way, and we would have convicted those people, and we would have immunized them, and we would have gotten a breakthrough. Now, I'm not minimizing what you've done or the press or anybody else, but the Department of Justice had that case going, Senator, and it was snatched away from us, and I don't think it's fair to criticize us because at that point, we didn't have the evidence to go forward.
Well, I'm just
Excuse
asking.
my emotion, but I've been there too long, and this has been a terrible year.
I'm asking you I'm just asking you some questions. Now, at an early stage, before any indictments were returned, they had men caught in the Watergate, plus the general counsel of the committee, plus another aide of the committee, and evidence that money came out of the committees to re-elect the president to Liddy in vast sums. Now, why wasn't that sufficient evidence to make out a probable cause to believe that people in the committee to re-elect the president had hired these people to burglarize the Watergate?
Well, the simple fact of the matter is that the testimony was that those funds were made available to Liddy to conduct an intelligence operation for the committee to re-elect the president, and Liddy had gone off on a gambit of his own. That was the testimony.
And I believe you stated that the prosecutors didn't believe what Sloan had to say about the money. Oh.
What Sloan had to say about what Magruder had to say about the money.
What Magruder has had to say about the money.
That's the reason we called John Mitchell to the grand jury, just because we just didn't believe Magruder.
Well, this is not any criticism of you, Mr.
Senator,
Petersen. I
understand.
Yes. Oh.
Just excuse my emotion.
Yes.
The simple fact of the matter is that every lawyer tries a case differently, and I am too sensitive about criticism of the Justice Department, I confess.
Well, sir, I've been impressed the time I've been in Washington, a few contacts I've had with you, and also of your reputation that you're a very forthright individual, and you have testified in a very forthright manner here, and you've also testified in a very forthright manner in respect to the questions that have caused me concern.
Well, I respect you so much it bothers me when you disagree with me, but...
Well, I practiced law a long time, and I always disagreed with at least half of the lawyers I came in contact with, and so it's no reflection on you.
I'd rather be on your side.
Senator Baker.
Mr. Chairman, thank you very much. Mr. Petersen, I don't want to prolong this analysis of the situation before the grand jury or the status of the ongoing investigation and the efforts toward prosecution much longer, but there are a few points that are a few questions I'd like to put to you, and maybe even a few observations that help me put it in perspective. To begin with, there is no assurance that no one isn't going to be indicted now. Stands any number of others who may be indicted as a result of the ongoing investigation of the grand jury now in the hands of special prosecutor. There is no current threat of the bar of the statute of limitations in that respect.
No, sir, that's correct, Senator Baker, but I have to say I cannot give you a precise status report since the case has not been with us since the appointment of the special prosecutor.
I understand that, but the point of the matter is the fact that people have not yet been indicted doesn't mean that they necessarily won't be indicted.
No, sir, that's correct. I anticipate that they will be.
And just to keep things in perspective, isn't it so that it's your duty as a government attorney, it's your duty as a member of the Justice Department in supervising the proceedings before the grand jury to go into the factual situation to determine probable cause, which is the test before a grand jury. Is there probable cause to believe that a crime has been committed and that a particular named individual committed it? Now, that's the technical and literal function of the grand jury.
That's right.
But you have a greater responsibility than that if you're going to prosecute that case, because the test at trial is not probable cause.
Precisely.
The test at trial is this man, as the Constitution provides, is this man guilty of the alleged crime, of the charges laid against him beyond a reasonable doubt? And that's a very different thing, isn't it?
That's precisely right,
Is
Senator.
it the practice of the Justice Department, or is it your practice to proceed then to try to compile the evidence not only to meet the test of probable cause, but to meet the test that's necessary to gain a conviction in that case as well?
Absolutely. It's a professional responsibility. And indeed, we have a rule of thumb down there that the guy who returns the indictment ought to try it.
Has there been anything in the handling of this prosecution by you, by the U.S. Attorney's Office, by the Assistant U.S. Attorneys, or anyone else that you know of connected with the Justice Department that, in your judgment, Mr. Petersen, has jeopardized the possibility of showing probable cause or guilt beyond a reasonable doubt of the several people that we've spoken of?
No, sir. I have to say that we're not perfect prosecutors, and my guess is if we went over it again, we'd do some things differently. I don't know anything specific.
I know a few things, and I'm going to get to those in a minute.
Okay, but I don't know of any instances where I can say we impaired the investigation.
But in any event, the blackboard is still blank.
Yes,
the grand jury has yet to act on many of the principal characters who are being investigated in this respect. Just a word, the chairman and I have jousted and disagreed slightly, and I hope mutually agreeable way on the question of the appropriateness or the legality or the desirability of giving testimony outside a grand jury. It happens, I agree with him. I think it's not good judgment, but as we've already agreed, I think it is not illegal. Let me ask you this one point, though. Just take the Stan's testimony as a particular illustration. As I understand it, you put it in these terms. We took the Stan's testimony under grand jury conditions, which means I take it under oath with an investigation or examination conducted by a U.S. attorney without other people present, including the absence of the witness's attorney.
That's right.
You did it that way. Now, was the transcript, the write-up of that material, then presented to the grand jury?
Yes,
was
sir.
it read to the grand jury?
It was made available to the grand jury, and that was not it was read into the grand jury.
Was there any step taken to prevent the grand jury from asking for Mr. Stans to appear then or later?
No, not at all.
Is there any prohibition against it now, or any impediment that's in the way of this or any other grand jury?
No, sir.
From now calling Stans to find out? Do I understand then that your motivation, and whether we judge it to be the right decision or the wrong decision, isn't important to this, but it was your motivation at the time that an investigation of public officials has a high degree of sensitivity because of the potential for harm as well as the potential for justice. That is, if charges are made against a public official in a public place. The story on page 38 that they found nothing on which they might indict him fades into insignificance by comparison to the original charges that he appeared before the grand jury.
There was another factor. When Ehrlichman called and was criticizing us for harassing Stans. One, he had been interviewed twice. And I said, we wanted that testimony under oath, and if there was anything more, and Ehrlichman said, well, that's all you're going to get. And I said, well, that may be, but we want it. But the part of the problem was that in that investigation, as you all know, there were far too many leaks. The grand jury was not functioning as the grand jury should. The grand jury, there was not the secrecy surrounding it. Indeed, you could follow the investigation from the newspaper, as I did.
And every leak from that grand jury was a felony, was it not?
Well, at least contempt, probably. But you see, if it's a leak by a witness, it's not. That's part of the problem. And there are an awful lot of self-serving statements by witnesses after they come out of the grand jury, indeed statements of what they testified to. So that we were, to the extent that we were responsible for the grand jury, subject to some criticism because all of this publicity surrounded it, and we were all sensitive to that.
I'm about to run out of time, Mr. Petersen, but
I'm
let me
sorry
ask
for
you two or
being so
three other
long-winded,
things.
Tom.
All of the statements that the chairman made about the money chain, about the information that was available to you on the identity of Liddy, on the identity of Hunt, and any number of other people, all of that information that the chairman very properly identifies as an integral part of this record was, in general terms, or maybe very literally, was all of that presented by one witness or another to that grand jury?
Sir.
So it wasn't withheld from the grand
sir.
jury. All of that information appeared before the grand jury. As far as you know, there may still be indictments on the basis of that information. And as you point out, a grand jury is perfectly entitled to hear hearsay information.
And that grand jury was not unaware of its rights.
How often is it your experience, Mr. Petersen, that you call a potential defendant before a grand jury? I know it's often done, but is it the rule or the exception?
It's the exception. Indeed, there's a specific rule of law which requires if you call a putative defendant before a grand jury, you specifically warn him of his rights.
That he is a target and that he may be indicted.
He is a target, that's right, yes,
and
sir.
There's some talk about there's no statute that authorizes you to take testimony outside the hearing of a grand jury. There's no statute that requires you to place a witness before the grand jury either, is there?
No, sir.
Now, Mr. Petersen, your own investigation, obviously, and the conduct of it, your motives in taking the Stans testimony and the manner in which it was done is suspect in the eyes of some. Otherwise, we wouldn't be inquiring into this, and I suppose you wouldn't be a witness. Let's get something straight on the record here. Were you appointed your present position by President Nixon?
To my present position, yes, sir.
How long have you been with the Justice Department?
Since 1947.
And how did you first receive employment and under what conditions?
I walked in and asked for a job, and they gave me a job as a messenger. Didn't have anything low.
Are you the first assistant attorney general that's ever come up through the ranks?
I guess. I really don't know.
Are you a Republican or a Democrat?
Well, I like to think I'm nonpartisan, but I'm a registered Democrat.
Is there any reason that you can think of why you would not conduct and did not conduct an energetic, vigorous investigation calculated to do nothing except to prosecute those that you could find the evidence to prove their guilt beyond a reasonable doubt?
No, sir.
Is that
the one thing arguing in favor of that is my own selfishness. I've been there too damn long to jeopardize my reputation for anybody. And I told Attorney General Kleindienst that immediately after this, that I wasn't going to jail for anybody, and he could expect political pressures. And if he was smart, he'd do just like I do, have a selfish regard for his own reputation and for the reputation of the Justice Department, and he did, and so did I.
Mr. Petersen, can I change the subject in the few brief moments I may have left? I'm told I have 1 minute.
I understood your testimony to be that you'd agreed not to use the Dean testimony unless you could reach an agreement, I assume, about immunity.
Yes, sir.
Is it fair to say that Mr. Dean did generally cooperate with you at that stage in the proceedings?
No, well, Mr. Dean was advancing his own interest at that stage of the proceeding. It was entirely a preliminary negotiation and never proceeded to fruition.
Was his information materially helpful to you at that point in which he was giving you information so that you could judge whether or not there was the basis for immunity?
That information did not satisfy us that we should immunize Mr. Dean.
Was it a question of deciding what you were going to get versus what you were going to give?
That's always a consideration, yes, sir.
That's the general immunity question, isn't it?
Yes, sir.
Is that still an open question with Mr. Dean?
That's a judgment a special prosecutor would have to make, whether or not it's open. Senator, we're on a very dangerous area.
Would you prefer that we didn't talk about it?
Yes, because I think this is going to be a seriously litigated issue.
Thank you, Mr. Chairman.
Senator Talmadge.
Mr. Petersen, I've been tremendously impressed with your forthrightness and your candor as a witness.
Thank you, Senator.
You've had a long and distinguished career in the Justice Department and came up from the ranks. And the President appointed you to a position of enormous responsibility. Now, under those conditions, where does a man's loyalty lie? You have testified that when the President of the United States gave an order, you clicked your heels. Yet within a very short period of time, you found that some of the closest confidants, most trusted aides and advisors of the President of the United States were involved in a campaign to obstruct justice. Under those conditions, what does a man do?
Senator, I don't know. You know, about 3 weeks ago, I was at a party, and present was the president of Gonzaga High School in Washington, D.C., which I attended. And, you know, they're strong on philosophy. And one of the questions I raised with him whether or not loyalty was a valid philosophical concept. And I've reached the conclusion that it is not, because it is not sufficiently broad, that it's valid only to the extent that you can be loyal to what you regard as a good. And to the extent that there is a demand for loyalty to which you regard as a bad, you cannot subscribe to it. So if the President of the United States asked for FBI reports, I would assume the President of the United States, the Chief Executive Officer, in a proper exercise of his authority, would have a right to those reports to determine whether or not his underlings were serving the best interest of the United States. Now, on the contrary, if the President of the United States said, I command you not to exercise your statutory obligation with respect to immunity in this instance, and the President and I debated that, and we reached the conclusion that that was my responsibility and there was anything in the world that he could do to take it away from me. So your question's a good one, and I've struggled with it. And, you know, I don't want to say I'm not loyal. You know, that's a terrible thing to say. But I have to say that I am loyal to what I regard as my principles, and to the extent that others adhere to those principles, I'm loyal to them too.
You went back to see the President and you persuaded him to change his mind. What would you have done if he hadn't changed his mind?
On the Ellsberg thing?
Yes.
Well, Mr. Kleindienst and I discussed that, and if the President had not agreed with us, we would have had to resign, and we were both prepared to do so. We discussed that before Mr. Kleindienst went to the White House that afternoon. Yes, sir.
You had agreed to do so.
Yes, sir.
A final question. Do you think the Office of Attorney General and its assistant serves the President of the United States or the people of the United States?
I think 98% of the time that he does both. I think where there's a conflict, he has to adhere to his legal and professional responsibilities, which are, I think, to the larger mandates of the Constitution of the people of the United States.
You think then when a conflict would arise between serving the President of the United States and the people, it would be a matter of conscience, the canons of ethics, the laws, the Constitution, and judgment?
Now, I think that there's certain obligations in the concept of loyalty that are required in that situation. I think that it's incumbent to be forthright with a president, to say, I disagree, and give him an opportunity to replace you with a cabinet officer who's presidential appointee or whatever, who happens to adhere more to the line that he thinks. I think that degree of loyalty is required, but I think basically the old adage, to your own self be true.
You made a very impassioned plea there, rejecting the idea of a special prosecutor.
I said I resent it. I didn't reject it. I recommended against it in the first instance. I reluctantly came to the conclusion that it was necessary. It was necessary because of the temper in the Senate of the United States. I don't at all agree with the Senate's insistence on the appointment of a special prosecutor. You know, Senator, Mr. Hoover had a basic concept for which he was sometimes criticized, and that is that you don't wash your dirty linen in public. He had problems during the times he was within the Federal Bureau of Investigation, and he handled those within the Bureau quietly and efficiently and expeditiously. And the footnote and the principal point in connection with that was the importance of the people of the United States in having confidence in their law enforcement agencies. And I don't think it did a service to the Department of Justice or the people to insist on the importance of appointing a special prosecutor at that point in time. I think it could have been handled differently. I think the Senate committee could have called the prosecutors up there in executive session and said, what do you got? Let's see what kind of a job you're doing. Subject them to some time of scrutiny. And if convinced that they were doing a decent job, go ahead and let them do it. But to appoint a special prosecutor means that the Department of Justice, a vital institution, one of the oldest cabinet agencies, one of the foremost principles of civilized society, is inadequate to do the job it's appointed to do. I think that's terrible.
Pursuing that one point further, who made the decision to appoint the special prosecutor?
I think the President recommended it.
It was what I thought. You inferred that it was a Senate.
Well, you know, that's my point of view, and it may be that I have a biased point of view. My own point of view is that, well, first of all, the President didn't want to do it. I didn't want to do it. I recommended against it. Kleindienst recommended in favor of it. From my point of view, it was the Senate's insistence that precipitated it, and I think it's unfortunate. I finally reached a conclusion at the latter stage of the proceeding and told the President the situation's deteriorating too rapidly. As much as I regret it, I think that there's such a lack of confidence that you've got to recommend that it be done.
Now, you're referring to washing the dirty linen. This was not the dirty linen of the Department of Justice, but the dirty linen of the people of the United States, was it not, Mr. Petersen?
Yes, sir. But when I say that, I say in a very selected sense. The implication being that the Department of Justice was incompetent to do the job. That is, that there was something wrong with it. Not that the Department of Justice was responsible for these acts, but the Department of Justice in the exercise of its professional responsibility was unable to do its job. Dirty linen only in that limited sense, Senator.
Mr. Chairman, I have no further questions. Mr. Petersen, again, I want to compliment you on your eloquence, your forthrightness, and your candor, sir.
Thank you, sir.
Senator Garney.
Thank you, Mr. Chairman. Perhaps I might take a little bit of the heat away from you, Mr. Petersen, by giving you my own ideas of why a special prosecutor was appointed. I remember a meeting that the Republican senators on the Judiciary Committee had with Mr. Richardson before his confirmation proceedings. It's customary for a nominee to come around and visit with all of the senators, Republicans as well as Democrats. And it was the unanimous advice of the Republican senators on the committee to Mr. Richardson that if he wanted to be Attorney General, he'd have to appoint a special prosecutor. I think I'm saying what you really didn't want to say. It was a political decision, and it was our advice that if we're going to have an Attorney General, we'd have to have a special prosecutor. Now, this is not to say...
I would have applauded him if he said, you take me or leave me.
This is not to say that the idea was a good one or a bad one. It is to confirm your, I think, implication that there were some politics connected with it. And I'm not indicating that the politics were good or bad. A lot of decisions in Washington are made with political overtones as well as other things, because that's what government is all about.
Prosecution is a political act in the broadest sense of the term, you know.
You were about to answer a question that Mr. Baker posed to you about the grand jury, and you didn't complete it, and I was curious. You said that the grand jury was not unaware of and then stopped.
Yeah. The grand jury was aware of its right to insist on calling people. Indeed, we had explained to them what the situation was and what the publicity problem was, and they understood at the time of the Stans subpoena. But thereafter, Mr. Stans and Mr. Mitchell appeared for civil depositions, and Mr. Stans and Mr. Mitchell were making statements to the press. And the grand jury, very rightly so, well, if they're doing this, there's no reason why they shouldn't come up here, and we said that's fine. And so we said, all right, they wanted to hear Mr. Mitchell. There was no real substantive reason at that point on the record. They didn't believe Magruder's story, and they wanted another witness to say whether that was true or false, and they subpoenaed we subpoenaed John Mitchell. Now, the grand jury was aware at that point that they could have issued their own subpoena if we had refused, or that they could have gone out and said the prosecutors won't subpoena him. They were not unaware of what they could do.
Incidentally, back to that special prosecutor issue again. I remember I was asked, not once but many times, about my own opinion on a special prosecutor, since I was on the Judiciary Committee, as you know. This is more in appearances back home in Florida politically. And I said, I don't think we ought to have one, because I think one of the things we need more than anything else is to get these people indicted and tried as soon as we can. I think that's what this country needs more than anything else, to clean up Watergate in the courts so that the people will have confidence in the system, particularly the judicial system. And the appointment of a special prosecutor, as I see it, is simply going to slow this process up by certainly many weeks and maybe many months, because the new men that are going to be brought in are going to have to completely brief themselves on matters that have been going on now for many months.
That's true.
And I'd like to ask you, as the Assistant Attorney General in charge of this whole affair, isn't it a fact that we have slowed up justice by doing this, and that the indictments are going to be held up, and then we're not going to get the justice we should have gotten until a long time after we could have gotten it? Isn't that a fact?
Well, I think that is a fact, and we're all in favor of speedy justice. And it's going to be delayed in this instance. But I have to say, and I'm happy to say that you agreed with me, but I have to, especially since you have a different perspective. But, as I've thought about this thing, and I certainly would have taken that position, same position with you all. Indeed, I plan to come to see Senator Irwin as I took with Senator Patman, urging you not to conduct the hearings and what have you. But if I had been a senator of the United States, I'm not at all sure that I would have taken the same position.
Well, I think all of us, with hindsight and 20/20 vision, would have made different decisions. But now I'm talking about...
All I'm saying is that I can respect the point of the committee, that there are larger interests in here than simply the prosecution. That is a valid point of view.
I think there are, too. And I think now that all of the dirty linen has come out in these hearings, and now that we know as much as we do about this whole Watergate affair, it's probably better that we have a special prosecutor, just to make sure that everybody understands that the prosecution is being done by somebody who's independent of the administration. But that wasn't the point I was making.
I understand.
The point I was making is that actually justice would have been more speedily arrived at.
We paid a price.
If we hadn't gone in that direction.
Yes, sir.
Did you know at any time, Mr. Petersen, that Haldeman and Dean were trying to get the CIA to stop the investigation of the FBI as far as the Mexican money was concerned?
Only to the extent of Pat Gray's conversation with me on or around July 5th.
What did he tell you at that time?
He didn't tell me that he had been contacted by the White House. He did tell me that he had been in contact with CIA, and that there was it was a very guarded conversation, type of thing. Well, you need to know situation. And I simply said, well, that may be, but don't accept that unless you accept it in writing. But I had no more information on it than that, Senator.
But you didn't know anything about the White House involvement?
No, sir.
Just the CIA?
That's right.
Any time during this whole sad affair, either last year or this year, until, of course, the events that transpired in around April, did anybody try to pressure you to stop or slow down or soft pedal this investigation that you were in charge of?
No, sir. The only thing that could be possibly casting that category would be the call from Ehrlichman with respect to the stand subpoena. And, frankly, that didn't bother me that much. As I told Kleindienst, he just made a mistake. But no one else. Now, there was some pressure,
confidence in the system, particularly the judicial system. And the appointment of a special prosecutor, as I see it, is simply going to slow this process up by certainly many weeks and maybe many months, because the new men that are going to be brought in are going to have to completely brief themselves on matters that have been going on now for many months.
That's true.
And I'd like to ask you, as the Assistant Attorney General in charge of this whole affair, isn't it a fact that we have slowed up justice by doing this, and that the indictments are going to be held up, and then we're not going to get the justice we should have gotten until a long time after we could have gotten it? Isn't that a fact?
Well, I think that is a fact, and we're all in favor of speedy justice. And it's going to be delayed in this instance. But I have to say, and I'm happy to say that you agreed with me, but I have to, especially since you have a different perspective. But, as I've thought about this thing, and I certainly would have taken that position, same position with you all. Indeed, I plan to come to see Senator Irwin as I took with Senator Patman, urging you not to conduct the hearings and what have you. But if I had been a senator of the United States, I'm not at all sure that I would have taken the same position.
Well, I think all of us with hindsight and 20/20 vision would have made different decisions, but now I'm talking about...
All I'm saying is that I can respect the point of the committee, that there are larger interests in here than simply the prosecution. That is a valid point of view.
I think there are, too, and I think now that all of the dirty linen has come out in these hearings, and now that we know as much as we do about this whole Watergate affair, it's probably better that we have a special prosecutor, just to make sure that everybody understands that the prosecution is being done by somebody who's independent of the administration. But that wasn't the point I was making.
I understand.
The point I was making is that actually justice would have been more speedily arrived at.
We paid a price.
If we hadn't gone in that direction.
Yes, sir.
Did you know at any time, Mr. Petersen, that Haldeman and Dean were trying to get the CIA to stop the investigation of the FBI as far as the Mexican money was concerned?
Only to the extent of Pat Gray's conversation with me on or around July 5th.
What did he tell you at that time?
He didn't tell me that he had been contacted by the White House. He did tell me that he had been in contact with CIA, and that there was It was a very guarded conversation, you know, type of thing. Well, you need to know situation. And I simply said, well, that may be, but don't accept that unless you accept it in writing. But I had no more information on it than that, Senator.
But you didn't know anything about the White House involvement?
No, sir.
Just the CIA?
That's right.
Any time during this whole sad affair, either last year or this year, until, of course, the events that transpired in around April, did anybody try to pressure you to stop or slow down or soft pedal this investigation that you were in charge of?
No, sir. The only thing that could be possibly casting that category would be the call from Ehrlichman with respect to the stand subpoena. And, you know, frankly, that didn't bother me that much. As I told Kleindienst, he just made a mistake. But no one else. Now, there was some pressure, you know, get the indictment out, get the indictment out. They wanted it out by September 1st, and we couldn't do that. I frankly promised them September 1st. We couldn't do it until September 15th. That didn't impair the investigation. We were ready to go to trial in November, but Judge Sirica had a bad back or something and continued the thing on his own motion.
Let me inquire about the contacts you had with the President of the United States. The log here shows a great many phone calls as well as some meetings. Of course, you have covered them, some of them.
Some of them, yes, sir.
What about those 4 phone calls which the President initiated to you after your afternoon meeting with him on April the 15th? What were those about?
Well, the first was, should I meet with John Dean? Yes. The second was, a meeting's been set up. The third was, if Liddy's not talking because of any sense of misguided loyalty to me, you better disabuse him. And I am issuing orders to you to that effect. The fourth was, I've had a meeting with Dean. He's given me basically what he's told you, and I think it's been helpful.
Without going over all of these, because I know you've covered some of them, but I can't identify what you have and what you haven't. Generally, what was the President calling you about during this period of time and these...
The status reports. Status reports, immunity, the Ellsberg thing, Strawn's testimony. You know, we had Strawn like this, and Magruder on one side and Strawn on the other, and we finally decided to put them both in a lie detector. He wanted to know how they came out, that sort of thing.
He was keeping them almost in daily touch, and sometimes, of course,
yes,
several times a day just to find out.
But there's one qualification I ought to put. The President had asked me to give me, after I gave him that initial memorandum, give me a complete memorandum of everything you have on the White House personnel, and I caused an examination of the records to be made, and finally I had to tell him. As we had previously agreed, Mr. President, I cannot produce all of that other information as grand jury information, and we had previously agreed, he and I, that I should not disclose grand jury information to him.
One general question here, I don't know whether you can put a handle on it or not, but during all of this investigation and trials and everything, did you at any time suspect that there was a cover-up going on of Watergate? Have a feeling, I'm really trying to say.
Yeah, I had a visceral reaction. I used to say, well, the words I used to the prosecutors and the Kleindienst, nobody acts innocent. You couldn't translate that. There was an overriding concern. There were no records. Things were destroyed. Well, they just didn't act like innocent people. Innocent people come in and say, fine, what do you want to know? It was not like that. There was a visceral reaction. Yes, you know, that's the reason we were so insistent that we'll get this thing, get them tied down to sentence and then immunize them.
And it was your thought that when you got to that stage of the point, you'd get probably what happened after McCord got the message from the judge.
Well, that's right.
One other thing. The Senate, of course, out of our hearings and some of these confirmations we've had during the last year, and especially the Gray confirmation hearings, have been concerned about the status of the FBI. Suggestions have been made, and one or two senators are very impressed with the idea, perhaps, of setting up the agency as an independent agency and out from under justice. As one who probably has had as much experience with the FBI over the years, at least in preparation of evidence for criminal cases, what would be your own opinion on that, Mr. Petersen?
I would be reluctant to see that done. Like most things in a democracy, decisions are a result of compromise, and you operate at a lower level of efficiency than is maximally possible, I think. That may be so. You might have a more efficient investigative agency if you separated them, put them out, but I would find it a little frightening. I think they ought to be subject to some degree of political control. You see, it's very strange, Senator. You know, before Mr. Hoover died, he was criticized for his independence. You know, and after he's dead, you know, the Bureau is being criticized because they're not independent enough. Now, whichever is the truth, I think it points up something that's very important. The Bureau ought to neither be independent nor completely dependent. And I think the answer is to have a strong investigative agency under the charge of the Attorney General. I think the Office of the Attorney General is a very, very difficult one. I think that he ought not to have the responsibility of presidential advisor. I think he ought to be the Attorney General of the United States, in charge of litigating the government's business, in charge of investigation. But I don't think he ought to be either political or legal advisor to the president.
Put it another way, you think that perhaps the dangers of political supervision are less than a total independent investigating agency?
I think so, yes, sir.
Thank you, Mr. Petersen. That's all, Mr. Chairman.
Getting the cooperation of the mysterious G. Gordon Liddy is the subject of Senator Inouye's questions in just a moment. Public Television's coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Senator Inouye now asked Petersen about Gordon Liddy's cooperation in the investigation.
Senator Inouye.
Thank you, sir. Mr. Petersen, in his testimony before this committee, Mr. Dean stated that he informed the president that, quote, perhaps Liddy would agree to cooperate if the president would meet with Liddy's lawyers and give the signal that Liddy was apparently waiting for. This is supposed to have happened on or about the 15th of April. He then stated that, quote, the president picked up the telephone and called Petersen and told him that if Liddy's lawyer wanted to see him to get a signal, that the president was willing to do this, end of quote. Do you remember such a call, sir?
Yes, sir, and that was not the context of the call. The question was not that the president was agreeable to seeing Liddy's lawyers. Indeed, if he had suggested it, I would have recommended against it. I don't believe that the President of the United States ought to be involved in the law enforcement business. What the President said was, if he's waiting for a signal from me or from the White House that he should cooperate, I want that signal given and you get in touch with his lawyers immediately. That I did.
What was the signal, sir?
I called Mr. Tom Connelly and I told him that the President had instructed me to get in touch with Mr. Liddy's counsel and have request that they advise Mr. Liddy that the President expected everybody to cooperate in this investigation. Mr. Connelly assured me that he would do so. He conveyed that information to Mr. Maroulis, who's not only Mr. Liddy's counsel, but I'm told a longtime friend. Mr. Maroulis called me at around 12:15 that night to confirm that information. I confirmed it for him, and he assured me he would convey that information to Mr. Liddy.
This afternoon, you testified that you and your prosecutors could not believe Mr. Magruder, especially a story about money. Am I?
That's right, Senator.
If that's the case, and if you didn't believe Mr. Magruder, why did you put him on the stand as a government witness?
Because we couldn't disprove it. All we have was a visceral reaction, what I regard as the poor boy syndrome. You know, in effect, what they were saying is, well, you all don't know how these things operate. Here we have a $30 or $40 million political campaign. $350,000 isn't much. Well,
So
maybe it isn't to them. You know,
so you placed on a stand a government witness you couldn't believe?
No, sir. Well, I just said that. We didn't believe him. Well, that's right. I mean, I had a visceral reaction that he was not telling the truth. But for a prosecutor, we have to go beyond that. And we didn't have any evidence to suggest it. He got on the stand, told his story. He told his story to the grand jury. We couldn't refute it. I didn't like the story, but I didn't have any evidence. You know, all I could say is, it doesn't add up.
Mr. Dean, in his statement before this committee, testified that he called you after Mr. Magruder's appearance before the grand jury in August of '72. Did he call you, sir?
Yes, sir, he did.
He further testified that he asked you how Mr. Magruder's testimony went, and you were supposed to have responded that Mr. Magruder had made it through by, quote, by the skin of his teeth.
That's not correct. I remember the conversation very well because, one, I didn't know the answer when Dean called. I had to call Silbert. I did call Silbert, and Silbert said, one, he's an articulate young man. He made a good appearance, good witness in his own behalf, but nobody believes the story about the money. But the grand jury didn't. They were, again, that overstates it, but they were uncomprehending how such a large sum of money could be given to a man and he had no requirement to file records or to account for it or explain to his superiors how it was spent. And that is the statement that I gave to Mr. Dean. He made a good witness, but nobody believes his money story. And that was where we were focusing our efforts. That's where we were concerned because the records have been destroyed.
I'll read the full paragraph, and if I may have your comments. following Magruder's appearance before the grand jury, I received a call from Higbee requesting information for Haldeman as to how Magruder had done before the grand jury. I subsequently called Mr. Petersen, who said he would find out and call me back. Petersen called back and said he had made it through by the skin of his teeth. I called Haldeman and so informed him, and subsequently informed Mitchell and Magruder. I recall that Haldeman was very pleased because this meant that the investigation would not go beyond Liddy.
I mean, I have no comment except that the obstruction was successful, Senator. I mean, that's what it was. We had lying witnesses. And, of course, that's the problem with the forthcoming prosecution. You've got people who've lied 2 or 3 times under oath.
In July of 1972, soon after the break-in, Mr. Alfred Baldwin, who was in the hotel, I believe, advised the prosecutors that on May the 30th, 2 bugs had been placed in the Democratic National Committee.
I'm not sure of that, Senator.
And after the arrest, they found 1 bug in Larry O'Brien's telephone. Mr. Baldwin had notified your prosecutors that the other one was in Mr. Spencer Oliver's telephone. For some reason, that telephone was not searched. On September the 13th, the CMP telephone company made a sweep and found this bug. And a few days later, the Vice President of the United States and the Attorney General suggested that this bug had been placed in there by Democrats to confuse the issue and embarrass the Republicans. Now, if the prosecutors knew that there were 2 bugs there, why weren't the FBI people notified?
This was a source of concern to the prosecution, Senator. After that second device was found in Spencer Oliver's telephone, we went back to the FBI, and there are records in the files of the Department of Justice reflecting this. A memorandum to me of Mr. Silbert in which he, well, quite literally questioned whether the Bureau was telling the truth. The Bureau said they had checked that telephone and there was nothing there. And the investigation was proceeding on the ground that it may have been installed at a later date or by someone at the committee to exacerbate the situation. We didn't know what the truth of that was, and we asked the Bureau to look into this doubly sure, to make certain that they knew what they were talking about. I'm not at all certain. You know, frankly, I think they missed it, and they didn't want to admit it. That's all. That's my own evaluation of it. One thing about the Bureau, they're never good at admitting their mistakes, I'll tell you.
Mr. Dean, in his interview with this committee, stated that immediately after the break-in, he held a meeting with Mr. Kleindienst and yourself, and at this meeting, it was discussed that although he had no direct evidence, he was afraid that this matter could lead directly to the President. Did he ever say such a thing?
No, sir. As a matter of fact, that whole conversation is entirely miscast. It was Kleindienst and I who were telling him that, you know, obviously this thing had dire political ramifications, and the only thing that could be done would be for the Department of Justice to run it all out, and the President ought to be told. Mr. Dean's statement, perhaps honestly, you know, miscast that in a very favorable light to him. That's all I can say.
I believe my time is up, sir. Thank you very much.
Senator Wyckoff.
Mr. Petersen, I'd like to ask you a question that I've asked other witnesses before this committee. I again refer to the President's statement of April 30th, 1973, in which he states, "As a result, on March 21, I personally assumed the responsibility for coordinating intensive new inquiries into the matter, and I personally ordered those conducting the investigations to get all the facts and to report them directly to me right here in this office. And my question to you is, on March 21st or thereabouts, did you receive any such order from the President of the United States?
No, sir. My understanding of that is that he charged Ehrlichman with conducting that inquiry at that point.
No, Mr. Ehrlichman's own testimony, just so the record stays straight, is that he was charged on March the 30th with that
all
text.
I know is the March 21st date.
Well, now, I wish somebody would answer the question so I don't have to continue to race around this town trying to find out who it was that was ordered to conduct these investigations. I personally ordered those conducting investigations to get all the facts and report them directly to me right here in this office. This committee has received testimony that Mr. Ehrlichman was ordered to conduct an investigation on March the 30th. Mr. Gray has denied that the FBI received any orders. Mr. Kleindienst has denied that the Attorney General, he received any orders. You have denied that you received any orders. Exactly who was it in the city of Washington that was ordered on March the 21st to conduct investigations?
I have no way of knowing. Yeah, the only time I was ever in the White House for any extended discussion was April 15th.
So that at least insofar as this committee has been able to develop the evidence, assuming that the earliest point in time was March the 30th in a directive to Mr. Ehrlichman, we have a gap really of 9 days between the 21st when this new information came to the President and the 30th, which is Mr. Ehrlichman's testimony. That is testimony given before the committee as to when any investigations were conducted. As far as you're concerned, your investigation commenced on the 15th of April. Is that correct?
No.
Well, I mean, in other words, the President put you in charge of this matter on that date. Would that be?
Kleindienst recused himself, and I was the next guy there. That's
all right. Now, there are a couple of questions that came to mind as I kept on reading this statement. This statement was made on April the 30th. And the reference is to new information on March the 21st. There's no reference at all to April the 15th, which I consider to be a rather significant date insofar as the information given to the President, at least information by you and Mr. Kleindienst, or the Attorney General Kleindienst. Nowhere in this memorandum is April 15th mentioned. Nowhere in here is mentioned the fact of your conducting the investigation as of April 15th. Could you give me any reason? Were you consulted at all prior to this statement being made?
the April 30th statement?
The April 30th statement?
I knew that the President was up at Camp David working on something, but I was not consulted with respect to its content, no, sir.
And yet you were the one that was put in charge of the investigation as of April 15th, right?
That's right, but if I had been requested, I think I would have demurred. I didn't regard it as my obligation to, well, you talk about conflict. I didn't want to be, what I just said about the Attorney General, I didn't want to be sitting there advising the Attorney General or the President with respect to what type of statement should come out of the White House. I wanted a free hand to run the investigation. And that was prepared by counsel at the White House.
Now, in the course of that investigation, in the course of your findings, even before you were officially put in charge, did it come as a surprise to you that the Attorney General, Mr. Kleindienst, was arrayed with Mr. Haldeman, Mr. Ehrlichman, and Mr. Dean?
Yes, sir, and I was very disappointed at the President's actions in that regard. Indeed, as a matter of fact, Mr. Kleindienst, in our meeting on April 15th, had raised a question as to whether or not since he was recusing himself, he should resign. And we discussed it, and I recommended against it, and the President recommended against it, so I was considerably surprised and frankly disappointed.
Now, you indicated that on April the 26th, this was the evening in Mr. Kleindienst's office, the evening that Pat Gray returns to talk with you and the Attorney General in his office, that prior to that meeting, you had talked to the President.
Yes, sir.
Okay. And we have evidence from Mr. Kleindienst in the morning that he talked to the President during the course of that meeting. And yet, when the meeting is over, Mr. Gray is still in position. Why wasn't any action? Or can you give me, at least from your conversation with the President, or your recollection, why wasn't Mr. Gray notified right then and there? This is it.
Well, I happened to be in Mr. Kleindienst's office when the prayer call came through.
Right.
The President spoke to Mr. Kleindienst. Obviously, I could hear only Mr. Kleindienst half the conversation. Immediately after he got off the telephone, he said, we have to talk about Pat Gray and what have you. And then the telephone rang again. And this time it was for me, and I walked out to the back office and took it. It was the President. And he asked what I thought, and I told him that I thought Pat's position was untenable, that I thought he was an innocent victim, and I regretted it, and what have you. And he said, well, talk to Kleindienst about it, and the two of you get together with Pat Gray. We called Pat's office, and he was just about to leave, and we ran him down and brought him back there. We sat down and discussed the situation, and not tearful, but almost so. And at the conclusion, Mr. Kleindienst went out. I don't know whether he had another call from the President or went out to make one, but that was it. We left with no decision. I was under the strong impression that Mr. Gray would resign. Thought he had to think it over, and I expected he would think it over. So when he called me the next morning and told me that after a night of thought he decided that he had no other alternative, I was not surprised. That's all I can tell you about it, Senator.
Did you mention in testimony before the committee here this afternoon, and it just slipped by, and I'm not so sure that I understood the context, and I might not have understood the substance either, what you said, that the President offered tape to you?
When the President called on April 18th about the John Dean conversations, on April 5th, the night of April 15th, his question was, has John Dean been immunized? And I said, no. And he said, well, he says he has. And I said, that is not true. And we got into an argument, which was ridiculous, because neither one of us were present when the agreement was entered into. And we said, all right, now wait, I'll check with the prosecutors. And he said, well, I have it on tape. And I said, well, I'll take your word for it. I don't want to hear it. And let me check with the prosecutors. So I called up the prosecutor, and Silbert said no. And I said, well, go back and check with his lawyer. That was the tape he was referred to. Now, I told Mr. Cox about that, and they asked for the White House, and I'm told that the President said that was a statement of tape of his recollections of the meeting. Now, whether it was a tape conversation or not, I don't know, of the meeting, as opposed to a tape that the President made of his own recollections. One or the other is true, but I don't know which.
I'm sorry, I just lost you on that last part there.
One or two possibilities exist. Either that there was a tape being utilized at the time the President met with John Dean.
I see.
Or after the meeting, the President sat down in front of a tape recorder and recorded his own recollection. I don't know which he was referring to.
I see. But in any event, he offered, was it on April 18th?
Yes, sir.
A tape to you of this conversation with John Dean.
That's right.
Yeah. Of his conversation with his conversation with John Dean.
Which I refused to listen to.
Which you refused to listen to, correct. Just two more questions. On September the 13th, 72, dropping back just a little bit.
The date, Senator?
September the 13th, which date, let me give you what occurred there, which might refresh your memory far better than a date. Did you receive a summary memorandum from Mr. Silbert which indicated that there might have been others higher than Liddy and Hunt involved in the Watergate matter?
September 13th, 72?
Back in September of 72?
I don't recall such a memorandum. About the only thing I could think of would be the prosecutor memorandum, which probably came in about that time, just before the indictment. But I think that that's unlikely that there is such a memorandum. If you recall,
But did you get summaries from Mr. Silbert?
No, I didn't get. I got oral reports from Mr. Silbert of the investigation as it progressed, usually on a daily basis. There was a written recommendation with respect to prosecution and the basis of prosecution of the 7 on or about second week in September, just before the indictment.
And was there any indication in that memorandum that more might be involved?
I don't recall, Senator. No, sir.
Then lastly, this is the last question I've got. You indicated with some anger, and I must say I can't blame you, that it was a proof of no, because I can't. You're a professional man. I don't blame you for sticking up for your branch. That maybe there was some sort of lack of confidence on the part of the Senate in you, members of the Justice Department, professional staff over there. Has it occurred to you that maybe the lack of confidence did not exist in you?
Yes. Yeah, I like to think that. This occurs to me every day.
Yeah, I mean,
but I think it's a self-serving thought, Senator.
The quest for the truth, at least in a legal sense, this is something that is looked upon, at least as far as the American people are concerned. They look to the executive branch of government. Don't you think that's true? I mean, rather than to blame it on yourself or feel that there's a relationship between you and us in this matter?
That's what I was trying to get across when I say I would take one position as prosecutor and perhaps another as Senator of the United States. I understand the larger implications. I don't really like it.
I have no further questions, Mr. Chairman.
Senator Montoya.
Mr. Petersen. Mr. Petersen, don't you find it very peculiar that the President offered to play this particular tape with respect to Dean, and he refuses any tapes to the prosecutor downtown and to this committee?
No, not especially.
Why?
I think that, well, let's take attorney work papers. We argue that they're privileged. New counsel comes in to assist old counsel. Old counsel shows him his work papers. That's quite a different thing than turning them over to the other side, to the defendant's lawyer. Now, if the President obviously thinks of this as the other side, at least in terms of the executive versus the judicial or executive versus the legislative branch, I don't think that's necessarily inconsistent, Senator. I think that the President was willing to let me hear it because it was apropos to our discussions, but at that point, he considered me bound by executive privilege. And he had told me so. He subsequently released me, but at that point he certainly did.
Well, couldn't he do this with Mr. Cox?
I don't know. Well, you know, I hesitate to comment on what he could do with Mr. Cox. The questions in litigation, I understand, has been argued today, and it's one of the grand issues of law. You know, it's only been litigated once. It's a very interesting issue, and I don't think I ought to comment on it, Senator.
Well,
I'm delighted to discuss with you in private. But
all right, wouldn't you think that if the President called Mr. Cox and played the tapes to him on an executive privilege basis, that Mr. Cox would honor that commitment?
Well, I wouldn't if I were Mr. Cox. You know,
you what?
I would not if I were Mr. Cox. I would want those things without qualification. It doesn't do him any good to get information that he can't use.
Have you, in the Department of Justice, discussed the significance of keeping the tapes in the sanctuary of executive privilege, the legal significance?
I have not, Senator, discussed it with anyone. I've given it some thought.
What kind of thought have you given it?
Well, first of all, I'm not at all shocked that the President of the United States records conversations. Whether or not he's selective about it is something else. I'm not even shocked that he does not disclose, because to disclose, I think, would put everybody on camera, and you might have some lack of candor on the part of his advisors. I think it's terribly important for the head of state of the strongest nation in the world, to have some record. Let's assume that some visiting statesman comes in there. I don't see any objection to that. I certainly had no objection. If my conversations were recorded, I don't have any objection.
What about the evidentiary significance of the tapes with respect to defendants' rights?
With respect to whose rights, Senator?
Defendants' rights. Or let me ask you the question in this form. Will not the failure to produce the tapes lead to some cases possibly being dismissed, since the information on the tapes could be claimed to be exculpatory in nature?
Well, Senator, I really don't know the answer to that, and let me tell you that it's come up in another context. It comes up in the context of this committee. It comes up in the context of what is now the Jackson Committee, the McClellan Committee. It's one of the questions that we're stumbling with down there, we in the committee. We're not in a confrontation situation, but it's a mutual concern to both of us. We're investigating a case. They're interviewing some of the same witnesses. They take statements from those witnesses. The question, are they producible? They're certainly not producible unless the Senate passes a resolution. If the Senate doesn't pass a resolution, does our case get thrown out? I hope not.
Yes, but you didn't answer my question.
I don't know the answer.
Well, have you given
this
some
situation thought? I know
thought?
it's a problem. Yes, sir. Whether it's from the executive branch or from the congressional branch, the same problem exists.
Well, isn't this in the same category as a wiretap?
No, sir. Absolutely not.
It's not produced in court?
No, sir.
I mean, an illegal wiretap?
No, sir.
Why not?
Because White versus the United States, decided by the Supreme Court approximately 2 years, holds that consensual eavesdropping is not illegal.
And do you mean to tell me that there isn't a court in this land that would dismiss a case against the defendant if exculpatory information was contained in tapes under the umbrella of executive privilege and in storage in the White House?
No, sir. I'm not meaning to tell you that. I'm telling you that that is an issue that concerns us. If exculpatory information is given to another branch of government and the Department of Justice, as the agent of the executive branch, brings a case, it's very conceivable that the Congress of the United States or the President or the courts or somebody else may be required to produce exculpatory information under court order. That's certainly possible.
Well, it would be on that basis and for that reason, wouldn't it?
Well, I'm not sure I get the gist of your comment.
If a court would order the production of those tapes, it would be to protect the rights of defendants.
Well, that would depend on their context. If it was exculpatory information, if the court held that there was no privilege, and if the court held that it was producible, and if the court held that the government was a monolith, and the Department of Justice was responsible for the presidency and the Congress, it's conceivable that they would throw the case out if we didn't produce it, even though it wasn't under our control. Yes, sir.
All right, now I will ask you about your testimony before the committee in private. I have a witness summary here which indicates as follows, and this is paraphrasing your testimony. Sometime after the Watergate break-in, Petersen and Dean had more extensive contacts because of complaints from the FBI or the prosecutors about White House foot-dragging. Now, what did you mean by that?
Well, what happened was the Bureau would want to view X. They would go about it through their own devices. A meeting would be set up, it would be canceled. Or Dean would say, we would set it up, but he would be slow in getting back to them on time. The Bureau would come, foot dragging is my phrase, the Bureau would come and say, you know, we've been after them for a week. I'd call Dean and he would set it up. Or Silbert would say, I've been trying to set up a meeting for the agents with so-and-so. I would call Dean and say, expedite it.
My time is up. Thank you.
When was it that you and Mr. Kleindienst and Dean had a meeting early in the state of the...
Well, Dean testified it was around the Monday or Tuesday following. I really don't recall. It was in the very early stages of the investigation,
Now, did Dean say that the White House couldn't stand an wide open investigation?
No, I don't understand that.
What was it he said that caused you to say that the matter was such importance that it ought to be reported to the President of the United States?
Well, you know, I don't know what he said. I think I was just pontificating, to be perfectly honest with you. Here we had a violation, a burglary of the opposition political party by persons who were identified with the committee to re-elect the president in an election year. And I thought that was of awesome political consequences, and the president ought to really jump out on it.
And you suggested he ought to be notified. His attention ought to be called to it. Now, in the early days of this investigation, didn't it become obvious to you that there was a conspiracy, that this crime was a nature of a crime of conspiracy?
I think that at the outset we considered it a conspiracy, yes,
and,
sir.
It's true that is it not true, as your experience it has been in investigating cases, that conspiracies ordinarily are made in secrecy and carried out in secrecy?
Sir, absolutely.
And in the light of, I don't contend, and I would stand my question to you, this is an easy case to break. I think it was a very difficult case to break, because I think the evidence before this committee indicates that a comparatively small number of men had participated in these matters, and they naturally had a self-interest which would prompt them to try to conceal them. And in the light of testimony here, we have received testimony that sums of money approximating $450,000 were paid to these the original defendants and their counsel and their families, and the inference might be drawn that we're paid to keep them silent. So I don't think it's a very easy case to break. And I do think we need to consider all angles and all viewpoints of this to make a complete picture for the committee. And I want to take this occasion to thank you on behalf of the committee for a very candid and very expressive, very eloquent
You're very generous in your comments.
Mr. Chairman, I have a number of other questions that would be collateral to the main points that have been made by Mr. Petersen and by the members of the committee. I will reserve those, except to say that I too wish to thank Mr. Petersen for his forceful presentation, for the clarity of his expression, for our ability to gain an insight into how the investigation proceeded. We're grateful for that. Thank you.
Thank you, Senator.
Any further questions?
Well, Mr. Chairman.
Any further questions? Any further questions, Counsel?
I have no further questions, Mr. Chairman.
No further questions, Mr. Chairman. Well, the committee want to thank you again for your cooperation. And
Thank you,
the committee will stand in recess subject to the call of the chair.
Quietly, almost offhandedly, the first round of these historic hearings ended today. Hugh Sidey, Washington Bureau Chief and columnist for Time Magazine, and Jack Murphy of the Georgetown University Law Center were with us when the gavel came down, and now I'm going to ask them a couple of impossible questions, beginning with Jack Murphy. Jack, what is your overall view of the state of the evidence at this point?
Well, I don't want to tarnish the great public image which this station has projected in providing this public service by offering a very dumb judgment at the end of Phase 1, so I'm not going to go in any particular detail into what my judgments are in general. I'm going to be as reserved and judicious as I've tried to be throughout these things and give you some sense of where we are without really apprising the audience of what my secret thoughts are.
You sound like a United States Senator.
Well, that's the way I feel these days. I've been sitting here watching them long enough. The fact is, we know now a lot of what happened, but on the state of this evidence, we're not yet sure who was responsible for that. We know, of course, of the bugging. We know the CRP was in some way connected with that. We know of the cover-up. We know of the delays that were occasioned by various activities in the White House, the abuse of the CIA, various other suppressive details have emerged. But who's responsible for that remains very much in question. John Dean's testimony is pivotal to all this, and he has neither been discredited nor totally affirmed. Much of his testimony has been confirmed in general detail, and the great disagreements arise as to the interpretation of what actually was meant by that meeting or this telephone call or that particular phraseology. You have, in defense of the administration and of individuals up to the president, this notion offered. The life of the bureaucracy is hectic, multifaceted. We're doing thousands of things all the time. We couldn't have known necessarily what was going on. Therefore, you must understand the context in which these things were happening. They were separate, disparate, independent, and didn't form a kind of cohesive or conspiratorial image. On the other side, you have the people saying, you can't miss an elephant in the living room. It was right there, and it's impossible to believe that only 1 or 2 or 3 men were responsible for this. It has to have gone higher. It has to have been more of a conspiracy. We cannot accept the notion that you overlooked the elephant, if you'll pardon that image. You have another channel of analysis, people saying the effort has been from the administration to pin this on Dean and Magruder and Mitchell and to save Haldeman and Ehrlichman. And the evidence can be weighed in that fashion. I certainly have no final judgment in that respect. So, in general, we don't have any kind of legal basis for accusing anybody of anything. I was intrigued today by Mr. Petersen's indication that there would be many more indictments of some of the people that we've been discussing. And just as those indictments have not come down from the grand jury, neither will one fall from the lips of this lawyer. But I'm sure we share, and I share with many other citizens, a suspicion that John Dean on his own could not have carried off a cover-up of this dimension and breadth.
And the question to be resolved is who else was helping him, in your opinion. Hugh, you've been in Washington for 17 years and professionally observing presidents of the United States in action. Let me ask you, after 37 days of these hearings, how would you analyze the state of the presidency?
Well, I think we're entering very serious times now for this nation, and also the condition of the presidency, very delicate time. I suspect that the people will go off to the beaches or wherever they go at this time of year, and they will weigh, presumably, not only this evidence, but Mr. Nixon's rebuttal, which is expected soon. They will weigh all of this in their hearts and their minds, and I think there's a tribunal that goes beyond simply the courts or the Senate caucus room, and that is the matter of how each person feels about his president in his heart and in his soul. I think at this point Mr. Nixon stands diminished. I don't believe it has much to do with direct implication or who violated what laws. It has to do with the sheer weight of the spectacle that we've seen. All of these people that have paraded across the screen that we've seen, the perjury, the burglary, the attempts to subvert the system as we have known it. I don't believe Mr. Nixon can separate himself from that. So I believe that he's a crippled man, and he will have to finish out his term, indeed, if he's allowed to, with that prospect. There are other factors, too, that must be weighed. I think outside events may have some effect on the impact of these weeks on people. I mean, namely the economy. We have seen recently the polls show that businessmen, particularly in Wall Street, where the stock market is affected and the value of the dollar is affected and all of these things, great concern because it's hit right home very hard. The price of meat, pork chops, hamburger, whatever it is. I think that all of this is going to kind of come together in kind of a last of summer analysis by the American people. And as I say, unless there is some hidden evidence we don't see or some grand plan that Mr. Nixon has, I would expect him to be quite diminished in his role as president.
What do you think, you mentioned his coming rebuttal. What could he do in that rebuttal, do you think, at this point, to overcome, as you say, the diminishment of him and the presidency at this point?
Well, I don't see much that he could do. Perhaps there's a surprise. We have, of course, lived in these last months with the suggestion from some that Mr. Nixon was a great clutch man, that he came up with a surprising maneuver. But on each time that we've expected this, he's come up with one of the old-style things out of the old grab bag. That is, the invocation of national security, that sort of thing. So I have real doubts. Will he come in and dump the tapes on the table and say, all right, play them, and they'll show that he's exonerated? Will he produce the records, and they will show that the other people were lying, that his people and he were right? I can't predict on that, but I have my doubts on it. And I have real doubts whether at this point in time, with so much evidence here of wrongdoing within his administration, which he can't separate himself from, really, I doubt that he can overcome this to some degree. We'll always leave the door open a little. There's always that chance for a miracle. I think, like Sam Ervin, most of us pray that there is some miracle, that he does exonerate himself and we can get on with the business of this country. We can right it again, but I seriously have doubts.
Gentlemen, thank you very much. Well, beyond these cosmic and imponderable questions of guilt and innocence, which we aren't competent to fathom at the moment, what impressions are left of these 37 days of hearings? For one, Peter Kay has been in or near the hearing room all this time, while Jim Lehrer and I have been down here in the studio. What are your feelings after this marathon, Peter?
Rob and I sat at a press table and straddled a post and sat under the hot lights for 37 days. Ran up and down the hall chasing Sam Ervin and Sam Dash and occasionally Sam Donaldson of ABC. Tried to run out in the front of our unilateral camera and do something relevant, if not wise. And to tell you the truth, along with the 200 other reporters, from Norman Mailer to Mary McCarthy to Mary McGrory, I loved it. Beneath our cynical comments and everything, it was one hell of a story, and we enjoyed doing it. But, you know, somehow in the course of all these hearings, they kind of took on a life of their own. They were more than just a big news story. And then beyond the original big players, the Ervins and the Bakers and the Sam Dashes, other people would emerge, as I'm sure the television audience made their own judgments. The impetuous Lowell Weicker, the embarrassingly honest Dan Inouye. But in so doing, I wonder if these hearings didn't, in a way, blow everything out of proportion. For instance, the caucus room itself became the world's biggest, perhaps, or most used, certainly, television studio. Everybody used it, not only us for our day and night hearings and the networks for their version, but the Dick Cavett Show, the Today Show, the CBS Morning News, and of course the nightly news. They all used it. And the hearings themselves were, I think, blown up maybe too much out of proportion. You look at the nightly news, for instance, night after night after night, 15, 17 minutes of each half-hour program were devoted to Watergate. Surely all of the news in the world put together must have been at least as important or more so than Watergate. It just doesn't make sense. And I think finally the committee realized it. I think the idea that the second and third phases may be before subcommittees, out of the big bright lights of television, and maybe the committee members got their mail and figured that too far, enough.
I'm not sure I agree with you about blowing it out of proportion. You know, it's commonplace to point out even now that in a couple of years the country is coming up to the 200th anniversary, which must be, whether you're an American or not, must be one of the most important dates in the history of the development of human social organization and the evolution of democracy. And personally, I dreaded what we were going to see in 1976. I thought we were going to be in for an orgy of pious self-congratulation by politicians of all parties and at all levels who didn't have a great deal to congratulate themselves for, really, in terms of having carried the Constitution forward through their brief span. And I think now we're going to have an entirely different note when that anniversary comes up because of the fantastic educative process of these hearings. And that's where I see their importance. It's forced the nation, even those who only watched a little bit, or even read about them in the newspapers, it's forced them to consider the kind of fundamental things on which this country's based: the rule of law, the constitutional protections for the individual, the limitations of executive power, the separation of powers, the freedom of the press, the proper functioning of the institutions of the country, and all that stemming from excesses in something that the Constitution never envisioned at all, or never mentions, and that is political life. And I think that's a terrifically healthy thing, even and very good to one of the points that was considered in the hearings, and that is the cynicism of young people about the processes by which this country runs. And even if even if everybody picks up only a little bit, I'm very hopeful that it is a healthy thing to refocus on the essentials of what made the country unique in the first place.
You know, I don't know how healthy it is, Robin, but I would carry it another step in terms of the educative process, and I'm sure this may be limited to those who watched it gavel to gavel, but what it did in exposing human values. I mean, from Bob Odle, the first witness, up to, through, and including Henry Petersen, the last one, all these people were human beings, and there were little guys and there were big guys, some of the most powerful people in government. And they were all had to come to grips with questions of loyalty. They had to come to grips with questions of what's right and what's wrong. When do I blow the whistle? When this man agreed to lie, this man agreed not to lie. This man gave in to pressure, this man didn't. And the whole question that kept going through my mind is here we were talking or listening to people who were involved in government and involved in political campaigning, but the kinds of questions that a lot of these people had to come to grips with are the kinds of questions all of us have to come to grips with, whether we work for a public television outfit or whether we work for a grocery store or wherever we work with, and the testing that these people had to go through. Some passed, some failed, some were called safe at home, but we'll see.
Yeah, it's a kind of extended morality play in a way, in which the values that have always been revered in the country, but which it is corny nowadays to maunder on about, could be uttered quite in a proper context by people like Sam Ervin, who could say things like, I love my country and this is why I love it, because it's based on these ideas.
And Richard Kleindienst could say the same thing today, and Henry Petersen could, and many of the other people could, but they were asked about these things, and it was all there for all of us to not only see how they reacted, but wonder, and secretly to ourselves, well, I wonder what I'd have done, if I'd been confronted with that.
Okay, fine. I appreciate your idealism, and it's nice to see it in gentlemen of your age and experience. But I still get back to the pragmatic question. Let me just lay it out honestly. Maybe I'm the house cynic. I don't know. How do you know when a liar is telling the truth? Really? Now, you said a whole... All right.
You have the same visceral feeling that Henry Petersen said today he had.
And we all had them, each in our own way, to each and every witness. That visceral feeling. And that's good for us.
It's good for you, but it doesn't do much good when you've got to write a report or pass legislation, or at some point in time, if I may use an old phrase, return an indictment or sit as a juror in a trial. It seems to me that in this age of Marshall McLuhan and the media being the message and all, and with all the great contribution of television, we're still back to the only time that when the hearings really have come to life in the last month or so is when we have something very concrete. Say, for instance, a document. When Bob Haldeman sat there and fielded those questions and looked like Casper Milquetoast instead of Bob Haldeman, the only time his eyes glazed over, the only time he looked like the Bob Haldeman I've known for 15 years is when somebody hit him with a document and said, Mr. Haldeman, this is what you wrote. No wonder the committee wanted those documents. No wonder they want those tapes. Because when you've got something hard and fast to decide who's saying what, then you have maybe the swing and the preponderance of evidence.
Sure. Well, that's the Perry Mason aspects of this thing, and that's what made it a good show on one level. It was the search for the truth. It was trying to find out whether the highest person in this country is guilty or not. And that was drama and, if you like, a very extended trial atmosphere, if you like. The point I wanted to make is that these other things were important, too. The other side effects of the hearings were important.
That's my point. I'm not saying that the hearings are justified just so it gives us all a little insight into what lousy or good human beings we are. No, I'm saying this also is a side effect. But you mentioned the Perry Mason thing, as you said a couple of times during the course of all of this, that the one dramatic element that hasn't been here, because we're all geared to watching great trials on television, is that nobody stood up in the back of the row. They stood up today to raise Cain, but you kept waiting the guy to stand up and say, I did it. And that's the frustration. Nobody's done that, and...
Well, thank you. Before all you Watergate addicts resume your normal lives, we'd like to thank you for your encouragement through these 37 days of hearings. During the first through a few weeks of the hearings, you wrote us more than 70,000 letters supporting this kind of prime-time gavel-to-gavel coverage. It's been carried, you might be interested to know, by more than 90% of the 237 public television stations across the country. And many of those stations, perhaps yours, has enjoyed increased financial contributions and new memberships due to interest in this coverage. Public television's coverage of the Senate hearings will continue when the hearings resume in September. We hope you'll be watching us then.
And before you sign off, Robin, I would like to point out that this is Robert McNeil's last night after 2 years on public television. On behalf of all of us in public television, and I'm sure on behalf of your audience here, I would like to wish him well. He is going to England and joining the BBC. And we wish you well and good luck, Robin.
Thank you very much. I wish you well when it all comes back in September. So, for my colleagues Peter Kay and Jim Lehrer and all of you behind the scenes, whose names you will see in a moment, good night for NPACT.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.